spell your name for the record?
Lindsay Fish, Lynseyfish.
And how are you currently employed?
I'm a detective with Metro National Police Department
And how long have you been employed there?
since 2020.
And did you ever have an occasion to make the scene in an incident involving Ms. Jade Benning at Vanderbilt Medical Center?
I did.
And that would have been around February 25th of 2023?
Correct.
And in what capacity did you show up on the scene?
I was a patrol officer.
Were you wearing a body worn camera?
I was.
Was it activated?
It was.
The court officer is handing you a photo, and I want you to take a look at it. Do you recognize it?
Yes.
Does it purport to be a still image of your body worn camera from that night?
It is.
And is it a fair and accurate depiction of your body worn camera that you were wearing that night?
Yes.
Has it been altered in any way?
It doesn't appear to be.
Y'all, at this time, I would ask that this be entered into evidence as a defense exhibit 3, I believe, or
We're just putting it in
55. I'm sorry. Permission to publish on?
Okay.
Can you describe what you see in this scene here?
This is the entrance to the ER of Vanderbilt Hospital.
And so this is can you circle this right here? That pole, can you circle it on the screen, please? What is that?
It's a form of metal detector.
And if a guest were to come into the emergency room, would they have to go past that metal detector?
They do.
You see this person with that mask on right here?
Yes.
Can you circle that individual, please? Do you know what that individual is doing?
He is the security officer for Vanderbilt and was checking people in as they go.
And that's what he was doing that night?
Yes.
And to the best of your recollection, was this individual alone, or was there another security guard also present there?
There was other security there.
And to the best of your recollection, were they doing their job?
To the best of my recollection, yes.
Did you ever have an opportunity to speak with a Miss Brown that night?
Yes.
One second, I want to go right back to exhibit number 55. Can you tell me what, if anything, that security guard is wearing on the face?
The mask?
Uh-huh. Is that a mask that they're wearing in this photo?
Yeah.
What about the individual that appears to be checking in? Is that individual also wearing a mask?
Yes.
And so was that a standard protocol and procedure that night that people entering into the hospital with no had to wear masks?
Yes.
Now, I just want to try to orientate the jury to, when you say you were one of the first officers on the scene that day,
Correct.
would that mean that you would have come before any detectives would have arrived?
Yes.
Did you have the opportunity to speak with a Miss Andrea Brown?
I did.
And do you know who that is?
It was Miss Benning's stepmom.
And do you
Roll
recall?
up closer to the mic.
And do you recall recall while speaking to her that Ms. Burks got on the phone?
I don't know who Ms. Burke is.
Ms. Burks would be the mother of Mrs. Benning.
But yes,
She did in fact get on the phone.
yes,
And you were present for that.
I was.
And what, if anything, did you instruct them while you were in the presence of Mrs. Browning with Mrs. Burks on the phone?
I just informed them of what was going on and asked them if they had any questions.
And did they inquire about whether or not there was an investigation going on?
They did.
And what did you tell them?
I told them that there was an investigation going on.
Did you inform them that detectives will be coming out?
Yeah, I did.
Did you tell them that the house, the apartment should be frozen?
I did.
Did you tell them that in being frozen, no one in, no one out?
I did.
And you came before Detective Smith, correct?
Correct.
And again, when you gave those instructions, Ms. Browning was present
Yes.
and Ms. Burks was on the phone?
Yes.
No further questions.
Question from Mr. Taylor.
Good morning, Officer Fish.
Good morning.
You were just asked if you recall telling them that the scene should be frozen, is that correct?
I did.
Okay. And if your body cam reflects you speaking to Ms. Browning around 12:37 a.m., is that accurate?
I don't know the exact time. But when
But it was prior to Sergeant Smith.
yes,
And to your knowledge, Metro National Police Department was going to go out, conduct a search warrant, and freeze the scene.
I knew that that was a possibility.
And if Sergeant Smith's search warrant later got denied, and there's a possibility he told them they could go back to the apartment, would that make sense?
I wouldn't know that information.
Okay, would it make sense if there was no search warrant and no one was freezing the scene, Metro wasn't there?
Objection, calls for speculation. The witness says she doesn't know that information.
Okay, rephrase your question.
Officer Fish, if Metro Nashville Police Department has no legal basis for holding a scene, freezing a scene, if they're not conducting a search warrant, would there be any reason to tell the family that they could not go back in the apartment?
No.
Okay, those were my questions, thank you.
Officer Fish, do you recall ever stating that you all had information that a possible crime had occurred?
I do.
And that's the information that you gave Ms. Brown, correct?
Yes. That the investigation was why the investigation was happening.
Fair enough. No further questions.
Any other questions?
No, sir.
Thank you. You can step down and get excused.
Thank you.
Who's the next witness?
Should have been called Leah Gutierrez. We'll move to Dr. Peters. What's the last name? Sheila Peters. Oh, there she is.
May we approach before?
Okay.
please state your name for the record, please?
My name is Nia Gutierrez.
And Ms. Gutierrez, how are you employed?
I am a Tennessee licensed private investigator and a Texas licensed private investigator.
And how long have you been a licensed investigator?
In Texas for about a total of 7 years, and in Tennessee, I'm coming up on 1 year.
And did you recently move to Tennessee?
Yes, last year.
Okay. And what company do you work for in terms of for investigations?
Out of Texas, I work for Willis and Associates, and out of Tennessee, it is Covert Results.
And how long has Covert Results been in business?
Since 2017 or 2018, I believe.
Did you have an opportunity to go out to the Ontario apartment where Ms. Benning lived?
Yes.
And when you went out to the apartment, did you have an occasion to view the apartment where Ms. Benning lived?
Yes, I did, on the exterior with the door closed.
Also, did you have an opportunity to view the marquee for the apartment?
Yes, I did.
I want to draw your attention. Do you have with you photographs?
I have something else not to put photographs with me.
Should I have photographs?
Yeah. I believe you should have that photograph in your packet there.
Yes,
Okay. Do you recognize that?
yes.
Okay. Can you find that in your packet and can I get my copy back?
I'm sorry, this picture is not in my packet.
Okay, that's fine. Do you recognize that photo that you
Yes.
took?
Yes,
And what is that a photo of?
it is a picture of the marquee of the incident location demonstrating the physical address of the apartment complex.
Okay, now I have it back, please, so that I can publish to the jury. Is it in the same fashion in the way that you photographed?
Yes,
And are you the one who actually photographed this?
yes, correct.
Your Honor, at this time, I'd like to publish. Is that in fact the marquee for the Ontario apartments or condominiums?
Yes,
Have you had the opportunity to view any photographs from 2023 or February in regards to the Ontario apartment complex?
yes,
And is that marquee in the same fashion that it was in 2023?
yes.
Could you please read for us the address here at the bottom of the sign?
It is 1522 through 1550 Lebanon Pike.
Thank you. Did you have an opportunity to go out and look to see apartment 107 where Ms. Benning was living at the time?
Yes,
And were you able to ascertain whether or not Ms. Benning's apartment had windows?
yes.
Where were her windows situated?
On the rear of the apartment.
If I may, Your Honor. Was there anything behind that apartment where the windows were located?
There is a trailer type business, it's a trailer service repair business at the rear of the apartment complex. It's rather large, and from my understanding, it's called TSR, and they repair trailers.
I want to first show you this photograph here. Do you recognize that?
Yes.
And what is that?
It is an angle from the rear of the apartment.
And are you the person who actually took this photo?
Yes,
And could you, for the jury, well, let me ask that it be admitted first, Your Honor.
Okay.
Could you, for the jury, please point out which window belonged to Ms. Benning's apartment?
It would have been, I'm not sure,
Mark,
I can mark on here, sorry. It would have been this one.
okay. And I want to now show you another photo. You can clear the screen.
Oh, sorry.
Okay,
Got it.
there you go. I want to now show you this photograph. What is this?
This is a picture of the rear end driveway, you could say, of the apartment complex, coming in after you would come into the apartment complex and then turn to the left. It is a picture of the driveway alley behind the apartment.
And would Ms. Benning's apartment window be adjacent to that, I guess, would it be a pasture or field?
It would be, you could say parallel, yes.
Okay, parallel, thank you. And if you could just orient the jury where Ms. Benning's apartment window would be located.
I can point?
Yes.
Okay. It would be this way.
And did you take this photograph?
Yes.
At this time, we would offer, let's see,
We'll just make it collective whenever you get all of them you've got.
if Ms. Benning was to have a camera in her window, where would that camera, if it was facing out, where would it focus on? Where would it be directed towards?
Depending on the range of scope of the camera, it would have captured the entire back alley drive here, or maybe just her back patio, or to where a vehicle could be stationed back there, or all the way up into the trees. It's unsure.
Were there any other windows besides those windows that you saw in apartment 107 at the Ontario?
That is the only one that I recall.
I want to draw your attention now to another photo, if you can clear the screen. What is this?
This is an angle closer to the end of the parking where the truck repair service business is located, just below on the hill.
Is that also behind Ms. Benning's apartment and the view that would be out of the only window in her apartment?
Yes.
And what about this photo?
That is another angle showing the trailer service repair business.
Now, did you have an opportunity at our request to do any research in regards to the son of Miss Stephanie Franklin?
Yes, I did.
Did you determine a name for the son of Miss Stephanie Franklin?
Yes, the name is Jordan Franklin.
And were you able to ascertain whether or not Mr. Jordan Franklin was in fact a police officer?
Your Honor, I'm going to check the relevance of this.
Your Honor, there's been testimony that a police officer gave Ms.
Right,
Franklin,
you asked all about it. A police officer told her to do X, Y, Z.
correct, and if I may,
Now-
I would like to,
So what do you want to ask?
did you ascertain whether or not Ms. Franklin's son was actually a police officer?
Yes, so to answer the
I
question,
suspect that would be based upon hearsay.
Care to be heard?
Yes, it's not hearsay, she did the record search herself, Your Honor.
Well, I know that, but wouldn't the information be an out-of-court statement offered for the truth?
I don't believe that if you are doing, nobody told her anything. She researched to see whether or not a T code existed
So
for.
you want to litigate whether the gentleman was or wasn't a police officer?
I think that's very important for the jury to know, Your Honor.
I object on the basis. Hearsay.
I believe it goes on the effect of the listener.
Correct on the list?
Absolutely.
Okay, it is hearsay, so I'll sustain the objection.
Also, it goes to 609 impeachment, which allows you to impeach with hearsay.
Based on reliable information.
Correct. And I believe that the information that Ms. Gutierrez received.
You have to have one that you're calling from a police department saying he wasn't a police officer.
Yes, sir.
You do?
We have researched and looked
No, I'm
at.
saying, do you have a person from that department?
Ms. Gutierrez called that
I'll
department
sustain the
directly.
objection.
And, Your Honor, if I may, through this witness, introduce this judgment.
I certainly object to that.
Okay. The
It is-
judgment about.
It's a certified copy in regards to
Okay.
Mr.
Have
Jones.
you looked at the certified copy?
I'm not sure which one
Yes,
is
sir.
using. We have the one,
Here you go. I gave it to you last week, but I'll give you one.
but may we approach?
Oh, okay. Okay, any other questions?
Not of this witness at this
Okay.
time.
Any questions from the state?
I would request James.
Any statements you have from this particular witness?
No, no.
Okay.
May I see the exhibit,
The photos?
the collective exhibit? Yes, sir.
Yeah,
I believe you said that you were employed by Covert Investigations. Did I get the name right?
Yes, and Willis and Associates.
Oh, okay, okay. And is that based in Texas with an office here, or is it totally Texas?
The Willis and Associates firm is based out of Houston, Texas, and Covert is here out of Nashville, Tennessee.
Okay, and so when were you retained? When were your Covert?
Are you asking if I've been retained through which firm?
Yes.
Or, okay. Okay, well, I've been retained under Willis and Associates since before my move to Tennessee on this case.
I was just trying to get the time lined down. And with respect to this particular case, when were you retained?
Covert Results was retained at some point on the case after Willis and Associates, but is my understanding, to my knowledge,
When were you retained on this case?
When did you start billing?
I'm billing under Willis.
When did you start?
Oh, early 2024.
And what is early 2024?
I would say probably March.
Do you have records of that?
Yes, according to timesheets that I turn in, correct.
Do you have those with you?
I do not, but I can get them if needed.
Did you have any other involvement as an investigator with this case prior to, when you say early 2024?
No.
Were you familiar with this apartment complex prior to being
No,
retained?
I was not.
complex on Lebanon Pike here in Nashville, Davidson County, Tennessee.
Mm-hmm.
Correct?
Yes.
And this sign is at the entrance, correct?
At the entrance, correct, main entrance.
And Miss Benning's apartment that you were directed to
Mm-hmm.
is essentially in the far back corner, correct?
I would say the center far back corner building.
Well, let me, council, seen this, okay. Let me put this, view. Actually, it might show better, but you have the ability to touch this.
Mm-hmm.
Where is the sign that we just saw?
It would be right about here.
Okay? And Ms. Benning's apartment would be in that general area, correct?
No, that would be the entrance of the breezeway to her apartment, but not on that corner.
Okay, well, would you circle in what
It would-
part of that corner it is?
Probably right here towards the center, somewhere in that section.
All right. Yep, another one that's a little bit further out. And this is a larger view of the businesses in the area, correct?
Yes.
And the truck repair place is in the top of the picture, is that correct?
Yes.
And now on this picture, could you circle what you say is Miss Benning's apartment?
You want me to circle it on here?
Yes, please. And again, circle the entrance.
Where the marquee would have been?
Yes. Thank you. All right, tender these photographs as the next 42, 58, 57.
There are two,
There are two, yes.
okay, just make it collective 57.
And this is part of exhibit 6 that we've previously seen. Would you circle again the, what you say is the window to Ms. Benning's apartment? No. The next window over, is this also not a part of her apartment, or do you know?
I don't recall. I have to look at a bigger angle. But it is possible.
And obviously, as we see in this picture, the blinds are closed all around, correct?
Yes.
You never went in this apartment, did you?
I did not.
And the photographs that you took, do you know when those were taken, the date and time?
Can I look at my notes, Your Honor?
Sure.
On June 21st, June 24th, and June 26th, just this recent, I visited the property.
Okay. This month,
Correct.
had you visited the apartment complex prior to that?
I had not.
Those are my questions. I'll
Okay.
submit these facts.
Any other questions?
No, Your Honor.
All right, thank you. Next.
At this time, Your Honor, we would submit the judgment.
Okay.
The judgment theft on September the 1st of 2022.
Okay. Or mark that as 58. Who's the next one?
The defense will call Dr. Sheila Peters, Your Honor.
Okay.
Yeah, it is what may we approach.
Okay.
Morning.
Can you please state and spell your name for the record?
Sheila Peters, Sheila Peters.
And how are you currently employed?
I am an associate professor at Fish University, and I also operate a private practice,
A private practice in what?
clinical psychology.
Did you have to go through or undergo any schooling for that?
Yes.
What
We
school?
are objective. They're not calling her as an expert.
This is background information, Your Honor, if I may.
Okay, go ahead.
Did you have to undergo any schooling for that?
Yes.
What kind?
Undergraduate degree as well as a master's and a doctorate.
From where?
Undergraduate degrees from the University of North Carolina, Chapel Hill, my master's and my PhD from Vanderbilt University.
Dr. Peters, have you ever been employed with the Tennessee Titans?
Yes.
In what capacity?
As the team clinician,
And in that role, what were you expected to do?
in that role, I was expected to provide support and assessment for players, coaches, and the entire organization.
And when you say support, what, if any, difference is there between support and clinical work?
My role was to help anyone that was experiencing any kind of distress and determine what their best treatment would be.
Did you ever come to know Mr. Blaise Taylor?
Yes.
How?
During the playing season, on average, I would attend one practice a week, and I would see him as I would see other individuals coming out to practice.
And in those general interactions, what was, if any, your impression of him?
Your Honor, I object to that.
Impression.
We're not having.
They were co-workers, Your Honor. I'm just
Okay,
asking her what was their impression, her impression of Mr. Taylor.
With a time frame.
All right, I'll sustain the objection.
When, did you ever interact with Mr. Taylor in 2022?
Just cordial hello.
And did you ever interact with him in 2023?
Yes.
And what was your interaction with him?
I was asked by the GM.
Your Honor, objection,
Okay,
hearsay, and this is in a professional capacity.
If I may, Your Honor.
what is your question?
My question is, did you interact with him at all in
Your answer is
2023?
yes or no?
Yes.
Okay, she did.
Thank you. And what time frame did you interact with him?
It was in March.
Was it once or more than once?
It's twice.
Do you recall any dates?
Yes.
What dates would that be?
March the 3rd and March the 8th.
And when you interacted with him, what is any impression that you have of him?
And again, Your Honor, I object.
Okay, To
Your
get
Honor, if I
an
may.
impression, she'd have to be declared an expert in what?
I'm not, I'll rephrase my question.
Okay.
What, if anything, did you think of his demeanor when you interacted with him?
Your Honor, I object to what she thought about it, because that would be a
Okay,
clinical
she
assessment.
could describe his demeanor. What was that?
He was concerned about the situation.
That would get into hearsay.
Yes, sir.
So,
She just described his demeanor as concern, Your Honor.
okay, concern. All right, then what's your next question?
And the second time you interacted with him, when would that have been?
She said that already.
Well,
March
did-
8th.
March 8th.
Yes, sir.
And what was his demeanor like when you interacted with him on March 8th?
On March 8th, he was troubled because Ms. Benning,
See, you can't get into things he said, and you relied on those to come to that opinion.
Your Honor, I thought she testified that he was troubled, not that he said anything.
If she was about to say that, because of something.
Do you know why he was troubled?
And Your Honor, objection.
That would be based on hearsay from your client. She says he was troubled, so what's your next question?
And were you there to support him?
yes,
And how did you do that?
Your Honor, I object to the relevance of her support.
Your Honor,
Did you counsel him? That's a yes or no.
yes,
Okay, what's your next question?
and as a result of your interaction with him on March 8th, what, if anything, that resulted from that interaction?
Your Honor, I object to that.
Let the lawyer step up.
Dr. Peters, do you know if Mr. Taylor remained with the Titans after March 8th?
I don't know.
Do you know where did he go, if anywhere?
Sometime thereafter, he went home.
Do you believe that was a good decision?
Well, Your Honor, whether she believes it's.
Okay, I'll sustain the objection.
When you encountered Mr. Taylor on March 8th, was there anything out of the ordinary with him?
It's been asked and answered.
Okay. How would she know anything's out of the ordinary unless it comes from hearsay?
Well, based off of the impression that she would have gotten in observing him and interacting with him, what his demeanor may have been,
She's described that as trouble.
she did, but not in relation to not in relation to what would actually happen when he left. So I think it's a little nuanced there, Your Honor.
Okay, well, I'll sustain the objection.
During your time at the Titans, did you ever have any personal problem with Mr. Taylor?
No.
No further questions, Your Honor.
Any questions from the state?
No, Your Honor.
Thank you, ma'am. You can step down. Who's next?
At this time, Your Honor, the defense will call Dr. Melissa Jerry.
Jerry.
Your Honor, at this time, pursuant to previous discussions, state request can carry out. Because we have no report.
All right, ladies and gentlemen, the jury, if you'll step down and call Agent 3.
to the defense in regards to the blood and urine of Ms. Benning and the testing of that blood and urine that went to the cause of death in this particular
And
case.
you're wanting her declared an expert in what field?
And laboratory testing of toxicology.
Is she a toxicologist?
She is.
Okay. And the state's objection is what?
If we have no report, we have her CV, but no report to know what the parameters of her.
Do you have a report from her?
She didn't give a report. She looked at the evidence.
Notes? Do you have any
Do you have any
report?
notes?
No, I'm asking you, do you have any information from her that would be considered a statement?
I don't, Your Honor. I asked
I'm
her.
not talking about you, I'm talking about your firm, your counsel.
No, I am the firm counsel. We don't have anything. I've met with her on several occasions. I have my work product, but I don't have any notes from her.
So she's never emailed you or anything like that?
Of course. But it
It would
wasn't a
be-
report.
Her notes?
I don't have notes from her. She may have emailed me in regards to what time is the Zoom call or are we
She
meeting?
doesn't have a report.
No.
So what do you want me to do?
We would hear her testimony out of the presence of the jury for the court to determine whether it will materially assist the jury and basically a McDaniel hearing.
So you're thinking this particular witness isn't qualified as a toxicologist?
No, it's the substance of what she testified about that we have no knowledge. She just now says about NMS. Well, if we'd had a report, we might know whether to have had
Some people don't do reports for
Unless-
tactical reasons.
Yes. And from here, since the witness has a notebook with her, that there may be some, there's nothing else, jigs material.
What's all that?
Your Honor, it is my brief notes to prepare for testimony today and the NMS reports that were provided.
Okay. Do they have a right to look at that?
Sure.
How long do you need to do that? See, this just, the jury's back there thinking, I won't say what they're thinking.
Prior to the last trial, when we had this come up, certainly recall that the court said witnesses would be excluded if they did not prepare a report. And here we are now without a report.
I don't know if I said that.
As well as counsel saying that they were only intending to call Eric Devlin.
Well, I don't know who that is. I mean, this person's listed on this witness list.
We have provided the state.
Lena Gill.
We have provided the state a full list of all of our experts and a brief summary of what they are to testify about. The rules and the statute does not require that every expert draft a report. Any notes that Dr. DeGarry may have, I don't have those notes, in which they are more than willing to look at whatever notes that she's made in order to assist herself in this testimony in the same manner. Dr. Bethune had to give me notes, but she almost 10 notes to me.
Okay. Run a copy of those. Do they have notes?
I can find out.
Do they have reports?
They do not have reports. All of our experts, Your Honor, reviewed all of the toxicology reports in this case. there were almost 13 toxicology reports in this case that needed to be interpreted. There were litigation packets that went along with those toxicology reports that were out of the purview of counsel's knowledge. We're not scientists, so we had to actually confer with experts in order to understand the science in this case.
Sure.
And so we hired experts to assist us to do that.
Did you have someone get from those other 3 doctors their notes that they would be using to testify?
I certainly can.
And get those to the state?
I certainly can.
All right, go ahead and do that. How long is the state meeting?
Judge, we were very much under the impression, based off of Your Honor's prior rulings in the hearings, that if they did not provide us reports, their experts would not be allowed to testify. We would have had Dr. Mithun stay so that she could be in the courtroom and listen to this, so that we could recall her as a witness. We are without our experts, which is exactly what we said when we asked Your Honor to exclude them if they
I don't
did
think I
not
can
provide a
exclude them
report.
when they don't provide a report. The rules talk about turning over a report discovery if there is one.
You know, the state didn't give us notes of all of their experts.
They got a
I don't know.
litigation packet, that is their note.
Said you had 1,300 pages.
We asked for that litigation packet and paid for it ourselves. The state did not provide it to us. We provided it to them.
Do you want time to get Dr. Carney or anyone else up here?
Judge, our toxicologist is in Pennsylvania.
We never said we
I
wanted.
didn't ask you to say anything. So what do you want me to do? Declare a mistrial? Delay it till next Monday?
Would Your Honor allow us to contact Dr. Mithun and see if she is available to watch it by video so we can at least confer with her after this witness testifies? If she was present today, she would be allowed in the courtroom.
Sure, she can go on, as I'm understanding it, live streaming and watch it.
May I step out to get in touch with her to see if
Sure.
she's available to do that?
All right, get those other notes. We'll be in a 15-minute recess. Whatever her name is. Yes, no, maybe. Is the state ready?
Yes, Judge, we were just, honestly, to expedite the process, we are no longer asking for the jury out. We have our toxicologist that's on the link, and we won't, if Your Honor is going to allow the witness, we won't object.
Okay. Well, do you want to be heard on your qualifications and all, and I can do that?
Not as attorney.
Okay. And then if Dr. Minton is to be recalled,
I haven't heard anything. I really know nothing.
Which means, you know, we would like notes and emails as well, please.
what are you talking about?
I said, if she is, so that we can get ahead of it, we would like notes and emails as well, please.
Notes, emails about what?
Her testimony and her notes that she made.
She would be, as you said, offered as rebuttal.
And I would like those.
Raise your right hand, we'll just bring the jury down then. Shut the door there. Did you give them earlier when we were in here all of your notes?
That I had with me, yes.
I have 4 pages that she handed us.
What is all of this?
I just got handed this.
We printed what you asked us to print, the notes.
For this witness?
Yes.
I thought she provided it.
You wanted emails, so I looked.
No, I didn't want emails.
You
I
asked,
asked her for notes.
she gave her notes.
What are these?
My email.
These are not,
I didn't ask for emails.
these are not emails. I just got a whole stack of notes.
What is all this stuff?
That was you had asked earlier if I had sent her work product of what I was doing as I was reviewing the data, and that's what that is. That's what I sent to her a long time ago prior to preparing for testimony. This was my analysis of going through the data.
So she did give you notes.
Sounds like a
Let me see what you have, I don't know what you have.
That's not,
That's what you emailed them, and somebody printed these out for me.
it's not a report. There's not an opinion in it.
Under the state remains our
This is
objection to
this
this
is-
witness.
This is the exact same thing that is a snip of the litigation. It's all it is.
Okay? Can you determine whether most of that is from your witness's litigation packet?
There's only, I think, the last 3 pages of this. This is
And
all
then what's the other
notes.
stuff?
May I explain to her what she's looking at?
I'm asking counsel.
Okay.
If you look, all of this are snippets of the litigation case.
Is all of this snippets from the litigation packet?
All of it is derived from the litigation
And
package.
then
What do you
there are
mean
notes
derived from?
on
It's-
top of it.
It's not, it's notes on top of it of what I was
From
seeing.
who?
From me, as I was
Why didn't you
looking.
give us that earlier?
I didn't have it, sir. I don't have
See,
it.
this is what hide the balls off. You know, I got a jury back here, I guess I'll direct myself to you, that's thinking I'm an idiot because of this trial. The procedure, the logistics, and they're back there wondering what in the heck we're doing. That's why, you know, the intent of Rule 16 is not hide things.
I'm getting the notes in the same number that they gave
Why
to
didn't they
me
give
with
them?
Dr.
I'm not worried about how
McCoy's
they
saying.
gave them to you. I'm dealing with how you gave them to them.
Well,
Do you think, Mr. Brand, Rule 16 doesn't include providing these notes pre-trial?
no, he did, and so.
No, he didn't. Y'all didn't. I'm asking him, do you think Rule 16 would include, when it says copy photographs, documents, reports, and provide the other side, if you've requested discovery? Did that include this stuff?
No, Your Honor,
How so?
because I think that's probably James material, under 26.2.
But they're reports from what you're proposing to be an expert.
I don't think that's a report, I think it's her working notes as she's reviewing the material, which could be James material, but is not a Rule 16 report.
See, that's the problem with efficiency, which I hate, inefficiency.
I appreciate it.
So, do you need additional time now?
Yes, I would like for my expert to be able to have this. I just got handed it as she was
Can you
literally.
email that to your expert?
Completely disorganized. Judge, I submit that what she has provided is a report that she provided to the defense, and she just said it was a while ago, and the defense did not provide it. We filed a motion to exclude and asked Your Honor to exclude any witnesses that had not provided us with a report pre-trial.
Okay. They're saying that's not a report.
I mean, do we need to have a jury out to determine if it is? If it is a report, is Your Honor gonna exclude it?
Sure.
Well, then I would ask the witness, there be a proffer to the court, for the court to make a
Inspect
determination. if
and
these
copy
are
or
real.
photograph books, papers, documents, photographs, tangible objects, or copies or portions thereof, if the item is in the defendant's custody and intended to be introduced as evidence in their case in chief.
This is not being introduced in our case in chief.
That makes no sense.
Well, it's not being introduced for our case in chief.
So you want to orally ask her all about it and then just, I'm not moving to
The same
introduce
manner
it.
that General Norman did.
I'm not dealing with that. I'm dealing with, have you complied with Rule 16?
Yes, I have.
So you're not gonna ask this witness to introduce anything?
No, I'm not.
So what do you want, General Norman?
Well, honestly, I guess my paperwork to go copy it and send it to our expert.
I thought you got an email with that in it.
I haven't even had a chance to look at it, but what the little I looked at, it looks like she typed up a report.
It's not a report.
Where is that? Where's the copy I gave you?
Here it is.
What page in that are you thinking is a report?
There's one that has like 7 or 8 pages and then a couple of pages of litigation packet in the back.
Well, I'm not worried about the litigation package.
I'm not either, it's everything that precedes it.
It looked like, I don't know, what, page 47, 48, what are all these notations from the litigation packet?
Yes.
Page 50, 51, so that's just a summary of what she's looking at. 69, 75, 81. How, Ms. Holmes, is this not a report telling you what she's finding in the medical records?
She is regurgitating what is in medical records. It is not an opinion. She's not a doctor. So where she can't give an opinion on a medical
Well,
record.
it's saying here,
And neither are we planning on introducing it.
page 75, instrument had an error, incorrect vial, not on our case. What's she reporting to you?
What's in the litigation package? That is not her opinion. That is directly taken from the litigation package.
Okay, what do you want to do, General Norman?
Judge,
Witness testify.
I think the witness should be excluded.
Okay, other than that, what do you want to do?
I would ask the court to give us 5 minutes so I can at least have the paperwork in front of me before she starts
Did
testifying.
you get this document through an email?
I don't know. She handed me documents, she emailed me documents. I'm
It
asking
was
that
an
all,
email to the court?
I asked
Were you
all
not
of it to
in
be
on it?
printed. I'm saying I don't think they're the same things. What she handed us and what she emailed us, they are printing it right now.
The emails that I sent over are nothing but logistics. I sent them over because they're emails.
Sent them to who?
To Joe.
No, I'm not talking about emails in the past. I'm talking about, did you email this packet to the state?
I don't know.
Yes, Your Honor, I believe that the packet that you're holding is included in email to the state that has
Did you get this
several
by email?
Word documents.
I received an email with 7 attachments that say summary of lit package, which sounds like a report. If she is not introducing anything, then our
Do you
request.
want to forward this to your
Yes,
Dr. Mitchell? Can you do that?
I have forwarded the email. I'm asking that the printed documents, which don't appear to be exactly the same, be scanned in so we can
send that, and that's happening right now.
How did I get this if it's not included in an email?
I'm saying she handed us documents, and the emails look like there's additional things.
Who handed you documents?
They did, right when she was walking out
Was
to the
this
stand.
packet sent to the state as an email?
Yes.
Yes.
Do you have that?
Yes, Judge, I received it a few
Okay,
minutes
can
ago.
you forward that to your expert?
I did.
Okay. All right, so do you need additional time?
I would like to have a copy, but I guess.
Oh, okay, give that to the state. So do you want additional time?
No, you're right.
All right, let the jury step down.
Judge, just before they get out here, the state is going to object to her testifying to anything related to any report that was not introduced as evidence in the state's case in chief. She cannot introduce NMS reports that have not been introduced.
Okay.
And so,
These two binders?
no, those are the medical records.
Okay.
So NMS did more testing than what was introduced in our case in chief, and I'm objecting to her testifying to any reports that were not testified to by Dr. Mitten and entered as evidence because it's irrelevant to this proceeding to talk about other tests that were not presented to the jury.
Okay. Do you agree with that, Ms. Holland?
I do, because we're only
Okay.
talking about the two.
Good, then we don't have a problem. All right, thank you for your patience, ladies and gentlemen of the jury. Now, if you'll step up, raise your right hand and be sworn.
You swear the testimony you're about to give to be the truth, so help you God.
Yes.
All right. Okay.
Good afternoon, Dr. Picard, how are you?
Good, how are you?
I'm good, thank you. Could you please state and spell your name for the record, please?
Dr. Melissa Jiguer, Melissa Giguere.
And how are you employed?
I am currently an independent contractor for forensics toxicology and science.
And where are you in terms of company that you work for? Who do you work for?
I currently work for a company that I own. It's MG Forensic Consulting.
And how long have you been a toxicologist?
I started doing toxicology in 2014.
And where did you go to school?
I received my Bachelor of Science at the University of North Texas, and I also received an Industrial Master's from the University of North Texas in Chemistry. An industrial master's is different than a regular master's because I did not have to do a thesis. I had to be working in the field and had to write my paper in regards to what I was finding and doing the lab work in the field. And then in 2023, I graduated from Oklahoma State University with a Doctor of Forensic Sciences with an emphasis in toxicology. It is not a PhD, it's a professional doctorate. The difference between a PhD and my doctorate is I didn't have to write a dissertation. I had to be employed in the laboratory, and all of my papers were based on data that I produced while working in a laboratory.
And how many, I would say, how long would you say that you worked directly in a toxicology laboratory?
Just over 10 years.
And have you been peer reviewed with your work? And have you also peer reviewed others and their work?
Are you referring to peer reviewed and just releasing my data and someone reviewing my work prior for release?
Yes.
Yes, I've done both ways.
At this time, we would tender Dr. Jagari as an expert in laboratory toxicology.
Any questions on that request from the state? Party, Blaise or the jury would still have to give an expert opinion in her field. Like I told you before, you could place such weight on it as you choose.
And do you have a curriculum vitae in regards to your training, experience, and education?
Yes, I do.
At this time, Your Honor, I would tender Dr. Jagari's CV.
All right. You want her to see it?
No, I just tender.
Okay, just give it to the clerk. 15 minutes.
Dr. Jagari, have you had the opportunity to work in labs that are accredited by the ANAB?
Yes, I have. I did my full 10 years working with an ISO ANAB accredited laboratory.
And what exactly is ANAB?
So ISO 17025 is it's an international standard that people who do qualitative, quantitative results have to follow this standard. It is, if you look up pharmaceutical companies, petroleum companies, they follow it as well. So then you have ANAB, which is a subsidiary more for forensics that you have to follow. And so it gives a little more guidelines to be more for science versus petroleum or some other company that could have ISO. But then it goes a little further, it goes into ASB, which is an American Standards Board, and they produce guidelines and standards specifically for forensic toxicology. So you have a blanket overview and then you kind of narrow down into a funnel from there.
And can you tell us some of the things that are required in order to be accredited, such as chain of custody, such as keeping things stored at proper temperatures and things of that nature?
Sure, so the accreditation is very, the ANAB standard itself is very bottom line. It's very minimum, and it says you have to maintain a chain of custody. You have to monitor your refrigerators, and it should be kept between this temperature to this temperature. But you get those more finite details in the American Standards Board standards, those ASB standards. ANAB is more of a general, it's you have to do this, but you should try and go better. It's the bottom line of what it is. And so you have to maintain chain of custody, you have to document all kinds of everything in a forensic laboratory. You have to, the bench notes that as you're working through a case and you take a bench note, you write down it's oily or it smelled funny or whatever, that has to be maintained with the case file as well. It also goes through guidelines about who's allowed to work on it based on credentials. It goes through who has access to certain areas. It restricts that. It doesn't restrict it, let me clarify that. It dictates how you should document who has access. It's more of a documentation aspect from ANAB versus the recipe on how to do things.
And why is that important?
Forensics is the way I look at it, has three pillars. You have integrity, you have chain of custody, and then you have unbiased opinions. And you have that as a three-pole. and a stool. If you lose one of those, then you kind of wobble and you kind of can lose the reliability of the forensic analysis that you have. And so those guidelines between ASB, ANAB, and ISO all help to make sure that that stool is good and stable and it can be reliable and accurate at the end of the day.
So I want to draw your attention to the NMS lab report number 231-26889. Are you familiar with that toxicology report?
Yes, ma'am.
Do you have a copy of that report with you?
Yes, ma'am.
How many reports were issued under that work order?
I just have the one that was originally provided to defense, that was dated 5/16 of 2023.
And have you recently been made aware that there was a new report issued on June the 10th of 2026 in regards to litigation packet 231-26889?
Yes, you informed me of that.
I want to talk to you about whether or not when you did your analysis, well, let me ask you this first. Did you do an analysis of this particular toxicology report?
I wouldn't call it analysis in the sense of science. That's doing actual chemical extractions. I did do a review of the data.
Okay.
Sorry.
Excuse me. I need to get with your terms. So tell me, what, if anything, did you learn after reviewing the data in regards to work order 231-26889?
So when I first reviewed it, what first caught my eye was, we can see at the bottom it says specimens received, so that's what I go to look at. Typically, if you're looking at anything for blood,
Sorry.
oh,
It's not working. Yeah. Just get it. Don't worry, I can use this. My computer doesn't like that. Can I switch? We're gonna end up having a problem with it, so don't worry about it.
My witness is not in the feed, it keeps hanging up and she's not able to view what's happening.
He said it's on the witness's end that he can hear.
It's not that she can't hear it, it hangs up, and it just flags and freezes up, so it's not just hearing, it's producing.
That is her internet and her buffering, not. It has
You
nothing
want to
do
go
with
out
her.
and call her and see where she might be or relocate?
cell phone.
Ladies and gentlemen of the jury, if you'll step back down the hallway. I don't know of any way to do a Zoom link and do officially what we're talking about doing in this trial. She's somewhere that she could relocate or get better internet service.
She said she tried it on Wi-Fi and also her cell phone. She was in the car driving and drove to the location so that she could do this. She said if she could just be on a phone line so she can hear what is said, that would be sufficient. Is that a possibility?
I don't know how well she'll be able to hear, but we call her from that phone up there. As long as she's not speaking.
She wouldn't be
You
speaking.
want to come punch in her number? Yeah, hit speaker.
Dr. Connolly, this is Carrie.
Dr. Nissen, this is Stephen Norman. Can you hear me?
I can, yes.
So I have you on the phone at the court.
Okay.
Can we ask the witness to say something to see if she can hear?
Can you hear me, doctor?
Yes, I can. It's a little, difficult, but, I can hear you.
Okay, can you turn the volume up on all the mics? All right, can you state, can you state your name, please, ma'am, for the record?
Melissa Jaguar.
You'll have to speak up into that mic.
Melissa Jaguar.
Can you hear that?
Yes, that's much better. Thank you.
All right, bring the jury back down.
Judge, Dr. Mendon couldn't hear the report number. Can we just let her know that we're talking about 2312688?
231
2688.
26889. Okay.
Gary, we were talking about litigation packet 231, I'm sorry, toxicology order, 231-26889 from NMS. Can you tell the jury what sample of specimen is this referring to?
You'll have to speak into the mic.
It's referring to the clear plastic top tube with 1.75 mils that was collected on 2/25/23 at 22:31 or 10:31 p.m. labeled hospital blood. And it also includes a clear top plastic tube, 8 grams, collected on 3/7/2023 at 13:34 or 1:34 of liver tissue.
Now, we see there on this report that number 1 is a clear plastic tube, which is self-explanatory. But could you tell the jury what is ID 003, homogeneous container?
So as you heard from Dr. Methune, that's where you take it and you blend it essentially and make it so you can, in analytical chemistry, you have a thing, it's called an Eppendorf pipette, and you have to draw up a specific certain amount for the test to be accurate and based on validation. And so you have to make it to where you're able to draw a liquid into this little tip to be able to start the extraction. So the laboratory took, I don't know how much, usually it's documented, but you take a portion of that, you weigh it on an analytical balance, and then you mix it, in my experience, we've mixed it with water, and we put it through a blender, better way to think of it, and you hit go and it blends up the tissue to make it to where it is more pipettable for the equipment.
And we see that on item 2 and 3, it notates liver tissue. Do you know whose liver that this report is referring to?
I do not, because the labeled as number is the same, so I would think that I interpreted this when I was first reviewing that the liver was from the same person with the hospital blood.
And whose hospital blood does that belong to?
Based on the review of the medical record, that it was tied to a Jade Benning.
Have you since learned who the liver tissue belongs to?
Yes, it was discussed that it was belonging to the fetus of Ms. Benning.
Have you, well, in preparation for litigation, is there something that NMS will provide to attorneys if the attorney requests that?
It's called the NMS litigation packet. You've heard about talking about litigation packets.
The answer would be either yes or no. Did you get that?
Yes.
And can you tell the jury exactly what a litigation packet is?
Sure. So a litigation packet is a copy of the report, followed by a copy of their receiving data, where they start their chain of custody. It also includes the summary of who would have touched the sample along the way. It also includes the, if there's a disposal, there's a communication log, anytime that there's a communication regarding to that particular case. Sometimes there's also emails that are included in it that are not in the communication log, just within their own departments. Also included in that are all the testing that was completed for that case. So in this case, I believe it was around 1,900 pages to review. You have every test that was ran on it. You have all of their standards, which are the calibrators, which allow you to put a quantitation number to something. It also includes the quality controls, and it includes this case specifics data.
And did you have an opportunity to review the litigation packet for toxicology report 231-26889?
I did.
What, if anything, did you find as a result of reviewing that report?
That it, looking at the, and I don't have it up here, I didn't bring all of it, but the request was signed to be relinquished from the medical examiner's office on 3/31. It was received at NMS, I believe, on 4/4. With any kind of blood sample or even just tissue, anything that's biological, it needs to stay refrigerated. For multiple reasons, it helps to slow down any kind of growth or breakdowns, preferably to be frozen, but it helps to reduce that. And then looking at when it left the medical examiner's office, I presume it arrived with the body. Part of my past experience is I did medical examiner work, and we would get antemortem tubes with our postmortem samples to look at and compare. And when we would get that, they would be multiple tubes to choose from. And so I don't know if there were multiple tubes sit in this case, and this is the one that they chose. But it was collected on 2/25, and it doesn't, and as far as I can tell, arrived to the medical examiner until 3/7. So I don't know how it was stored, who had access to the sample. It was collected for medical purposes, so I don't know what was done at the hospital for testing, opening, who had access to it there, how much blood was removed, did they spin it down at all, anything that could have happened to that tube prior to it arriving at the medical examiner's office.
So, thank you. So are you stating that you found that there was an issue with the chain of custody with this particular sample?
Yes. And the medical records also state that they couldn't identify a chain of custody, which is why they contacted the PD to have the PD come draw their sample to establish the chain of custody. And that was after this sample.
So did you ever find in your review of any of the materials, anything that could establish a chain of custody that would be sufficient, in your opinion, in regards to the ANAB standards?
The laboratory maintained a chain of custody, and that's where the chain of custody started.
What about previous to the time before it got to the laboratory or arrived there?
I don't believe I've had any documentation for that.
Was there anything else that you noticed about this laboratory report that you found issue with?
I notated that there was no seals on the tubes when they arrived at NMS. There was no evidence tape over it. There was nothing to seal it. Not saying it was open and spilling everywhere. I'm not saying that. The sample would have been closed because there was notation of no spillage. But there was nothing over top of the tube and a date and an initial to make sure that it hadn't been tampered with or hadn't had anyone had access to it prior to it arriving to the laboratory.
Is that something that ANAB requires of an accredited laboratory?
No, it doesn't require it to be that. It's just required that they document how it was received.
What do you find is best practice when you're dealing with these types of forensic toxicology tests, especially in criminal cases?
In my experience, we've received our samples for forensic toxicology to be sealed, dated, and initialed by whoever collected it for the integrity of the sample.
And was that done here?
It was not.
What type of tubing was the blood or the vial of blood? What type of tubing was it packaged in?
It was in a clear plastic tube, which would have no preservatives. So if there was a dirty collection, meaning if they didn't have the site clean and some bacteria got in, there's nothing to even slow down bacteria growth or bacteria formation. And there's also nothing to slow down or retard any of the degradation of any of the drugs that would have been present.
Are there, if you can educate the jury, and we've all had our blood taken before, are there different types of tubes that are utilized to preserve whatever the sample is, whether it's blood, urine, whatever that is? Are there different type of tubes for that purpose?
Yes, there's different color top tubes. Ones that I'm familiar with from working in the laboratory, we saw tiger top, we saw blue top, purple top, and those are all unique to the medical field of what they're looking for to test. So each of those have a different preservative in them depending on what the medical need is out of that sample. The most common one used in forensic toxicology is the gray top tube because it has potassium fluoride or potassium oxalate and sodium fluoride, and both of those help to slow down or retard the formation of bacteria, as well as help to preserve the blood specimen as best that it can.
Now, was this sample actually preserved with the proper tubing?
Not for forensic testing.
So, did you find that as a result of the issues, well, let me ask you this, were there any other issues that you found with this particular vial of blood?
I think that those are the main ones that I found.
At some point, were you able to ascertain the levels of concentration for this particular vial of blood in terms of what it was looking for? What exactly was this test looking for in regards to this toxicology report, I should ask?
So it was looking for cocaine in the products, which is what it's listed as, which is the cocaine and the metabolites. And the blood was also looking for designer opioids, which are going to be looking for your more typical illicit fentanyls and illicit opioids. This did not look for the actual drug of fentanyl.
And so, are you stating that where we see the testing designer opioids, that does not include fentanyl?
It does not.
Did you see anywhere in this particular report where it was asking for a fentanyl test?
I do not, and they also didn't order a general screen that you typically see with forensics post-mortem that we saw in the liver, which is a very broad, looks for multiple substances. And I believe there was a note in there that it was a direct reflex for cocaine in the designer opioids because they were nervous about the volume of blood that they had left for testing. So they directed this sample instead of taking out of the normal flow of how a sample would have been received and processed.
And were there results as a result of the testing for this particular report? Did it yield any results?
It did.
And what results did it yield?
We have benzylecanone, which is the first major metabolite out of cocaine, cocaine, which is the parent drug, and then ercanine methyl ester, which is a secondary metabolite out of the parent cocaine.
Was there anything else of consequence that resulted out of this blood as a result of the testing that was performed?
So the things that are reported are things that are above their, what they call the LOD, the lower limit of detection, or the LOQ, which is the lower limit of quantitation. I'm not sure, it was not provided their SOP or their validations for these methods, so I don't know if those are one and the same. Some laboratories, their LOD and LOQ are the same. Then what that means is that the instrument cannot look below that quantitation level or that limit of detection and be reliable. And so I don't know if that included that, but in my review of the data, I actually did find that there was some of the metabolites that were present that were just not above the reporting limit, so it wasn't reported, but there was presence of an indication of in the data.
And what exactly did you notice that was present in this particular report that was not reported?
So in this, it would be the item number is 1A1, and I can identify it because it has a 001. So if we go back to the first page and we saw that the clear top tube had 001 in front of it, that is, as I review the data, everything that I find that has 001 is tying it back to that specific item. So I'm not mixing up that with the other liver item or the homogenate. And so I was, there is presence of coca-ethylene in the windows, and if it's not there, then the window should be just a flat line. There should be no coloring of the little mountains or peaks in there. But
Is this?
No, that's 285.
I apologize.
That's okay.
Let me make sure I have the right one. So, did you find in fact coca-ethylene in that report?
I got indication of. I will also say though that the, you'll pull up, so I can, up or down, sorry.
Sorry.
Over to the right, that's the comforter.
Okay.
And so the ion ratios though on this are out, however. And what that is important to also note that even though it is in the window, the ion ratio is out. So it was below the reporting limit and it had another criteria that was also out for the reporting limits. But this was a very low sample and it was very, I don't know what all had happened to it prior to, so if we would have had a full sample, I don't know if those ratios would have been able to be in, because I would have had the full sample instead of having stuff removed, because I don't know what the hospital took, and I don't know what the hospital did to that too prior to it being there.
Okay. And so did you in fact find a notation or an indication, if you will, of coca-ethylene?
Yes, it is present in both windows of the, there's a transition, you have a main transition and you have a second transition, and it looks at, for lack of better understanding, you have my water bottle as one transition, and you have this cup as a second transition. You look at this ratio of the height between the two, and that's what it's talking about the ion ratio. That ratio needs to be consistent to call that drug. But just because it doesn't have the ion ratio, it should lend to further testing to look and see if it is actually present or not.
Would this be the correct?
No, that's 183.
Okay, sorry about that. So, but you can tell us that it was in fact an indication of coca-ethylene in this report.
There's indication in both windows, yes.
Now, you stated that the ion ratio was out, is that right?
Yes.
And so how can you then tell this jury that coca-ethylene, there was some indication of it?
The ion ratio being out doesn't mean that the instrument didn't see the analyte. The instrument saw the analyte and was able to generate a indication or a peaks in the window. If it wasn't there, it wouldn't have a peak in the window.
Okay, and did you in fact see a peak in the window in this particular testing?
I saw indications of yes.
Okay. What does that tell you in regard to whether or not coca-ethylene was present in the blood of Ms. Jade Benning?
As I said, it would just draw me to do further testing. With the ion ratios being out and below the reportable limit, it would definitely cause me to run the test again, see if you can do microing, you can pull it down and reconstitute it and make it at a stronger concentration, and then rerun it and see if we would be able to obtain a value or not, to prove if it was there or not.
So if I draw your attention here at the bottom of page 3 of 4 of this report, do you see where it states coca-ethylene here?
Yes.
And is this a confirmation test?
Well, we're looking at the liver. You'd need to move up a little bit.
Sorry about that.
Okay, yeah.
Okay.
So this would be a confirmation because we can see that it's the liquid chromatography tandem mass spec. And that's where we're able to get the two different windows to see the transitions based on the instrumentation selected here. If this was a screen, it would have been an ELISA or an immunoassay type test.
So before they move to a confirmation test, what type of test do they perform first?
Typically, you would do a screening test, but in this case, I believe it went straight to confirmation. So they skipped the screening test and went straight to this test to look for the drugs.
Thank you. Are you familiar with coca-ethylene or the metabolite coca-ethylene?
Yes.
What is that?
It's a metabolite that is made only in the presence of ethyl alcohol and cocaine at the same time, and it's made in the liver.
And
is there any other way, to your knowledge, that cocaethylene can be formed in anyone's blood or urine or any matrix that you know of?
No, and that's what makes it unique about cocaethylene, is the only way it is produced is with mixing cocaine and ethyl alcohol, or what we would call alcohol in our normal language, and it has to be at the liver at the same time.
And there was indication that here.
Yes, ma'am.
Did you find that there were indications, and just so that we're clear, at what time was the blood sample taken for toxicology report number 231268889?
2:25:23, 22:31 military time, or 10:31 p.m.
And did you have an opportunity to review the medical records in this case?
I did.
And did you find in the medical records in this case an actual urine drug screen that matched the date and time in this toxicology report?
A urine drug screen?
Yes, well, urine was taken from Ms. Benning. Did you find that in the medical records?
Yes, I saw urine was taken. I don't have it in front of me. I don't know the time, but I know it was taken on 2:25.
Did you find that it was consistent with what you saw here?
This was a blood.
In terms of this report?
So this was a blood sample.
I'm sorry, not urine, blood, yes.
So I did see in the medical records that there was blood taken. There were several orders of blood being ordered at the 22:31 in the ER medical records.
Yes, that's my apologies. Now let's go now. You were talking earlier that I had showed you the comforter. Do you remember that?
Yes, ma'am.
And that would be toxicology report 231298285. Do you remember that?
Yes, ma'am.
I want to show you now what would be considered the data from that report. Would that be consistent with that?
Yes, this is a summary page of the cocaethylene.
And the comforter in this case, would that be the comforter that was recovered from Ms. Jade Benning's home?
According to the documentation provided in the literature packet, yes.
And did you learn that on that comforter that Ms. Benning had vomited on that comforter, according to what was told in the facts of this case?
Yes.
And as a result of that, did NMS perform testing on that vomit?
Yes.
And is this a result of the testing that was performed on that vomit?
It's one of them.
And did they find in that vomit cocaethylene or an indication thereof?
So yes, if I can, just to help the jury to see what you're looking at besides just a bunch of numbers. Sorry, you could switch the other way. Sorry. Yes.
Okay.
If you look at line item number 43 and 44, and what I'm looking at to identify this is the 007 number. And if you would show the cover page so that the jury can see where that
Yes.
number comes from.
You can go ahead.
Okay, so they extracted at the same time controls. So the low control is labeled 003. The case blank, so that would have been based on documentation, it was taken from an area completely away from where the vomit stain was, but of the same material in which they were extracting for this case to look at the vomit, and that was listed as 004. And then you have a high control, and that's listed as 005. And then they have a lab blank. So they took another piece of fabric or something from a case unrelated completely to this case and extracted it in the same manner. And that was listed as 006. And then 007 is the case sample. So that would be where the vomit would be taken from the stain of where the vomit is to believed. And so that is how I then correlate looking at the data where we see the 007 1G1. The 1G1, all that is showing is the extraction vial that had been labeled so they can go back to their reports and such. And then the 1+99 is the 100 times dilution. And then the one below it, the 1+9, is the ×10 dilution from the original extracted liquid that they pulled off of a material. And then if you look under where it says nanograms per mil, where you see the 2.8, 2.6, we see that there's actually some values there. And if we scroll all the way to the far right, this one actually has the ion ratios in. And if we, at the top, it'll say ion ratios out, yes means that they're out. And then if it says no, it means that they're in. So,
you see that there?
yes, so if we down a little bit, up, nope, up. And then we want to look at the 1.9.
Let me scroll.
Yes, there we go. You can just see all the no's on the side.
Okay.
So
And you said the 1.9?
the 1+9, so vial item 43, go up a little bit. Up. So the 05 is showing you that high calibrator. So they ran a calibrator at the same time as they ran the case sample to make sure that their calibrator is still reporting and responding the way they intended it to respond when they did the original extraction at the very beginning. So that's just the checks and balance for them.
Okay. And so is the ion ratio that we talked about before, is that present in this particular test?
Yes.
Okay. And what does that tell you that is different than what the other test told you?
That this one would have been reported had it been above that LOQ or LOD. This is a reportable value.
And this was in fact found in the vomit of Miss Benning on the evening of 2/25/23.
It was found on the comforter.
Thank you. Was there anything else of value that was found on the comforter from Miss Benning?
That was found on the comforter?
In the vomit, yes.
No, I think that was it, that it was there, but it's below the reportable limit, and so it wasn't reported.
And what exactly would that have been that was there but was not above the reportable limit?
And that would the fentanyl as well. And so
Is this you're looking at the number here?
yeah. So 007, so that indicates us that is the case sample. We're not looking at a blank, we're not looking at a QC. And the 1+1 is a dilution of some sort that they're doing. I'm not sure what the dilution is, other than because they had to extract it from a solid material, probably into a water with some steps that they did. And then if you see the two windows on the top where it says fentanyl quant, the one on the two on the left is the deuterated internal standard. So that is something that was put there to know that the instrument is responding correctly and is doing what it's supposed to. The two on the right under fentanyl quant is the sample of the unknown. So if you look at the one that's below it, it's hard to read because it's blurry. It says norfentanyl quant. That second one, how it just has a squiggly line and there's no actual peak there, then that's not there. But if
you can give us a minute to see if we can fix it so that it can.
Yes. But you just need to see that those peaks are there. That's what the indication is. If it's not there and it's not indicated, then you would have what you look like there at the norfentanyl. You have to have both transitions for it to say that it is an indication that there is something there.
Okay. And so did you find that there was an indication of fentanyl in the vomit of Miss Benning?
Yes, and I believe the concentration was very low.
Now, speaking of concentration, as a result of the type of testing that was performed on the vomit, are you able to quantify that vomit?
No.
And why is that?
The method that was used was a detective method, so you can't have the validation that needs to go through to do any kind of method extraction and method development for the instrument. It's a two-part, but they kind of go into one. A validation is at least 16 experiments. It looks at precision, it looks at bias, it looks at extraction, recovery, and all of that has to go into how they are able to report at the end of the day based on the reliability and such of the sample. And so if you have a qualitative assay, it is just that. It's present or it's not. You cannot assert any kind of number to it. And in this particular case, you really can't because the curve failed. Meaning you can't take, a curve is created with known concentrations to make a linear line. I like to kind of help you guys have an idea. If you remember, have kiddos that have elementary school and you were given an X and Y and you had two of them you had to find and you had to count across on your X and up to the Y or either way to find it. Think of that line as the calibration curve, and then the unknown is that X or Y that you're trying to track over to it. So if that curve is not successful and does not pass, then anything on that cannot be reliable. And so then you switch it to qualitative, and qualitative is just there. Quantitative is a number. And so it's present or it's not. You cannot put any kind of faith into the numbers that are produced from that report.
And so are you telling the jury that when it comes to the vomit, there was on Ms. Benning's comforter, that there was in fact an indication of fentanyl, and there was in fact an indication of cocaethylene?
Quantitatively, yes.
Now, the blood that was taken, as we were discussing previously, in regards to the litigation report 231268889, I asked you whether or not there was a corresponding date and time of blood collection for Ms. Benning. Do you remember that?
Yes, ma'am.
And that was in fact at the hospital for 225 at 2231. Is that correct?
Yes, ma'am.
Did you have an opportunity to look in the medical records to determine whether or not Ms. Benning had been given fentanyl at the hospital prior to that time?
There is notations in the medical records. It says that it was pulled and then it says it was wasted, and so I'm not clear if it was given or not.
And that's something for more of a medical professional to discuss, but
Yes.
I just wanted to know whether or not you had the opportunity to review that.
I did.
Let's now discuss whether or not, or tell me this, what does it take for you as a toxicologist that works in a laboratory to review records if you were to look over someone's work in order for you to sign your name to it? Can you tell this jury what all that would take?
Objection, Your Honor, to relevance.
May I respond, Your Honor?
I'll overrule the judge. Go ahead.
So in my experience working in the laboratory, we've had people leave and had to review their work and whatnot. For myself to put my name on a report and take responsibility for that work, I looked specifically at the QCs, I looked at the calibration data or the qualitative data, whatever it is, but I looked at the entire case, and many times I would actually go to the instrument and I would look at the raw data. So there's printed computer data and then there's raw data. Raw data is what is done in the software, that's well above my knowledge, as it comes off the instrument and it computes it into the computer. The reason I specifically would want to go look at that raw data is an analyst can manipulate that data and then it will print, and you don't know in many cases if that data was manipulated or not. So if I'm going to be putting my name on that paper, I want to make sure that that data is true as it is on the computer. I want to look and to make sure that the entire batch had consistent results. So when you look at the lit packet does include the calibration and the controls, but we're only getting a snapshot of just this case. In many of these samples, there was hundreds of cases ran at the same time. So if you take a 35 millimeter film strip and you take out one picture, but what happened before or what happened after it, if I'm putting my name to sign out that case, I want to know that everything was before it, there was no problems with the instrument, there was no delays, there was no other issues, and correspondingly after it as well. And so it takes time to go through that data. Even doing this for 10 years, it still takes some time to review all of that.
And did you have an opportunity to look at the litigation packet as it relates to the litigation packet we were speaking of that ended in 889?
I did.
Do you remember how many pages of documents was that litigation packet?
I believe this one was around 1,900 pages.
1,912. Do you remember that specifically?
Yes.
Okay. And in your opinion, in order for an analyst to be able to review 1,912 pages of data, how long would you say that would take?
Just to review the lit packet and not look at the entire batch would take a significant amount of time.
Okay. What would be a significant amount of time?
To tell you, it took me almost an entire day just to go through just the lit packet myself and to look at everything and look at the controls, look at the responses, look and see if there's indications in the windows, and look at the entirety of just the lit packet. That's not looking at the entire batch.
And would you believe that you would be able to look at 1,912 pages in a fashion that you could sign off on it as having reviewed it in its entirety in less than 55 minutes?
Me personally, absolutely not.
Do you know of any situation in your experience as a laboratory toxicologist, with all that you know that it requires, any situation where that could be done, based on your opinion?
It would be difficult to do a thorough review before putting a name on the bottom of it and taking true ownership of that data.
Now, let's say that there was another packet that you needed to review, and that packet was over 2,600 pages. Given the same example and having to review both of those packets in less than an hour, would you believe that that would be possible?
Not to review the entire litigation packet and to do a thorough review of it.
Can you tell this jury exactly how many people actually have to perform testing in order for a toxicology report, let's say for 231-26889, the one that's 1,912 pages, how many people perform tests in that litigation packet?
For NMS specifically, because every laboratory is different, NMS specifically, there was, I believe, 4 to 5 people who handled something in the preparatory of that sample. So from my understanding, I don't work at NMS, but from doing review and talking to colleagues that work there, it starts off with one person who receives the package, and then it goes to another person who does an aliquot. So it's a big science word. An aliquot is a sample of the whole. So if you think of a piece of pie and you take your slice of pie out, you've taken an aliquot of pie. And then they then put the rest of it aside, and I'm guessing so it's easier to maintain and move through. Doing 130 samples in one batch is significant, a number of tubes you would be having. And then it goes to another person who preps the sample, and then it goes to another person who does the extraction for the sample,
and then someone puts it on the instrument, and then someone reviews it coming off the instrument, and then it goes to the review person after that, and then it appears with Dr. Methune to release the report to the customer at the end. So it goes through multiple hands along the way.
I want to show you an example of both of those packets that I just discussed with you about the review of those packets. Can you see these packets here, or do I need to move them over there?
I can see them.
Okay. And so, this is the data that is compiled in 2 of those packets. In your professional opinion, Dr. Jaguar, can you review adequately everything that you explained? All those individuals who had to run through this testing and perform some of the data that goes along in here. And I'd like to just show the jury and orient them to some of the data that you must review.
Objection, Your Honor, this witness cannot authenticate data, and I object.
I'm not asking her to authenticate it.
I'm asking that anything be shown to the jury that has not been.
Okay, you're just asking to show.
I'm just asking a question.
You've already asked that question about the volumes.
And so, this is just an example of all the data that's compiled in those litigation packets. It's not.
It is.
And does a analyst who signs off on this packet to sponsor that all of this information is correct, would they have to review all of this paperwork and data?
In my opinion, yes, before they put their name on it.
Can you do that in 53 minutes, Dr. Jaguar?
Not unless you're a speed reader.
Thank you. I'll pass the witness.
Questions from the state?
Yes, Judge, because of the circumstances, can I have just 5 minutes?
Okay. If you'll step down the hallway, ladies and gentlemen. Thank you. You're wanting General Norman just to speak with Linda.
Yes, Your Honor.
Is that going to be the case? Is she going to need to listen to Dr. Mario Bartolome, Dr. Kelly Larkin, and Dr. Lindsay?
I believe that Dr. Carney is our expert that would be for the other 3. It's
Oh,
just
okay.
Dr. Mithun with this person. If I could just have a few minutes to speak to her.
Okay, all right, we'll take a 5-minute break. I guess hang her up there, she can call her on her cell phone.
Court's in a brief recess.
Okay, so I'm gonna talk just a little bit, just kind of, sort of. Let me see if they are back. Live. Okay, so quick question, because I think I'd have missed it at the end. Did they say they were going to lunch? Or just taking a recess? I don't know. They've been doing all types of stuff this morning. Nothing currently, little miss. They are on break. I don't know if it's a lunch just yet. I haven't confirmed that part. I'm scared to cut on my camera because I am streaming using my hotspot on my phone. So there we go with that. Okay, so I'm gonna talk just a little. Oh, want to see the first? Oh, you so funny. Okay, so we will. Let me show y'all this. I'm trying not to open up too many windows. Okay, wait a minute. Let me get her up. So in case you guys didn't see it, I did post it over in Discord. This is Apple Denny's Facebook post. So basically, she says, thank you to everyone who has prayed, texted, or reached out in any way. I've tried to respond to everyone. If I missed you, please know I am grateful for the support. I have much to say that I have much to say that I'll find words for at some point, but for now I'm praying and ready to finally close what was such a difficult chapter in my life. As hard as the last 3 years have been, I am grateful that my story could serve in some part of finding justice for Jade and Ivy. Um, yeah, so yeah, this is what she had on. I'm almost sure this is what she had on at court. It looked like the outfit I had. It's nothing wrong. I was like, but that was good because I was able to confirm it. That was her. Okay, and then I know I probably cannot get into my I'm so scared to pull up Discord, but let me try to see if I can pull up um of course, because Drunky sent me some information. I don't know if we are assuming that this is maybe the girl, but I don't know yet. We have to find out, but it appears that it may be her. So, um, let me see if I can pull up her page. It must be her because I see when I pull up Xavier Winford, um, Denny comes up too. I wonder did she respond or anything? Let me see. Wait a minute, y'all. It's so crazy that I don't be on Facebook to the point that we got a Facebook page, right? And I barely even know how to work Facebook. But let's see. Okay. Okay, and here is the girl that we think that he is. This is who they're talking about in regards to. They all kind of look alike to me, but this is Xavier Winford. This is the girl he was with when. This is the girl that Apple, I believe, allegedly, that Apple was testifying that she was the one that was cuckoo for Cocoa Puffs, and he didn't want to have a baby by her, and he reached out to Apple to get a pill or something, and Apple made an appointment for this young lady to have an abortion, allegedly. But the funny part is that when he moved, I believe it was to Utah, when he moved to Utah for his new job, when they picked him up, guess who he was with? He was with her. So I don't know what that says for that. Like, I wonder, does she come in and testify and tell us something different? And so this is kind of her Facebook thing. Very pretty girl. They all look like kind of the same, quiet as kept to me. To me. Yeah. They all kind of like, if you put all three of them side by side. You see, Arkansas University. Mm-hmm. Let's see. Let me check on the courtroom feed. I'm trying to be careful in regards to what I'm opening up because, Lord. Yeah, so it looks like they are still on lunch. Or break. I guess they went to break or lunch. I don't know which one they went to. Let me go back and try to listen real quick. And that way I can tell what we need to do.
You're wanting Joe Norman just to speak with Midwood. Is that going to be the case to Dr. Mario Foley, Dr. Kelly Larkin, and Dr. Lindsay?
I believe that Dr. Carney is our expert that would be for the other three. It's just Dr. Mithun with this person. I could just have a few minutes to speak to her.
Okay, all right, we'll take a 5-minute break.
Oh, well, it was supposed to be a 5-minute break. Oh, thank you, Junkie. Yeah, it's supposed to be a 5-minute break, but we see how long that's been. So it's been over 5 minutes, but whatever. Let's do this for people that didn't see this. I know this is in the beginning. Today we kind of had some sketchy. I got struggle streaming going on, but let's look at this. The beginning of the court date. I don't know if a lot of you guys even seen when we went over to when I had to close this stream down and we went over there to the other stream, my other little streaming service that I have with the stream with the what is it called? It's to another platform versus to StreamYard. I think I made. I mean, I know today was impromptu of me streaming out of there. It doesn't change anything from y'all. It just changes the look for us. So I will. Maybe I'll stream through there tomorrow so y'all can see how it looks, and we can decide which one we like better, as far as our streaming service. Okay, little miss. We'll be here. We taking a 5-minute break that's been over 5 minutes, but who am I? But yeah, I think I'm gonna try that tomorrow because I think through that streaming service, like I want to have us a verdict clock for Take It to Trial. So when we are watching the verdicts and we are in verdict watch, that we have our own clock that we're kind of like going by. And through StreamYard, I can't do that, but I figured out a way to do it through another streaming service. It's just kind of me getting used to not streaming in StreamYard, I guess. So, hey, Lon, yeah. He said 5 minutes. They've been gone for way longer than 5 minutes. That's what I can tell you. So, just to give y'all an idea of what I've been trying to do, like behind the scenes, and try to figure out for us so it can be, I don't know. I'm just trying to figure out some stuff. But here we go. Let's listen to this morning is I don't know what they thought they was gonna do, this judgment of acquittal. I don't know, but here we go. Let's listen.
That the medical examiner relied on in determining the cause of death for Ms. Benning, given the fact that the expert who testified to the validity, the integrity, and the blood in terms of the cocaine being in the blood, that she was a surrogate witness, it should be excluded after her testimony when she stated that in the amount of time that she had to review all of the data, she had to rely on the underlying test and analysis. Additional to that, she actually testified, I did not look at each quality control. I was not able to actually check each batch. With her not being able to do that, it violated Mr. Taylor's right to confront all of his witnesses and therefore violating the confrontation clause. As a result of that, anything that was relied on by that surrogate witness should be excluded and should not be considered. Without the blood listed toxicology report 1268889, there is nothing that the ME has testified to that she relied on in order to determine the cause of death for Ms. Benning. In addition to that, there has not been one witness that has tied Mr. Taylor to any drug, any form of cocaine whatsoever. There has not been any evidence presented to this court that Mr. Taylor bought cocaine, researched cocaine, did anything of the sort.
There have to be.
We believe that there has to be a causal connection between Mr. Taylor and the cocaine in order to determine that he...
Just the proof based on who was in the apartment for the 3 minutes between the 911 call and the Ms. Benning's call, isn't it?
I would disagree in that it has not been established by any of the experts that the only period of time that Ms. Benning would have been required to take the cocaine, that it was only within that
There's plenty
period
of
of time.
testimony that would have been very quick.
However, they did not state that it would have been very quick after she took it, but we don't know when she took it, and we don't know who gave it to her. There hasn't been any evidence.
Be somebody in the apartment, or we Danny, or, I mean, that's a jury question.
It is the defense position that no causal connection has been made between the cocaine and Mr. Taylor. As a result of that, in addition to the Smith v. Arizona issue, that there should be a judgment of acquittal, because without a cause of death, then there is no proof evidence that in fact Mr. Taylor could have caused the death of Ms. Benning. As a result of that, we move for a judgment of acquittal.
Okay. All right, does the state care to be heard?
Your Honor, Dr. Mithun was very thorough in explaining that she did her own analysis. She was not a substitute witness, just reading from someone else's report. She did her own analysis. She formed her own opinion. She wrote her own report. It is not even a comparison. Her explanation about that there's no connection to Mr. Taylor and the cocaine, and the state submits that there is substantial circumstantial evidence of he is the person who put the cocaine in Jade Benning's drink. Her own words were that she just didn't know what it was. Dr. Carney gave very explicit testimony about timing and that it wouldn't take long to feel the effects. She described dizziness as being something that would be possible, as well as the person might be able to walk, but not for very long after ingestion. And she said that a time frame of approximately 30 minutes until Jade Benning would be in full cardiac arrest, that was consistent with everything that she knew, and specifically consistent with the other autopsy she reviewed. That was the only one that had circumstances similar to Ms. Benning's case. There is I would say proof beyond an absolute certainty that Mr. Taylor was the only one with Ms. Benning in that apartment during that time frame. So the state would ask that their motion be denied.
Okay. All right, at this point, the court relies on the testimony that's been presented by the state. In light of that testimony, the court's discussed already the testimonial Smith v. Arizona issue. There's nothing the court's heard since that ruling that changes that. I mean, Dr. Mithun talked about each batch, but said that didn't affect the reliability of her testing. She looked at a number of them. I don't know if she was asked specifically how many, but, and in terms of the causal connection, something happened to Miss Benning in that apartment. There is circumstantial or direct proof that Mr. Taylor was the only one there, so that's not my role to judge credibility. If they believe Miss Jackson's statements, then the cited utterance from Miss Benning tells us who it was. So I'll overrule the motion for judgment of acquittal. Who is the defense first witness?
Detective James Smith.
James Smith. Is he here?
He is here, I understand. Really briefly, Your Honor, I think we need to pass our...
I thought that had already been done. The people were here.
I think we're here. I don't think we tested you yet. I just want to make sure we get tested real quick.
Is that your computer?
Yes,
What's on your computer?
it's a PowerPoint that's on it.
Well, your apps are down there.
Yeah.
It's James Smith, JamesSmith.
And where are you currently employed?
The Metro Nashville Police Department.
And how long have you been employed there?
Nearly 13 years.
Did you ever have an occasion to get involved in this case involving Mr. Blaise Taylor?
I did.
Were you the first officer on the scene at the hospital, the first detective on the scene at the hospital?
I was the first detective to respond.
Did you ever call Andrea Browning and give her permission to go into the house?
Initially, I did not recall that spoke. But yes, been talked about, yeah.
And would you have given anybody permission to go into the house? Is that something you would have done?
The only time that would be done is because I was not doing the search warrant, and the officer I had released, the officer, emergency officer, who initially was going to secure the scene or the apartment at that time, he had been released. The apartment at that time had been released, was no longer in police custody. to be frozen and such. So to give permission to anybody, it would have been after that fact that I can't say they can or cannot go in there at that time.
And just to be clear, do you have any documentations or recordings suggesting that you gave someone permission to go into the house?
I personally do not.
And would you have given permission for her or any friends to enter into the apartment?
If given permission, it would have just been family. I would have given them family.
And did you give family permission in this case to go into the apartment?
Based off the recollection that was given to me, it would have been either stepmom or mother, but Ms. Browning would have been the contact.
Would an email that you sent refresh or aid in your memory for your testimony here on today?
Yes.
Have you had the opportunity to refresh your memory?
Yes, sir.
After refreshing your memory, do you have any recollection of giving Mrs. Benning's stepmother or any family members permission to go into the house?
Like I said, initially when I sent this email, I had no recollection or memory of giving anybody permission.
And when did you send the email?
This email was sent yesterday, Sunday, June 28th, 2026, around, it would have been 4 p.m.
And do you stand by that recollection?
Not with the information that was given to me this morning.
What information was given to you this morning?
You provided me a transcript. I still don't remember exactly giving the permission. Like I said, it wasn't in any documentation. I don't have a recording. The last recording I have was speaking or interviewing anybody was Mr. Taylor. But it was possible that since you gave me information showing this transcript that from Ms. Browning that I had spoken to her.
So, is your testimony today that you called Ms. Browning and gave her permission to go into the house?
I would say it's possible, yes.
Based on what?
Based off the information that was given to me this morning.
And who gave you that information?
You did.
And the information that I gave you was what exactly?
Transcript from you state Miss Andrea Browning testifying that I called her.
Was it Ms. Browning or was it Ms. Burks?
I'm not sure. I recall you saying Miss Browning.
It was Ms. Burks.
I'm not sure who Ms. Burks is.
Did you ever speak to a Ms. Burks?
I'm not sure who that is.
That is Mrs. Benning's mother.
I spoke to her on the phone initially at the hospital. Again, I don't recall speaking to her after.
And in that conversation with her at the hospital, do you recall giving her permission to go into the house?
No, not at the hospital.
Thank you.
Or any questions from me?
We did Sergeant Smith, correct?
Yes, sir.
All right. Sergeant Smith, the other patrol, the uniformed officers had spoken to certain individuals, including Ms. Browning, before you did, correct?
Yes, sir.
All right. And if the timing reflects that your conversation with Ms. Browning was approximately 1:45 a.m., does that sound accurate?
Yes, sir.
And again, that would have been after Officer Fish discussed.
Yes, sir.
Interviewed her. And so at 1:45 a.m. and thereafter, you knew that there was not going to be a search warrant.
Yes, sir.
Correct? And that there was not going to be any police present at the apartment, correct?
Correct.
And so legally, whatever, morally, was there any authority you had to tell them that they could not go into Jade Benning's apartment, secure it, and deal with it?
No, sir. Once it was released, I can't say who cannot go in there.
Well, you said released. Had anyone ever actually been there to put
No.
up crime scene tape or stand at the door?
No, sir.
Barring entrance?
No, sir.
And so whether you over that 145 or thereabouts, or later in the call, had absolutely every right to go there.
At the time, yes, sir.
That's all I
Detective Smith, to be clear, yesterday in your email, you said you did not talk to anyone?
I said, based off my memory and recollection, I don't recall or recount talking to anyone about giving permission to enter the apartment.
And you are aware that your conversation with Ms. Browning, do you know if that was recorded or not?
The initial conversation with Ms. Browning at Vanderbilt Hospital is. Any conversation, again, the last conversation that's recorded in my interviews was Mr. Taylor.
And you would agree with me that nowhere in that recording with Ms. Browning did you give her permission to go into the house?
Yeah, at Vanderbilt Hospital, there was no recording of me giving permission to anybody when I was at Vanderbilt.
And
Go ahead.
sorry.
You go ahead.
And outside of that recording, you don't have any documentation or recollection of ever giving someone permission to enter into the home?
I don't recall having documentation, or like I said, Mr. Taylor was the last recorded interview I had.
And you do recall that a request was made for the scene to be secured?
I do.
Any other questions?
No, Your Honor.
Thank you.
Thanks.
Who's the next witness?
We will call Sergeant Lindsay Fish.
Do you swear the testimony you're about to give to be the truth, so help you God? I do.
Good morning.
Morning.
Can you please state and spell your name for the record?
Lindsay Fish, Lynseyfish.
And how are you currently employed?
I'm a detective with Metro National Police Department
And how long have you been employed there?
since 2020.
And did you ever have an occasion to make the scene in an incident involving Ms. Jade Benning at Vanderbilt Medical Center?
I did.
And would have been around February 25th of 2023?
Correct.
And in what capacity did you show up on the scene?
I was a patrol officer.
Were you wearing a body worn camera?
I was.
Was it activated?
It was.
The court officer has handed you a photo, and I want you to take a look at it. Do you recognize it?
Yes.
Does it purport to be a still image of your body worn camera from that night?
It is.
And is it a fair and accurate depiction of from your body worn camera that you were wearing that night?
Yes.
Has it been altered in any way?
It doesn't appear to be.
Your Honor, at this time I would ask that this be entered into evidence as a defense exhibit 3, I believe, or
We're just putting it in the
55. I'm sorry. Permission to publish on?
Okay.
Can you describe what you see in this scene here?
This is the entrance to the ER of Vanderbilt Hospital.
So this is can you circle this right here? That pole, can you circle it on the screen, please? What is that?
It's a form of metal detector.
And if a guest were to come into the emergency room, would they have to go past that metal detector?
They do.
You see this person with that mask on right here?
Yes.
Can you circle that individual, please? Do you know what that individual is doing?
He is the security officer for Vanderbilt and was checking people in as they go.
And that's what he was doing that night?
Yes.
And to the best of your recollection, was this individual alone, or was there another security guard also present there?
There was other security there.
And to the best of your recollection, were they doing their job?
To the best of my recollection, yes.
Did you ever have an opportunity to speak with a Miss Brown that night?
Yes.
One second, I want to go right back to exhibit number 55. Can you tell me what, if anything, that security guard is wearing on the face?
The mask?
Uh-huh. Is that a mask that they're wearing in this photo?
Yeah.
What about the individual that appears to be checking in? Is that individual also wearing a mask?
Yes.
And so was that a standard protocol and procedure that night that people entering into the hospital with no had to wear masks?
Yes.
Now, I just want to try to orientate the jury to, when you say you were one of the first officers on the scene that day,
Correct.
would that mean that you would have come before any detectives would have arrived?
Yes.
Did you have the opportunity to speak with a Miss Andrea Brown?
I did.
And do you know who that is?
It was Miss Benning's stepmom.
And do you recall?
Closer to the mic.
And do you recall while speaking to her that Miss Burks got on the phone?
I don't know who Miss Burke is.
Miss Burks would be the mother of Mrs. Benning.
Yes.
She did in fact get on the phone.
Yes.
And you were present for that.
I was.
And what, if anything, did you instruct them while you were in the presence of Mrs. Browning with Mrs. Burks on the phone?
I just informed them of what was going on and asked them if they had any questions.
And did they inquire about whether or not there was an investigation going on?
They did.
And what did you tell them?
I told them that there was an investigation going on.
Did you inform them that detectives will be coming out?
Yeah, I did.
Did you tell them that the house, the apartment, should be frozen?
I did.
Did you tell them that in being frozen, no one in, no one out?
I did.
And you came before Detective Smith, correct?
Correct.
And again, when you gave those instructions, Ms. Browning was present?
Yes.
And Ms. Burks was on the phone?
Yes.
No further questions.
Questions from the state?
Good morning, Officer Fish.
Good morning.
You were just asked if you recall telling them that the scene should be frozen, is that correct?
I did.
Okay. And if your body cam reflects you speaking to Miss Browning around 12:37 a.m., is that accurate?
I don't know the exact time.
But it was prior to Sergeant Smith?
Yes.
And to your knowledge, Metro National Police Department was going to go out, conduct a search warrant, and freeze the scene?
I knew that that was a possibility.
And if Sergeant Smith's search warrant later got denied, and there's a possibility he told them they could go back to the apartment, would that make sense?
I wouldn't know that information.
Okay, would it make sense if there was no search warrant and no one was freezing the scene, Metro wasn't there.
Objection, call for speculation, the witness says she doesn't know that information.
Okay, rephrase your question.
Officer Fish, if Metro Nashville Police Department has no legal basis for holding a scene, freezing a scene, if they're not conducting a search warrant, would there be any reason to tell the family that they could not go back in the apartment?
No.
Those were my questions. Thank you.
Officer Fish, do you recall ever stating that you all had information that a possible crime had occurred?
I do.
And that's the information that you gave Ms. Brown, correct?
Yes, that the investigation was, why the investigation was happening.
Fair enough. No further questions, Your Honor.
Any other questions?
No, sir.
Thank you. We'll step down and be excused. Who's the next witness?
The person called Leah Gutierrez. We'll move to Dr. Peters. What's the last name? Sheila Peters. Oh, there she is.
Might we approach?
Okay. It's got, no, don't bother. Go ahead with your question.
Thank you. Could you please state your name for the record, please?
My name is Nia Gutierrez.
And Ms. Gutierrez, how are you employed?
I am a Tennessee licensed private investigator and a Texas licensed private investigator.
And how long have you been a licensed investigator?
In Texas for about a total of 7 years, and in Tennessee, I'm coming up on 1 year.
And did you recently move to Tennessee?
Yes, last year.
Okay. And what company do you work for in terms of for investigations?
Out of Texas, I work for Willis and Associates, and out of Tennessee, it is Covert Results.
And how long has Covert Results been in business?
Since 2017 or 2018, I believe.
Did you have an opportunity to go out to the Ontario apartment where Ms. Benning lived?
Yes.
And when you went out to the apartment, did you have an occasion to view the apartment where Ms. Benning lived?
Yes, I did, on the exterior with the door closed.
Also, did you have an opportunity to view the marquee for the apartment?
Yes, I did.
I want to draw your attention. Do you have with you photographs?
I have something else not to put photographs with me.
Should I have photographs?
Yeah. I believe you should have that photograph in your packet there.
Yes.
Okay. Do you recognize that?
Yes.
Okay. Can you find that in your packet, and can I get my copy back?
I'm sorry, this picture is not in my packet.
Okay, that's fine.
Do you recognize that photo that you
Yes.
took?
Yes.
And what is that a photo of?
It is a picture of the marquee of the incident location demonstrating the physical address of the apartment complex.
Okay, now I have a text please, so that I can publish to the jury. Is it in the same fashion in the way that you photographed?
Yes.
And are you the one who actually photographed this?
Yes, correct.
Your Honor, at this time, I'd like to publish. Is that in fact the marquee for the Ontario apartments or condominiums?
Yes.
Have you had the opportunity to view any photographs from 2023 or February in the apartment? And is that marquee the same? Could you please read
It is 15.
Did you have an whether or not Ms. Benning's apartment had windows?
Yes.
Where were her windows situated?
On the rear of the apartment.
If I may, Your Honor. Was there anything behind that apartment where the windows were located?
There is a trailer type business, as a trailer service repair business at the rear of the apartment complex. It's rather large, and from my understanding, it's called TSR, and they repair trailers.
I want to first show you this photograph here. Do you recognize that?
Yes.
And what is that?
It is an angle from the rear of the apartment.
And are you the person who actually took this photo?
Yes.
And could you, for the jury, well, let me ask that it be admitted first, Your Honor.
Okay.
Could you, for the jury, please point out which window belonged to Ms. Benning's apartment?
It would have been, I'm not sure.
Mark.
I can mark on here? Sorry. It would have been this one.
Okay. And I want to now show you another photo. You can clear the screen.
Oh, sorry.
Okay.
Got it.
There you go. I want to now show you this photograph. What is this?
This is a picture of the rear end driveway, you could say, of the apartment complex, coming in after you would come into the apartment complex and then turn to the left. It is a picture of the driveway alley behind the apartment.
And would Ms. Benning's apartment window be adjacent to that, I guess, would it be a pasture or field?
It would be, you could say, parallel, yes.
Okay, parallel, thank you. And if you could just orient the jury where Ms. Benning's apartment window would be located.
I can point?
Yes.
Okay. It would be this way.
And did you take this photograph?
Yes.
At this time, we would offer, let's see if it yourself.
We'll just make it collective, whatever you
Thank
get
you.
all of them you've got.
If Ms. Benning was to have a camera in her window, where would that camera, if it was facing out, where would it focus on? Where would it be directed towards?
Depending on the range of scope of the camera, it would have captured the entire back alley drive here, or maybe just her back patio, or to where a vehicle could be stationed back there, or all the way up into the trees. It's unsure.
Were there any other windows besides those windows that you saw in apartment 107 at the Ontario?
That is the only one that I recall.
I want to draw your attention now to another photo, if you can clear the screen. What is this?
This is an angle closer to the end of the parking where the truck repair service business is located, just below on the hill.
Is that also behind Ms. Benning's apartment and the view that would be out of the only window in her apartment?
Yes.
And what about this photo?
That is another angle showing the trailer service repair business.
Now, did you have an opportunity at our request to do any research in regards to the son of Ms. Stephanie Franklin?
Yes, I did.
Did you determine a name for the son of Ms. Stephanie Franklin?
Yes, the name is Jordan Franklin.
And were you able to ascertain whether or not Mr. Jordan Franklin was in fact a police officer?
We are going to check the relevance of this.
Your Honor, there's been testimony that a police officer gave Ms.
Right,
Franklin.
you asked all about it. A police officer told her to do X, Y, Z.
Correct. And if I
Now-
may, I would like to,
So what do you want to ask?
did you ascertain whether or not Ms. Franklin's son was actually a police officer?
Yes, so to answer the question,
That would be based upon hearsay.
Care to be heard?
Yes, it's not hearsay. She did the record search herself, Your Honor.
Well, I know that, but wouldn't the information be an out-of-court statement offered for the truth?
I don't believe that if you are doing, nobody told her anything. She researched to see whether or not a T-code existed
So
for
you
Ms.
want to litigate whether the gentleman was or wasn't a police officer?
I think that's very important for the jury to know, Your Honor.
I object on the basis. It's hearsay.
I believe it goes on the effect of the listener.
Effect on the listener?
Absolutely.
Okay, it is hearsay, so I'll sustain the objection.
Also, it goes to 609 impeachment, which allows you to impeach with hearsay.
Based on reliable information.
Correct. And I believe that the information that Ms. Gutierrez received.
You have someone that you're calling from a police department saying he wasn't a police officer?
Yes, sir.
You do?
We have researched and looked
No, I'm
at.
saying, do you have a person from that department?
Ms. Gutierrez called that
I'll
department
sustain the
directly.
objection.
And, Your Honor, if I may, through this witness, introduce this judgment.
Now, I certainly object to that.
Okay. The
It's-
judgment about.
It's a certified copy in regards to
Okay.
Mr. Jones.
Have you looked at the certified copy?
I'm not sure which one
Yes.
is using. We have the one,
Here you go. I gave it to you last week, but I'll give you another.
but may we approach?
Oh, okay.
out of Houston, Texas, and Covert is here out of Nashville, Tennessee.
Okay, and so when were you retained? When were your covert or?
Are you asking if I've been retained through which firm?
Yes.
Or, okay. Okay, well, I've been retained under Willis and Associates since before my move to Tennessee on this case.
I was just trying to get the time lined down. And with respect to this particular case, when were you retained?
Covert Results was retained at some point on the case after Willis and Associates, but is my understanding, to my knowledge,
When were you retained on this case?
When did you start billing?
I'm billing under Willis.
When did you start?
Early 2024.
And what is early 2024?
I would say probably March.
Do you have records of that?
Yes, according to timesheets that I turn in, correct. I do not, but I can get them if needed.
Did you have any other involvement as an investigator with this case prior to, when you say early 2024?
No.
Were you familiar with this apartment complex prior to being
No,
retained?
I was not.
Now, Ontario is an apartment complex on Lebanon Pike here in Nashville, Davidson County, Tennessee. Correct?
Yes.
And this sign is at the entrance, correct?
At the entrance, correct. Main entrance.
And Miss Benning's apartment that you were directed to is essentially in the far back corner, correct?
I would say the center far back corner building.
Well, let me, council, seen this photograph. Let me put this view. Actually, it might show better, but you have the ability to touch this. Where is the sign that we just saw?
It would be right about here.
Okay? And Miss Benning's apartment would be in that general area, correct?
No, that would be the entrance of the breezeway to her apartment, but not on that corner.
Okay, well, would you circle in what
It would-
part of that corner it is?
Probably right here towards the center, somewhere in that section.
Okay. Yep, another one that's a little bit further out. And this is a larger view of the businesses in the area, correct?
Yes.
And the truck repair place is in the top of the picture, would that be correct?
Yes.
And now, on this picture, could you circle what you say is Miss Benning's apartment?
You want me to circle it on here?
Yes, please. And again, circle the entrance.
Where the marquee would have been?
Yes. Connor, I would tender these photographs as the next one, 58, 57.
There are two.
There are two, yes.
Okay, just make it collective 57.
And this is part of Exhibit 6 that we've previously seen. Would you circle again what you say is the window to Ms. Benning's apartment? No. The next window over, is this also not a part of her apartment, or do you know?
I don't recall. I have to look at a bigger angle. But it is possible.
And obviously, as we see in this picture, the blinds are closed all around, correct?
Yes.
You never went in this apartment, did you?
I did not.
And the photographs that you took, do you know when those were taken, the date and time?
Can I look at my notes, Your Honor?
Sure.
On June 21st, June 24th, and June 26th, just this recent, I visited the property.
Okay. This month,
Correct.
had you visited the apartment complex prior to that?
I had not.
No, Your Honor.
Thank you. Next.
At this time, Your Honor, we would submit the judgment.
Okay.
The judgment for Keontae Jones for conviction of theft on September the 1st of 2022.
Okay. Or you want that as 58. Who's the next one?
The defense will call Dr. Sheila Peters, Your Honor.
Okay.
Yeah, it's with Lady we approach.
Okay.
And how are you currently employed?
I am a associate professor at Fish University, and I also operate a private practice,
Private practice in what?
clinical psychology.
Did you have to go through or undergo any schooling for that?
Yes.
What's
We are not objective. We're not calling her as an expert.
This is background information, Your Honor, if I may.
Okay, go ahead.
Did you have to undergo any schooling for that?
Yes.
What kind?
Undergraduate degree as well as a master's and a doctorate.
From where?
Undergraduate degrees from University of North Carolina, Chapel Hill. My master's and my PhD from Vanderbilt University.
Dr. Peters, have you ever been employed with the Tennessee Titans?
Yes.
In what capacity?
As the team clinician,
And in that role, what were you expected to do?
in that role, I was expected to provide support and assessment for players, coaches, and the entire organization.
And when you say support, what, if any, difference is there between support and clinical work?
My role was to help anyone that was experiencing any kind of distress and determine what their best treatment would be.
Did you ever come to know Mr. Blaise Taylor?
Yes.
How?
During the playing season, on average, I would attend one practice a week, and I would see him as I would see other individuals coming out to practice.
And in those general interactions, what was, if any, your impression of him?
Your Honor, I object to that.
Impression.
We're not having.
They were co-workers, Your Honor. I'm just asking her what was their impression, her impression of Mr. Taylor.
With a time frame.
I'll sustain the objection.
When, did you ever interact with Mr. Taylor in 2022?
Just cordial hello.
And did you ever interact with him in 2023?
Yes.
And what was your interaction with him?
I was asked by the GM.
Your Honor, objection.
Okay.
Hearsay, and this is in a professional capacity.
If I may, Your Honor.
What is your question?
My question is, did you interact with him at all in
And your answer is
2023?
yes or no?
Yes.
Okay, she did.
Thank you. And what time frame did you interact with him?
It was in March.
Was it once or more than once?
It's twice.
Do you recall any dates?
Yes.
What dates would that be?
March the 3rd and March the 8th.
And when you interacted with him, what, if any, impression did you have of him?
And again, Your Honor, I object.
Okay. To
Your
get
Honor, if I
an
may.
impression, she'd have to be declared an expert in what?
I'm not, I'll rephrase my question.
Okay.
what, if anything, did you think of his demeanor when you interacted with him?
Your Honor, I object to what she thought about it, because that would be a
Okay,
clinical
she
assessment.
could describe his demeanor. What was that?
He was concerned about the situation.
That would get into hearsay.
Yes, sir.
So,
She just described his demeanor as concern, Your Honor.
okay, concern. All right, then what's your next question?
And the second time you interacted with him, when would that have been?
She said that already.
Well,
March
just-
8th.
March 8th.
Yes, sir.
And what was his demeanor like when you interacted with him on March 8th?
On March 8th, he was troubled because Ms. Benning,
Yeah, see, you can't get into things he said, and you relied on those to come to that opinion.
Your Honor, I thought she testified that he was troubled, not that he said anything.
If she was about to say that, because of something.
Do you know why he was troubled?
And Your Honor,
That would be based on hearsay from your client. She says he was troubled, so what's your next question?
And were you there to support him?
yes,
And how did you do that?
Your Honor, I object to the relevance of her support.
Your Honor,
Did you counsel him? That's a yes or no.
yes,
Okay, what's your next question?
and as a result of your interaction with him on March 8th, what, if anything, that resulted from that interaction?
Your Honor, I object to that.
Let the lawyers step up.
The defense will call Dr. Melissa Jerry.
Jerry.
Your Honor, at this time, pursuant to previous discussions, state request carry out, because we have no report.
All right, ladies and gentlemen, the jury appeals step down the hallway just briefly.
Testimony out of the presence of the jury for the court to determine whether it will materially assist the jury and basically obtain a hearing.
So you're thinking this particular witness isn't qualified as a toxicologist?
No, it's the substance of what she testified about that we have no knowledge. She just now says about NMS. Well, if we'd had a report, we might know whether to have had a...
Some people don't do reports for tactical reasons.
Yes. And it would appear, since the witness has a notebook with her, that there may be some, there's nothing else, jinx material.
What's all that?
Your Honor, it is my brief notes to prepare for testimony today and the NMS reports that were provided.
Okay. Do they have a right to look at that?
Sure.
How long do you need to do that? See, this just, the jury's back there thinking, I won't say what they're thinking.
Prior to the last trial, when we had this come up, certainly recall that the court said witnesses would be excluded if they did not prepare a report. And here we are now without a report.
I don't know if I said that.
As well as counsel saying that they were only intending to call Eric Devlin.
Well, I don't know who that is. I mean, this person's listed on this witness list.
We have provided the state.
Lena Gill.
We have provided the state a full list of all of our experts and a brief summary of what they are to testify about. The rules and the statute does not require that every expert draft a report. Any notes that Dr. DeGarry may have, I don't have those notes, and they are more than willing to look at whatever notes that she's made in order to assist herself
in this testimony in the same manner Dr. Lethune had to give me notes when she turned over almost 10 pages of notes to me.
Do you have all of your notes pulled out?
They're right here, sir.
Do you want to look at those, the state want to look at those before she testifies?
Yes, Your Honor.
Okay. Run copies of those, Mr. Evans. And of Dr. Bartolome, Dr. Larkin, and Dr. Lindsay. How many of those do you plan on calling?
All of them.
Do they have notes?
I can find out.
Do they have reports?
They do not have reports. All of our experts, Your Honor, reviewed all of the toxicology reports in this case. There were almost 13 toxicology reports in this case that needed to be interpreted. There were litigation packets that went along with those toxicology reports that were out of the purview of counsel's knowledge. We're not scientists, so we had to actually confer with experts in order to understand the science in this case.
Sure.
And so we hired experts to assist us to do that.
Did you have someone get from those other 3 doctors their notes that they would be using to testify?
I certainly can.
And get those to the state?
I certainly can.
All right, go ahead and do that. How long is the state meeting?
Judge, we were very much under the impression, based off of Your Honor's prior rulings in the hearings, that if they did not provide us reports, their experts would not be allowed to testify. We would have had Dr. Mithun stay so that she could be in the courtroom and listen to this, so that we could recall her as a witness. We are without our experts, which is exactly what we said when we asked Your Honor to exclude them if they
I don't
did
think I
not
can
provide a
exclude
report.
them when they don't provide a report. The rules talk about turning over a report discovery if there is one.
You know, the state didn't give us notes of all of their experts.
They got them.
I don't know.
Litigation packet, that is their
You said you had 1,300 pages.
We asked for that litigation packet and paid for it ourselves. The state did not provide it to us. We provided it to them.
Do you want time to get Dr. Carney or anyone else up here?
Judge, our toxicologist is in Pennsylvania.
We never said we
I
wanted.
didn't ask you to say anything. So what do you want me to do? Declare a mistrial? Delay it till next Monday?
Would Your Honor allow us to contact Dr. Mithun and see if she is available to watch it by video so we can at least confer with her after this witness testifies? If she was present today, she would be allowed in the courtroom.
Sure, she can go on, as I'm understanding it, live streaming and watch it.
May I step out to get in touch with her to see if
Sure.
she's available to do that?
All right, get those other notes. We'll be in 15 minute recess. Say,
I never said who I was calling to make sure. I said I had experts today that I was calling. We have not said who we were calling next.
so you want to play the deposition, which is a 50-something minute long.
Yes.
Do you want her to go, so you want me to order them to do that?
Judge, I'm simply asking if we could have a jury out so your honor can make a determination if Dr. Larkin will be allowed to testify, because we just received a report that we have not had. It has an opinion and a conclusion about the cause of death of Jade Benning.
I haven't even seen that, Your Honor. So if she gave him the report, it's not
Wait,
something.
your staff
she gave
said
to me.
they had everything.
That's been emailed. When they said that they emailed that over, that is what they emailed over.
When?
This morning, I mean, this afternoon, I don't even know if it was morning.
She
Let me see
prepared
what
it
you're
for her testimony today.
Is it a report?
Yes.
Yes.
Is it a report?
Let me take a look and I'll let you know.
Okay.
Well, I'd ask the court to make that determination.
Judge, we received
Hang
it.
on a minute. I gotta get the definition of what a report is first.
It is definitely her opinion, so, but this is not something that we've had in the past. This is something that she formulated for her testimony.
When?
I'm assuming, I would have to ask, probably yesterday.
Letter, is it a sheet?
Yes, I'm
Letter
sure it's
F.
yesterday.
See if Dr. Kelly Larkin is out
No, she's not here yet. She is my last witness. So I was under the assumption that I could call my witnesses in the order that I wanted to.
That's normally the case. I was just trying to help do this jury out here while Dr. Carney was here.
She's not here yet.
So let me have that, make a copy of that. Can Dr. Carney come back? Who is Janice Lindsay?
She is a toxicologist.
And who is Dr. Mario Bartolome?
He is a toxicologist medical review officer.
And they're gonna be testifying about, someone said the cause of death?
In regards to Dr. Larkin, yes.
And Dr. Kelly Larkin is what?
She is an ER doctor, a medical doctor.
Not a forensic pathologist?
No.
And you wanna ask her what, you just found that out, what her opinion is today, so what do you want to ask her?
I want to ask.
What is her opinion?
Her opinion is that this was more in line with a fentanyl overdose and what she's seen in the ER as opposed to a cocaine overdose.
Based on levels of fentanyl that are not reported?
No, based on the symptoms that were explained
Symptoms.
and described.
Okay, so back to my question, whether Dr. Carney is available prior to Dr. Larkin testifying, if she does.
Judge, are you asking if she's available tomorrow based on?
No, we're gonna finish today, I'm talking about today.
She will move things to be here.
Okay, all right, well, I guess we've got an hour-long deposition, and where are the few extra text messages that you're wanting to introduce to the public? Do you have a copy of those?
Yes, they're putting it on a thumb drive now.
It's where?
They're putting it on a thumb drive, so.
I'm talking about copies, hard copies that I can look at and see if they're relevant.
We we don't have a printer here, so we would have to go back to
We
the
don't have a
schools
printer
office.
here.
We do, but it's not paper. So we don't have paper here. So we have to go to Ms. Riddle's office. This is
Here,
not
there's
our
just some
office.
paper right there. So
No,
get,
that's not. Thank you.
no, it's just 30. So get those printed out now, delivered in here to me, so I can look at them, so we don't waste more time. So we've got potentially, I don't know, I guess Dr. Carney, she can be available 4 o'clock or something. Okay. And on the deposition, the court reporter made me aware that there's an objection on page 28 about an exhibit, but then there's nothing else. The testimony just goes on without an issue. Is that accurate from the state's perspective?
I've not looked at that in a while. I do remember I objected one time and I don't feel like it was worth rejecting it.
Okay. That was some, have you reviewed some record before your testimony, and then it just went on? So that's, I don't need to make a ruling on that.
It's not my it's my understanding you do not.
Okay.
I don't know if the defense was asking for that.
We're not.
Okay, let the jury step in. Yeah, go ahead.
Just to clarify for Dr. Carney's schedule, Dr. Larkin will be here at 4 o'clock, and we're doing that at 4 o'clock.
I'm just guessing. I don't know how long or how many the text messages will come in with Mr. Devlin. I don't know how long Bartholomew or Lindsay will take. I don't know. Are they here?
They are here. Dr. Larkin is our last witness.
And where is she?
She should be here in 20 minutes or so,
Okay.
maybe by 3. But she's our last witness.
So maybe it's 5 o'clock. I don't know.
Judge, these are the messages they gave me previously, and they say they have 30 more. Just for
Actually, it's not,
reference.
it's probably shorter than that.
Can you get me someone on your
They're bringing it now.
staff to give me what you're trying to introduce through Mr. Devlin? Can they get that?
They're getting it now.
Okay.
Judges, before the jury comes in, with respect to the witness, Dr. San Bartolome, this morning, we discussed notes, anything, information, like we were advised, the court's hearing, that everything has been sent, and at 1:52 this afternoon, we received yet another packet of notes.
So,
Dr. San Bartolome.
once we were finished, yes, they
With
were
your
wrong.
staff
They
wrong.
were wrong.
Let
And
me
once
see
we were
what he's
finished,
got there.
I went and I spoke with all of my experts, and out of abundance of caution, I asked them to turn over everything they had. I was following what the state had been doing. So I
We're
didn't
not
know
worried
that this
about what
was
the
something.
state's been doing. We're here to what you're doing.
Well, I have to follow the leader over here, so. if
No, you have to
they're
follow
doing
the
that to-
rules.
They do too, Your Honor. It should
Well,
not
then
be
let me know
myself.
if you think they haven't. So is this?
I'm sure the court would know that her team had it apparently at 10:03 a.m.
what?
Is that Bartholomew? That's not my witness, so no, I haven't. But I'm sure Mr. Joyner may have.
Bartholomew is not your witness?
No, he's Mr. Joyner's witness.
Okay, I thought you were speaking for everybody. Has anybody to the west side of me, to my right, in a southwesterly direction, including the individual seated at defense counsel table, had this?
Now, I'm not entirely sure what that is, but I did receive the email 1003, which I did.
Why didn't Ms. Hollins know that you were, why didn't you pop up and say, hey, wait a minute, whoa, wait a minute?
I could have, Your Honor. I didn't check my email, unfortunately.
So you didn't get that until when? Now, when did you, I know it was sent 10:03, when did you get it?
I believe whenever we was anticipating breaking for lunch, Your Honor, I double checked my email.
Anticipating, when was that?
We came back at 1:50, so it had been around an hour before that.
Okay, so when Ms. Hollins was saying that's it, and confirmed with Ms. Miller or whoever this young lady is, that that's it, you knew it wasn't?
No, sir. I did not know it was.
Oh, I thought you said you looked at it in anticipation of lunch. Let me see if that. Is the defense anticipating getting into information in this document?
What information specifically are you referencing, Your Honor?
The sensitivity of identifying a woman with a substance abuse use problem is 80 to 88%, and sensitivity is 35 to 37%. I have no idea what that means, but that's what I'm asking about.
It is my understanding that Dr. Mario has treated pregnant women with substance abuse issues. Substance use issues, rather, not abuse, but substance use issues.
So, what does that have to do with this case?
We have a pregnant woman who we believe had substance use issues, Your Honor.
And then he's gonna say what?
He's going to opine as in his professional opinion about whether or not being pregnant is a barrier or an automatic stoppage to a person using substances.
Well, everybody in the nation knows that.
It's not like when it comes from an expert, Your Honor.
Because this goes back to our previous objection to
So you're wanting, hang on, you're wanting this jury to hear from Mr. Dr. Bartholomew that pregnant women should not use drugs, alcohol, or illicit substances.
No, not that, Your Honor. There's been an assertion in the state's case in chief that once Ms. Benning became pregnant, any prior use stopped.
Do you have proof from Dr. Bartholomew that she did?
That she did stop?
No, that she did use.
We believe that she continued to be involved in
Does he know that?
Yes, he's reviewed the records in this case, Your Honor.
What record?
He's reviewed medical records, he's reviewed text messages, he's reviewed...
What medical records show that she was using drugs?
Medical records show the absence of a test while she was pregnant, Your Honor.
Absence of a what?
Testing, drug testing. Actually, there was testimony
Does that mean she used?
No, that does not mean that she used, but she did have cocaine in her system, which suggests that she could have.
Everybody, they're saying she used too much cocaine.
Y'all, but they were silent on alcohol, Your Honor, and there's cocaine in her system.
Yeah, and that can be argued for the jury. So what does Dr. Bartholomew have any information about directly about Ms. Benning's drug usage?
He has direct information that was derived from the text messages in her phone, that was derived from the medical records, specifically regarding the OB/GYN records, where there wasn't any
that. They didn't do it, so that's just a non-issue. What else?
So, Your Honor, it goes, those two things are central to our defensive theory. If the state is wanting to allege
She could have not taken the substance because she was pregnant.
Yeah, she could have taken a substance.
I know, Your Honor, that's not the argument we made.
Does the state agree she could have taken a substance?
In the, anything,
Yes or
there is
no?
no evidence, there's no proof about that, all
Does
of the
the state
contrary.
agree that Ms. Benning could have taken a substance?
And this witness would not materially assist the
Well, the
jury
answer is yes.
in understanding that.
Okay. All right, we'll have a jury out as to whether he has any relevant information and whether this should have been provided to the state.
Your Honor, I just received a text from Mr. Weisman in regards to his witness, Dr. Bucalari. He is asking if it's possible to put this witness on prior to the planning of the deposition. I told him that I would speak with the court. She should be very short. And
That's
so-
up to you. You said it had to be this deposition next.
No, I just didn't want it to be Dr. Larkin for certain, but I can accommodate.
You said
Dr.
you wanted to
Bucalari.
put this deposition
I
on
do.
next.
I do.
So
but I
you
don't
want to
mind
call Dr.
Bucalari.
Brucolari next or the deposition?
I can, if you'll allow, I will let him know that he can bring her over. She's very.
She's
short.
not even here.
No, it seems like he's
Okay,
at.
bring the jury down. We'll play this deposition.
One last thing, do we have anything from Dr. Jancy Lindsay?
We just turned it over.
Is that the notes that you were throwing around?
Those are not even notes. Those are articles that she relies on. It's not Jinx material. It's not anything that we are turning over or trying to admit, but out of an abundance of caution, we turned it over. So you have what we have.
So no notes or no reports?
We gave you notes as well.
It doesn't matter what's been said, it could change.
They're not supposed to be, they are.
But of who? It doesn't say.
They're from Dr. Lindsay. That's what you asked for, that's what you have.
Let the jury step down. Who's the next witness on behalf of the defendant?
The defense calls Alyssa Smith by deposition.
Okay, all right. Ladies and gentlemen of the jury, the witness, by agreement, their deposition was taken since they were unable to be here this week for some reason that the party's aware of that they couldn't be here, so that's going to be played for you, and you can analyze that testimony as you would if the person was here and live and in person. Okay.
Judge, I'm sorry, we had a reporting done of this witness. I don't know. I think this is the.
What did you say?
That's not how we had a deposition recorded, but if it, I don't know.
That's the court reporter's recording.
Correct. We had somebody from our office that came and videotaped it.
Is this not, okay.
I don't know. I haven't seen this, but I'm sure it'll be fine.
Oh, right.
Just for the record, this is the deposition of Alyssa Smith related to State versus Blaise Taylor on Friday, April 17th, 2026. Ms. Smith, could you please state your full name for the record?
Yep, Alyssa Smith.
And could you spell your first name for the court reporter?
Alyssa.
Ms. Smith, where are you employed?
Vanderbilt Lifeline.
And you said Vanderbilt Lifeline, is that correct? Can you explain what is Vanderbilt Lifeline?
We provide pre-hospital care across a bunch of different service lines, from events to flight to ground transports.
And what is your position?
I'm a critical care paramedic.
Can you explain what the critical care paramedic does?
We provide life-saving interventions in a pre-hospital setting.
And that pre-hospital setting, can you describe, are you on an ambulance or some type of vehicle, or where are you normally physically working?
In my current role, I could be positioned on an ambulance, or I can just be in a venue. It just kind of depends on my assignment.
And would you ever sometimes be at Vanderbilt University Medical Center?
Working currently, no. We're not working at the hospital.
And how long have you been in that position at Vanderbilt?
In my current role since fall of 2023.
And prior to fall of 2023, what did you do?
I was working in the ER at Vanderbilt Adult.
And what was your position in Vanderbilt's emergency department?
Paramedic.
And can you describe what was your role in patient care when you were a paramedic in the Vanderbilt emergency department?
We were mostly support for the nurses. Anything that they would need, IVs, medications, we would work traumas, anything that would come in. We were just kind of support for the doctors and nurses there.
Okay. And that position is an EMT position, but it's a position at Vanderbilt Hospital. Is that correct?
Yeah, it's a paramedic position.
And so there are other paramedics that would work for National Fire Department with ambulance services. Is that correct? Okay. And specifically, were you working in that position as an EMT at Vanderbilt Emergency Department in February of 2023?
Yeah, I was working as a paramedic.
And were you working specifically on the night of February 25th, 2023 into the early morning of February 26th?
I was.
And while you were working, were you involved in providing any patient care to patient Jade Benning?
I don't remember.
In preparation for testifying today, did you review records to verify whether or not you were involved in any patient care related to Jade Benning?
Yes.
And were you involved in any way?
Yes.
And specifically, did you ever administer fentanyl to Jade Benning? And did you review records related to whether or not you administered fentanyl to Jade Benning?
Yes.
And in the records, there is an entry from February 25th, 2023 at 23 and 27 hours that indicates that fentanyl was dispensed. Did you review those records?
Yes.
And can you explain, what does it mean when a medication is dispensed?
When we are pulling it from the medication dispensing machine in preparation to either have it on hand to give or to give to the patient.
And did you locate in the records whether or not you actually administered that fentanyl that was dispensed at 23 hours and 27 minutes on February 25th of 2023?
No.
And no, you didn't review the records, or no, it wasn't?
It wasn't administered.
Okay, so it was not administered?
No.
Did the records indicate what happened to that fentanyl that was dispensed?
It was wasted.
And can you explain why would it be wasted, and what does that mean?
Yes, on the note on the document, it states that patient condition changed.
And so that fentanyl specifically was not administered to the patient, is that correct?
That's correct.
If I can have just one moment. Thank you, Ms. Smith. I don't have any other questions.
Ms. Smith, good morning.
Good morning.
My name is Letitia Quinones Hollins, and I'm going to be asking you some questions. If at any time you don't understand anything or you feel like I need to rephrase, please let me know, and I'll do my best, okay? I want to talk to you a little bit about your background. Are you from Nashville?
I'm not.
Oh, where are you from?
Arkansas.
Okay. And what part of Arkansas are you from?
Jonesboro.
When did you come to Nashville? When did you come to Nashville?
Fall of 2021.
Did you come here to school?
Yes.
And what school did you attend?
Nosy College of Art for my bachelor's. I'm sorry. Nosy College of Art.
Nosy?
Nosy.
Spell it for me.
N-O-S-S-I.
Oh, Nosy. College of Art. And you got a degree in photography. Was that your bachelor's? And what did you do after you graduated? What year was it that you graduated?
May of 2025.
Just last year. Congratulations. How old are you?
26.
And so then if you go back to 2023, were you in school then? I just speak a lot, so you can
Sorry.
I'm sorry. Yes. Okay. And what year were you in?
What age was I?
No, what year of college were you in?
Started in fall of 2021.
Okay. And went straight through. When you were doing your studies at Aussie College of Arts, did you get any type of training in any medical training there?
From the college, no.
Okay. And did you get any type of medical training in?
Yes.
And where was that?
Arkansas State University.
Okay. So I'm assuming before you came to Nashville, you were also in school in Jonesboro?
Yes.
At Arkansas?
Yes.
And what were you studying there?
That's where I obtained my EMT basic and my paramedic license.
How long does it take to get EMT?
EMT is typically a semester, paramedic is typically 12 months straight through.
Does the semester that you take for the EMT go towards a year to become a paramedic as well? So they're separate and apart?
Yes.
And so it would be a year and a half that you study in order to become EMT and a certified as well?
Yes.
What is the difference between an EMT and a paramedic?
Scope of practice.
Scope of practice. What is the difference in the scopes?
A paramedic is able to treat and do more, interpret 12 leads, start IVs, administer medications.
Things of that nature?
Yes.
And an EMT is only able to do what?
They're typically the driver, and they're there to support their medic and, anything they can help them do during treatment.
Okay, fair enough. They are not allowed to administer medication?
Tennessee is different with advanced EMTs. I was a basic in Arkansas, so I know they're allowed to do some here. I don't know because I was never an advanced.
Okay, sounds good. So as a paramedic, though, you were able to administer medications?
Yes.
What year did you receive your paramedic certification?
2021.
So right before you came to Nashville to start at Rice?
Yes.
And when you came to Nashville to start at school, I'm assuming you started as a freshman or you had credit already?
I have transfer credits.
Okay. Were you still a freshman?
Yes.
And were you working during that time?
Yes.
Okay. And would that be 2021? And where were you working?
When I first started school, I was at Emerson Ambulance back home, and then I started working at Hobby Lobby for a little bit to take a break.
One of my favorite places. Okay. And what about when you came to Nashville?
That Hobby Lobby was here in Nashville.
Oh, okay. have any employment between Hobby Lobby and Vanderbilt? When did you start at Vanderbilt?
March of 2022.
And what position did you start off at? Paramedic. What department? Would that be emergency?
Yes.
Did you work in any other department at Vanderbilt outside of the emergency department before February 2023?
No.
Okay. So, by the time that you, I'm sorry, by the time it's February the 25th of 2023, you have been at Vanderbilt working as a paramedic in the emergency department for almost a year.
Yes.
Is that fair?
Yes.
And I'm assuming you were going to school during the day?
Yes.
And then working at night?
Yes.
What were your hours during that time?
If it was I started on night shift from 7P to 7A, and I moved to a mid shift from 3P to 3A at some point. I think I was working mid shift by then.
Okay. So 3 p.m. to
3 a.m.
And I'm assuming you guys work 12-hour shifts. How many days per week were you working 12-hour shifts?
3 to 4.
So it's full-time and full-time student.
Yes.
Could you tell us exactly what your title was from March of 2022 to February of 2023?
Paramedic.
And nothing else in between?
No.
Did you hold any supervisory roles or anything of that nature?
The last 2 months that I was employed in the ER, I became a paramedic lead.
Okay.
That's it.
And can you tell me when would the last 2 months be? I know you said
August and September. I left September 24th.
September 24th. So September 2024, that's when you moved to your current position?
2023.
23, yes. Okay. So September of 2023 is when you left the emergency room department and came to your current position?
Yes.
And your current position again is?
Critical care medic for Lifeline.
Is that viewed almost as if it's a promotion, if you will? Or it's just like a lateral move?
Lateral transfer.
Okay. In your position as a paramedic in the emergency department back in 2023, February, tell us exactly what your average day responsibilities would be.
So I would come to work, clock in, check off all of our equipment throughout the department, look at the board, see what patients we had, get off-going shift report from off-going paramedics, and just help wherever the nurses need me and whatever I was told to do.
When you say check equipment, what type of equipment are we talking about?
Our crash carts, our trauma equipment, all of our cabinets, all of our carts, make sure everything's stocked for the shift.
Okay. And is medication in any of these cabinets or no? So what would be in your carts and cabinets and things of that nature?
IV supplies, like bandaging things, basic things.
Almost like support supplies for the nurses and things of that nature. Okay. So you would come to work, you check the equipment, see what patients are there in the emergency room, and then I'm assuming you then wait for someone to give you instruction as to where they would need your support.
Yes.
Who would primarily be the people who would come to you and ask you for support? Would it be the nurses, doctors?
Yes.
Both?
Yes.
Okay. Was there a particular doctor and or nurse that anyone was assigned to?
No.
It could be anyone.
Yes.
How many, if you know, how many nurses would you say would be on duty at any given time in Vanderbilt's emergency back then?
I do not know.
You know how many patients the emergency room department, in terms of rooms, how many rooms of patients do you guys
have an exact number. I know we go up to 38, like physical rooms.
38.
But it could be more, not 100%.
Yeah, I've seen sometimes with the patients in hallways. Who would have been your supervisor back then?
As our paramedic supervisor, it would have been Eric Frank.
Eric Frank? Did you guys have more than one supervisor?
For paramedics, no, he was our overall paramedic lead.
So outside of Mr. Frank, everyone was in the same role and position?
Yes.
Were you supervised directly by any doctors and or nurses?
No.
And so you, on February 25th of 2023, I'm assuming based on your prior answer, the only reason you remember that you were working that particular day is because you checked the records.
Yes.
And that makes sense, right? It was 3 years ago. You're saying that you were on duty there from 3 p.m. to 3 a.m. during that time?
I believe if it was my normal shift, then yes. I don't know exactly what my shift was.
And do you remember at all Ms. Benning coming to the emergency department on that evening?
I do not.
Do you remember which nurse and or doctor that you were working with on that day?
I do not.
Do you remember whether or not during that time that there were more than 38 patients, or it was pretty hectic during that time, or if it was just a normal call day? Do you remember anything like that?
I do not.
I should probably just ask you this. Do you remember anything about that day?
I do not.
And trust me, it's fair. That was 3 years ago, so that's fair. Okay. During your position and your daily duties at the emergency department, do you ever have interaction with family members or things of that nature?
Yes.
And what type of interactions would you have with individual patients, family members, and things of that nature?
If they're in the room treatment plan of what we're doing and what's going on and everything.
Would you be the individual that communicates that treatment plan to the family members?
It's typically the MDs, but if we come in and we start doing something, that's when I would explain what was going on.
And when you say that you would explain what was going on, you would explain what?
Like, hey, I'm about to start an IV.
Okay.
Typical things.
Not what the doctors are going to do, just this is what I'm going to do.
Correct.
Now, do you have any authority to, on your own, determine what type of medication a patient should receive?
Not in the ER.
Not in the ER, okay? Do you have, on your own, any type of authority as it relates to any type of treatment, not medication, but an IV and or a bandage or anything like that? Can you assess a patient on your own and say, this patient needs an IV or this patient needs a bandage?
I have to obtain orders from the doctor.
I'm sorry?
I have to obtain orders from the doctor.
From the doctor. Can you obtain those type of orders from a nurse?
Yeah.
Only a doctor.
Yes.
And so when you looked at the records for Ms. Benning back on February 25th of 2023, I'm assuming you noticed, like we all, that you had pulled some medication that day. And you said before that you dispensed medication.
Yes.
Tell us again exactly what dispense means in the EMT emergency room department world.
Pulling it from the machine that stocks it, that hat where it's stored. Just pulling it out of the machine.
Okay. And so if anyone is like me, what do you mean pulling it out of the machine? What does that mean?
We go in, type in the patient's name, type what medicine we need, and like pull it out of the machine, and we have the medication now.
Okay. So I'm assuming then there's some type of machine that houses medication.
Yes.
machine, does it house all medications or only controlled substances or things of that nature?
It houses all medications. It's not only controlled substances.
Okay. And so if you are dispensing, which we now know the EMT emergency room department world means pulling it out from the machine that houses the medication for the emergency department, we can assume, can we not, that a doctor, because you said you cannot take orders from a nurse, right? That a doctor had to have told you to do so.
Correct.
Because you otherwise would not get medication out of it.
Correct.
What credentials must you put in order to obtain those medications?
The patient's name and the first 5 letters of the medication you're trying to access.
Do you have to give any identifying information from you?
Yes.
Okay. Tell us what that is.
It's our login, our ID, and our password.
Anything else besides your ID, your password, the name of the first 5 letters of the name of the patient, and the actual medicine?
It's the first 5 letters of the medication and the name of the full name of the patient.
Do you have to give the patient's date of birth?
No.
No. Do you have to put anything in there as it relates to the doctor who gave you the authority? And so we see that on February 25th of 2023 at 23:27, which is 11:27 p.m.
Yes.
That you first pulled midazolam.
Yes.
What is midazolam?
Another name for it is Versed, and it's just a sedative.
A sedative, and it means that it does what to a patient?
It calms them down. We give it for seizures a lot. It just kind of relaxes their muscles.
Okay. Does it put them to sleep?
Patient dependent.
Okay, so it can make you drowsy, but it's not an agent that puts you under.
It can't. It depends on the patient. Everyone handles meds differently.
Okay.
So it depends on the patient.
Well, let me ask you this. If someone wanted to cause someone to go into an unconscious state, would they use midazolam in that type of arena to make that happen?
Yes.
And then we also saw that you also pulled fentanyl.
Yes.
What is fentanyl?
It is a pain medication.
Is it also used as a sedative?
No.
It is solely for pain.
Yes.
So one can assume then that if you are administering pain medication to a patient, then that patient had to have been in some sort of pain.
Yes.
And how would you know a patient is in pain?
They will tell us.
I noticed, if I could, you reviewed your records when you
Yes.
prepared for today.
Yes.
I want to show you what I'm going to mark as the data's I'm going to mark it once they get that's Appendix Exhibit 1. Take a look at Appendix Exhibit number One, have you ever seen that document?
Yes.
Okay. When did you see that document?
A strip of only what I had done under my name was emailed to me.
Okay. Who was it emailed to you by?
That I do not know.
Do you, what email would they have emailed it to you?
My work email.
Your parent work email?
Yes.
Are you able to go back and take a look and see who emailed that document to you?
I don't have the ability on my phone.
Not now, but at some point.
Yes.
Okay. Do you remember when it was emailed to you?
No.
Was it this year?
Yes.
Was it in preparation for your testimony today?
Yes.
And you just don't remember who it was? No. Who have you been in contact with in preparation for your testimony today?
My lawyer.
Who is your lawyer?
Anthony Bills.
Have you been in contact with anyone else?
No. I got the subpoena emailed to me and that was it.
So then the only person that you've been in contact with as it relates to your testimony here today was your attorney?
Yes.
In these records, you notice that your name was present.
Yes.
Do you also notice where it states ABS override pool?
Yes.
What does that mean?
It means if we have a patient coming in or a patient that needs emergency medication right in that moment, we can go in and override and just pull the medication that we need as to a doctor.
Okay. Why would you need to override it?
Because they don't have time to go in and put the orders in the computer. Because it's an emergent situation and something's happening that we need those medications.
Okay, so is there another protocol for or dispensing, medication outside of this ABS override that would not require any override?
No.
So in every instance that you want medication, you have to do an ABS override?
Oh, no.
Okay. So what would you do if it wasn't an override, I should say?
The orders would be put in by the physician and we would go in and be able to pull them.
Okay, so then what you're saying is that the normal protocol is that a doctor would put in orders for medication.
Yes.
And it is because of those orders that you can then go to the machine that houses the medication. Does that machine have a name, by the way?
The Omnicell.
Omnicell? O-M-N-I? S or C-E-L-S?
Yes.
So, in a normal procedure or protocol, doctors put in orders into a system. That system somehow communicates to the Omnicell.
Yes.
And allows for you to go in and then put in the patient's name, the first 5 letters of the medication, your ID and password, and the medication is dispensed.
Yes.
But in this instance for Ms. Benning, there were no orders in the system.
Yes.
For the Omnicell to recognize.
Yes.
Because of the emergency situation.
Yes.
And so because of that, you implemented the ABS override pool.
Yes.
Okay. And what exactly is the override pool? What do you have to do there?
We hit, it's a button, medication override, and the reason, emergency, whatever the reason is for needing it overridden, so that it's all documented.
In that situation, what would the reason have been, if you know?
I don't know the exact reason.
Okay. Would it have been communicated to you?
Yes.
Okay. Who would have communicated that to you?
The pharmacist or the doctor.
Okay. Is it required for you to put in that reason every time you do an ABS override?
Yes.
Without that, you cannot administer it. I'm sorry, dispense it.
Correct.
Okay. And so then we can assume that when you did this ADS override pool, there was a reason stated as to why you were able to do that.
Yes.
When you put that reason into the system, are you also inputting the individual who communicated the reason to you?
No.
Just only the reason?
Yes.
Okay. How many doctors would you say are on duty at any given time during the 3 p.m. to 3 a.m. shift?
I don't have an exact number.
Would it be more than one?
Yes.
Okay. More than 5?
Yes.
More than 10?
I don't believe so.
Okay. So somewhere between 5 and 10. Yeah. Who would tell you the dosage of the medication?
The doctor.
When the doctor is communicating this information to you in this emergency situation where the orders are not put into the system, are you taking notes or are you just memorizing?
When we pull the medication from the Omnicell, it is the whole vial. So we go and pull the medication, we come back to the doctor and verify the dose before giving it.
Okay. So when the doctor is communicating to you before you go to the Omnicell, you're not taking notes or anything at that time, you're just remembering as you go.
The medication, yes. All I need to know is the medication.
Okay. So because we see in these records that there was a fentanyl pool, there was a midazolam pool, and an override situation, then we can, based on what you just testified here today, assume that there was a doctor who communicated this information to you in terms of what the patient needed.
Yes.
Now, when you dispense the medication, who administers the medication? Meaning, who gives the patient this medication?
Either myself or a nurse.
Not the doctor?
Typically, no.
Okay. And how is fentanyl and midazolam administered to a patient?
Through an IV.
And just so that we're clear for the sake of the jury, when we're dispensing medication in this setting, that means you're taking it from the Omnicell. When you're administering medication in this setting, you're actually giving it to the patient.
That is correct.
And so, at some point, based on your testimony, it was determined that this medication would not be given to this day, correct?
Correct.
Okay. Now, who would have told you that? So someone had to have told you to get the medication, dispense it. Who would have told you not to administer it?
The doctor.
The same person?
Yes.
Is there anyone else who could have given you the authority not to administer that medication?
Yes.
Who?
Another doctor.
Okay, but it had to be a doctor?
Yes.
Okay. Not the RN?
No.
Or a nurse practitioner? And again, as these doctors are communicating to you, you're not taking notes or anything, you're just on the spot, you're moving.
Yes.
So, it is now determined that you did not administer, the doctor based on the records, made the determination that you're not going to administer these medications to the doctor. What do you do with those medications?
They are wasted.
Are they wasted immediately?
Yes.
And how are they wasted?
We have a system in the Omnicell where we go in and waste it with a witness, and then they are disposed of. And it's called a cactus. It's a drug disposal thing that we sort the medication into.
Okay. Is that in the Omnicell as well?
It's beside it, yes.
Right beside it. Is it a separate machine?
Yes.
Okay. And does it require any information on your part in order for you to dispose of the medication into that machine?
Yes.
And what is that machine called?
It's not a machine, it's just a waste receptacle.
Oh, it's just a waste receptacle.
Yes.
Is that those red things you see to the receptacle?
Yes.
What do you do with the syringes?
Throw them away.
In the trash or something? Is there a special place for you to dispose of the syringes?
Yes, we have trash cans and biohazard trash.
Okay. When you dispose of the medication and you're inputting it into the 90 cell, are you also putting the reason that you're disposing?
Yes.
And where are you getting that reason from?
The doctors.
Are you having to list the doctor's name that told you that? And you stated, I think you said something about the patient changed, and that's how you knew that you disposed of it. How did you know that you disposed of that medication? For Ms. Benning particularly?
Yes, in the report, it states that I wasted it, and under the reason it states patient condition changed.
Okay. And what report are you speaking to in that regard?
It's a continuation of this report.
Okay. A continuation, you mean medical records?
No, it's all of them. It's in the medication report.
Okay. On the document Defendant's Exhibit 1 that's in front of you, is that information on this sheet? So there's another document somewhere that states that?
Yes.
But it's not a DUNC medical record?
Yes, it is.
Would your name be attached to that as well?
Yes.
Have you seen that document?
Yes.
When did you see that document?
It's the same one I was referring to, or I don't know when it was sent to me.
I'm sorry.
That's the one that was emailed to me. I'm not sure exactly when I received it.
In addition to Defendant's Exhibit 1?
I only received a strip that showed my name and like what I did. I didn't receive anyone else's name. It just showed my name and my involvement.
Okay. And that, was it a screenshot of the document?
Yes.
So then it would have been attached to an email?
Yes.
Not the email itself. And what I mean by that is, you know, sometimes you'll receive an email and there's a screenshot within the email.
Yes.
As opposed to an actual document that you have to click on and download to review.
Yes. I believe it was just in the email.
In the email itself. And just so we're clear, because I don't want to confuse that, what you received is different than Defendant's Exhibit 1.
Yes, it's less information. It is only it has these two parts on here and only what I was involved in. It doesn't have, it's not the full of all the other medications. It's only what I was involved with.
Thank you. And in Defendant's Exhibit 1, is it fair to say that Defendant's Exhibit 1 would be, if you look at just the two strips of where you were involved, would it be fair to say that the information you received is different than what's in those strips shown on Defendant's Exhibit 1 because it doesn't show where the medication was wasted?
Correct.
Because in Defendant's Exhibit 1, we don't see that, right?
Correct.
When we see the statement, "Do not tube must always be secured," what does that mean? If you know.
Oh, is that on here?
Yes, ma'am. For the record, what she says is that on here, she's looking at Defendant's Exhibit 1.
on the, oh, there it is. I believe it's referring to not, you can't send it through the tube system in the hospital like we send labs, because it's a controlled substance, so we can't just send it through the hospital. If we were, for some, we would never have a reason to do that, but that's all that means.
Okay.
Is do not put it in the tube system.
Let's keep those separate and secure.
Yes.
When we see the status as active, what does that mean? On the right-hand side.
I do not know.
When you look at it, it says ordering mode standard. What does that mean?
I also do not know.
You see there where it says at the bottom, package, and then it gives a number. Specifically under fentanyl, it says package 0409-9094-12. Do you know what that number pertains to? Fair enough. And finally, when you see frequency from 225.23 and 23.27 until discontinued, what does that mean to you, if anything?
I guess to me that's until they decide that we don't need it anymore, or until they discontinue the order.
Okay, and when you say they, you're speaking about the doctors?
Correct.
And to be clear, you would have nothing to do with the decision to administer these medications?
Correct.
Yes, okay. And you would have nothing to do with the amount of medication that is determined that needs to be administered?
Correct.
When you, and if you know the answer to this question, you can answer it if you don't. When you see fentanyl, well, let me back up. If someone was coming in for a potential overdose for any type of drug, would you expect to see fentanyl administered? If you know the answer, if you don't, that's fine.
I do not know the answer to that.
And reason being, because you're not the one who made those determinations, right? So that was an unfair question, I apologize. But what we can say is that we know for certain, based on the records you reviewed, that at 23:27 on February 25th of 2023, although it states that fentanyl was dispensed, you did not, and anyone to your knowledge, administer fentanyl to Ms. Jade Benning.
That is correct.
And I'm gonna get months. So, Ms. Smith, we're going to, I'm done at this time, but, and this is beyond your purview, but I want to set it on the record. We would like for you to grab that document, that medical record, where it states that you actually disposed of it, so that we can at some point talk to you again about it. And we'll work with the prosecution to that regard, okay? But we do want you to look. Okay. All right, at this time, I'll pass it to us. And for the record, I would just like to state that we're not done necessarily with this witness until we deal with the issue of this record we have not seen.
Okay, here, Judge. Who's the next witness?
Dr. Brooklyn.
in the medical records, but you mentioned it during the deposition. Do you want this marked as a separate exhibit?
Yes, please.
All right, release 60.
Your Honor, I would just renew my request that Dr. Larry not be asked about any testing that's not admitted as evidence as an exhibit.
Okay, I would have said step up.
Do you swear the testimony you're about to give to be the truth, so help you God?
Yes.
Okay.
Good afternoon, Dr. Bruckeleri. How are you?
I'm doing all right.
Bruckeleri, I'm sorry. Can you please state your name and spell it for the record?
Sure, it's Dr. Rebecca Bruckeleri, R-E-B-E-C-C-A, B-R-U-C-C-O-L-E-R-I.
And how are you employed, Dr. Bruckeleri?
I am employed by Vanderbilt University Medical Center as the medical director of the Tennessee Poison Center and a medical toxicologist.
And how long have you been employed with Vanderbilt?
Since October 2018.
And I want to ask you a question in regards to the treatment of Jade Benning. Are you familiar with the patient at Vanderbilt by the name of Jade Benning?
Yes.
And do you remember about the time that she was being treated at Vanderbilt?
Yes.
Was there an occasion where you were involved with her treatment?
Yes.
Can you explain to the jury exactly what your involvement was?
Yes. I was called shortly after she was admitted to the ICU to assist in drug testing because there was concern that Ms. Benning had been poisoned.
And do you remember about the time that she was admitted to the hospital?
She was admitted at about 9 to 10 p.m. on February 25th, 2023.
And who contacted you? Well, let me ask you this. What is your role there at Vanderbilt directly?
I provide inpatient and outpatient medical toxicology consults.
Okay. What exactly does that mean?
So I can provide advice on toxicologic cases, so whether or not someone's been poisoned, intentional overdoses, unintentional overdoses, adverse medication reactions, and envenomations.
And you just stated something about unintentional overdoses. Is that what you stated?
Yes.
Okay. Can you explain to the jury what exactly that means?
So a prime example of an unintentional overdose is if a small child finds a pill on the ground that one of their caregivers has left and ingested it, and the management of that.
And so what would your involvement be in a case like that?
So I would provide advice on how to treat the poisoning. It could be a myriad of drugs that could be one, but for example, something like a blood pressure medication could be ingested by a small child, and then I would provide treatment recommendations to the team on how to manage that.
When you were notified, or let me ask you a better question, do you remember the exact day you were notified in regards to Jade Benning's treatment?
Yes.
And who contacted
The ICU team.
you? And for what purpose were they calling you in specifically as it relates to Jade Benning?
They wanted help with extended drug testing.
And what type of service did you provide?
I provided advice on extended drug testing.
did you have an occasion to pull urine for or from Ms. Benning? Meaning, did you order a urine analysis or a drug test, drug screen?
I did help with drug testing.
Okay. And do you remember what day that was?
So I assisted in ordering, I don't remember the exact date and time for each time that I called the lab, but I assisted on add-on testing for urine that was already in the lab. And then at the end of her hospital stay, I helped order arsenic testing.
I want to draw your attention as to whether or not, well, let me ask a better question. Once that you order testing, where do you send your testing to? Meaning, where do you go, what lab do you utilize for your testing?
So for the add-on testing, there were 2 labs that I had advised or helped with ordering for. That was MMS Labs and Arup Labs. And then for the arsenic testing, that went to Arup Labs.
And I would like to show you what has been marked now as, well, I'd like to show you an exhibit, please.
What are you referencing?
No, I want to show you my exhibit that I'm handing her. It's not offering to evidence.
Your Honor, Dr. Bergolieri cannot authenticate documents, but it's very specific. She needs to be called about what's already been introduced.
That's what I meant. You said it was an exhibit. What number?
No, it's not an exhibit that's already been introduced. She's a witness. I don't understand why I can't give her a document, and if she can authenticate it, why am I not allowed to enter it into evidence?
Let the jury step down the hallway. Is this something, General Norman, you referenced before this witness was called?
Yes, Your Honor, it's exactly what I referenced before this witness was called.
And what, I don't know, what tests are you talking about that haven't been made exhibits?
I'm sorry, I thought you were asking me.
No.
Your Honor, work order 23078883, which is what this is about, it was not introduced as an exhibit. Dr. Mithun we did not submit it. Dr. Mithun did not testify about it.
What is it?
It is a urine test on a urine that was collected on 2/26/26 at 0922. We did not submit that lab test through Dr. Mithun. This is part of the NMS lit pack. Dr. Mithun is not here to testify about any of the test
Well,
results.
I don't know. I guess my question, why wasn't it admitted?
I'm sorry?
Why wasn't it asked about?
If we purposely did not ask about it because there was confusion about the date. And that was the limited testimony of Dr. Mithun, is that we showed that the work order was not the same as the one before, that there was one urine sample from that 2/25/23 at 22:59. It was a completely different sample, and that is what was sent to CFSRE. We have had no testimony
And this
about.
one deals with what? Which one?
Deals with, that's the thing, it's not in evidence. It's a
Which?
secondary urine sample.
2/26/1335 or 2/27/23 at 4 o'clock?
No, it's neither, I'm saying it's not either one of those. This has not been
That's only
submitted.
3 I've seen or heard reference to in the medical.
Correct. There has not been testimony related to this, other than to point out that the work order was different, and she knew for certain that the sample transferred to CFSRE was from 225, 23, and 2259.
What are you wanting to ask this witness, Ms. Thomas?
Specifically, I would like to address two things with this witness. There is in fact an email between this witness and Dr. Bethune in regards to a sample, a designer opioid screen from 225-23 at 2259. In this email,
That's been testified about.
I'm sorry?
There have been references to that.
Yes, and there's been an issue as to whether or not that urine screen was in fact on 226 or 225. I have an email in front of me from Dr. Brucaleri where she references a sample from 225-23 at 2259. That date is extremely important to the defense because
That's 225, 23, 2259 is not an issue.
it is an issue on our side, Your Honor.
That's,
Your Honor, you
is
can
that
make,
the urine screen you're concerned about, John Moore? 225, 23, and 2259?
That 225, 23, and 2259 is a completely separate work order, and that is in evidence, and she's more than welcome to ask about that. She is trying to ask about this other urine sample that we've had no testimony about. It was not admitted as evidence in any way, shape, or form.
Then I guess I need to go back to Ms. Holland. You've not told me anything that the state's objecting to, so what else are you wanting to ask this witness?
in addition to that, I would like to offer, there is a test from CSFRE where there is coca-ethylene that was found in the urine of Ms. Benning,
That's been testified about.
not by this witness.
Okay, maybe you're jumping the gun, I don't know. She's apparently not asking about any other urine screen.
Judge, this email is about a urine screen that is not in evidence at all. NMS has not testified to it.
So that doesn't make,
Dr.
that doesn't
Larry
matter
cannot
to you, don't you?
authenticate anything about the results of this test because we would have to have the NMS toxicologist
There's
testify
not been
about it.
testimony about you're saying the only testimony about coca-ethylene was from a blood test.
No, no, Judge, I'm talking about the emails and the first test that she wants to ask about.
There's been testimony about coca-ethylene, right?
Okay, so we're talking about a separate issue.
Coming from where?
Judge, which CFSRE report are you referring to?
2023-0090.
I have no objection to her asking
That's
about.
what I said. It sounded like we were jumping the gun.
I was going back to the original because you referenced a urine screen, and
She was talking about a urine screen.
so she's not going to be allowed to.
Show Ms. Holland the group of things that you're holding there when you're talking about objecting, and see if she has any plans of going into that.
I got one of these work orders, I am objecting.
Yeah, I didn't realize that my evidence was confined to what the state offered it to
Well,
evidence.
you would have to be, there would have to be a foundation for it. Who did it? And you wonder what, so what is your answer to her question?
I'm not trying to offer those test results.
She's not
I
trying
am
to offer.
speaking to this email written by this witness referencing a urine sample from 225-23. The purpose of that,
Is that an issue?
it is to.
I'm not asking you.
Oh, I'm sorry.
It is if she is going to get into the lab.
She just said she wasn't.
Judge,
Is that accurate?
That is correct.
All righty.
And in terms of, I am wanting to get into the results of the coca-ethylene found in the CSFRE.
In what, one of those work order numbers?
This work order
Well, the
is.
one she just showed you on her file there.
No, it's not.
On the manila file, you had two.
this work order that's, the email is about, is this work order that is not in evidence.
that accurate?
I'm not trying to enter those results, Your
Oh.
Honor. I am trying to simply enter an email from this witness referencing a
Show
date.
this witness that email and she can clear up what work order it's about.
This is the- And I included.
Hang on. Is all of that information you're looking at, Doctor, concerning 225, 23, 22, 59 Uri Street?
So, as best to my memory, it is not. This is in reference to a different specimen number. So at the time this was done, which was April 6, 2023, there was some differences in lab collection dates and times to what was matched in the EPIC record. I am pretty sure this is referencing the lab that was actually done at 2/26, 2023 at 9:22 a.m. And this specimen did not ever go to CFSRE because it went back to the crime lab. So
Okay.
this is
What
not.
about what you're wanting to ask about?
So I'm not interested in getting in the results of that test. I am simply interested.
She's saying this email applies to a total another work order that wasn't sent in MS.
Again, I am not trying to enter into evidence any results from any test. I
Then
am
why would you
simply-
want an email about a test that wasn't tested?
Because there's a date on there that is very important to
Ask her
my
what you
client's
wanted to
case.
ask.
Thank you. Is there a date that you are referencing in your email, Dr. Brooklyn?
Yes, and I am saying at that time, it was incorrect, because when you backtrace this work order to the specimen ID into the EPIC medical record, it is a different date and time, which was not discovered until after this email was sent.
And that's fine. I just want to reference the actual date that you have in that email. Back on April, I believe it's the 6th of 2023.
The date that I have is 2/25/23 at 22:59.
Thank you. That's all I needed. And then,
She's saying that's not accurate.
I understand.
So you're
The
entitled to
state,
introduce relevant evidence, not evidence that's not relevant.
the state has made it an issue that that date is not accurate. They have made that
So
an
that
issue.
date's accurate.
May I finish, Your Honor?
You're saying the state's saying 2/25/23 and 22:59 is not accurate?
That is correct. They have stated that in their
No,
case
they're
in
not
chief.
stating that. That's accurate. But you're asking about another work order that's not been testified to in the record, so how do we know what the results were?
I'm not trying to get into the results.
But you're
of
wanting
that
an email
test.
to confuse the jury about what's going on here, right?
Sir, I'm not.
Okay, well, I'm not allowed this email, so is
Fair
anything
enough.
else?
That's fine.
All right, let the jury step
I'm
up there.
I'm not done. I
Okay.
have another test. As
Okay.
I stated, there is another work order that Dr. Brucaleri is aware of where Ms. Benning tested positive for cocaethylene. I simply want her to have the opportunity to testify about that because
What
it
work
goes to
order
my
is that?
clients. It is work order number 2023-0090.
Was that tested
Yes, it was.
by Vanderbilt?
Yes, it was tested by Vanderbilt, but what's in question is what went to CSFRE, which is.
What?
It went to the Center for Forensic Research and Education.
But your hospital tested it and it showed what?
So it went to NMS Lab. So our hospital drew it, sent it to NMS
The
Lab.
hospital didn't test it.
Our hospital sent it for extended drug screening to NMS. I do not.
Vanderbilt Hospital test what she's asking about.
Could you repeat the question, Your Honor?
Did Vanderbilt Hospital test what this lawyer is asking about?
I don't know if they ran tests on that sample themselves.
She has personal knowledge that Ms. Benning tested positive for cocaethylene.
Is that accurate?
Yes.
From what source?
That's from the Center for Forensic Research and Education.
She didn't do the testing.
But she has personal knowledge.
Did
And
we
she's
hear
a,
that?
she's a toxicologist, Your Honor. And she's treated Jade
But
Benning.
you want everything to be reliable, right?
No, what I would like is
You
for
don't want
this,
everything to be reliable.
may I finish, sir, please?
Just answer my question.
I
You
would-
want all the test results to be reliable.
I would love for that.
Okay.
But
Well,
that's
we
not
don't
the
have the
case.
people that did this test. Did you subpoena them?
I don't need the people to be
Well, then
that
she
test.
can't testify about the results of someone else's test.
She can testify about her personal knowledge
She
because
doesn't have personal knowledge.
she just told you she did.
It's from another testing agency.
It doesn't matter. She got,
Okay, well, I
you
think
can make
it's
your
done.
ruling, Your Honor, and that's
I
fine.
ruled, so that's out. So
And what is your
else do you
ruling?
want? I just said it's out.
Thank
What
you.
else do you want to ask her?
There's nothing else.
Okay, let the jury step down.
Can I get my test back, please?
Sure. Subpoena somebody from the lab.
My questions have already been answered.
Okay. Do we need questions from this staff?
No, Your Honor.
All right, thank you. We get step down. Let's move with the next witness.
The defense calls, Eric Devlin.
All right, well, yeah, get here, somebody. Let the lawyers.
Okay, so while the lawyers are approaching, this is so wild. Oh yeah, he should be worried. He should be shaking in his boots now. Cause certain stuff that they trying to get in, yeah, look over there at mama and daddy. Yeah, y'all better try to figure this out. They better get to a plan B. Oh my gosh, Letitia, like do they not go through what evidence can come in? And I know what she was trying to do, but the judge wanted to pull one of those moves. Well, he did pull one of those moves like, oh, you want everything to be tested and tested correctly. When the state was bringing in their witnesses, they had a big fight about that vial of blood and the chain of custody and who's going to testify that they drew the blood from Jade. So the judge then flipped it back on them and said just that to her, like, oh, so you need to bring somebody in from the testing company to say they tested it because she didn't test it. And it doesn't matter if she has personal knowledge of it or not. I don't give a F. Nope. He don't care. So he just kind of like slapped her with her same thing. But God, what is that? A whole witness that backfired. They are not getting in what they want to get in. And basically what they are trying to continue to point out is that procedures were not followed. The house was contaminated as far as the scene. Nobody told anybody to go into the house. That's why the officer was called this morning. The paramedic that got on the stand, the reason why she was here today is the state didn't call her, but specifically in her testimony, in her deposition, she said, look, we did not administer any Fetty Wap. So now we have the doctor that's on the stand, and they didn't pull some urine on some date in February that wasn't tested. I have no clue why it wasn't tested, why they didn't bring it in. The state said they didn't bring it in because of the conflict of the dates. But here we go. You talking about a bitter fight to the end, like they all tired of each other, and I'm here for it. Go ahead, entertain me. It's better than a boring trial. Let the lawyer step up again. The judge say, I rude. And my little prosecutor attorney, she is not backing down from none of this stuff. And y'all be careful, because when Mr. Ben prosecutors jump up, I ain't figured out his name just yet, but when he jump up, he know what he talk about for real, for real. Yeah, it's like they trying to... I mean, the judge is there to make sure that they're not misleading the jury or confusing the jury, but it's so many. I don't know about y'all, but I'm so unclear on all this testing, how it was tested, what was in the test. Like, I am really unclear about it. I hope the jury, and I don't think they can even pay attention to this mess. Like, I don't even know if they clear about it. I'm telling you guys, like, regardless of what we may think over here in this chat, it's other chats that I go into, because I be out here on these YouTube streets and I be tricking out here. But when I be out here on these YouTube streets and in other chats, a lot of other people think that he is so... No, I ain't gonna say not guilty, that there's reasonable doubt. Like a lot of reasonable doubt. Like not just a little bit of reasonable doubt, a lot of reasonable doubt. Gosh, she gonna need a hot bath with some Calgon so it can take her away after this trial. and a drink, a margarita. She might need to get some of that lean green and hit that once or twice. You know that Calgon is for us real people up here in this chat. I remember those commercials. I was like, I don't think that stuff work. And y'all know how short he is? God, he is so short. He is shorter than Letitia. Blaise, Blair, whatever you want to call him. Like, he is shorter than his attorney. I'm like, well, maybe she got on heels. She probably got on her red bottoms, baby. But he is shorter than his attorney. I'm like, ugh, okay.
I do.
The attorney's going to ask you just some, I don't know about brief, but some questions in terms of the bottom line issue they're wanting to call you, okay?
Yes.
Outside the presence of the jury. Okay.
Good afternoon.
Good afternoon.
Can you please state and spell your name for the record?
Mario San Bartolome, M-A-R-I-O. Last name is S-A-N-B-A-R-T-O-L-O-M-E.
And what do you do for a living?
I'm an addiction medicine specialist and family physician.
And can you tell this court a little bit about your education?
Sure. I'm double board certified in family medicine and also in addiction medicine. I'm also a medical review officer, which is the individual that is involved with drug toxicologies as it relates to substances of abuse. And I currently work as an addiction medicine specialist at a community clinic overseeing a treatment and any sort of substance use related things at a federally qualified health center.
And can you tell us a little bit about your education?
Yes, I went to UC Davis for undergrad and then went to medical school at UC Irvine, followed by residency training at Long Beach Memorial, and then pretty much started practice right around that time.
And have you published any articles?
I have not.
Have you dealt with or worked at addiction treatment centers?
Yes, I have.
How many?
Approximately, I'd say 5 or 6. I've been a medical director for every level of what we consider to be along the continuum for addiction treatment. So inpatient, hospital-based detox, inpatient rehab, outpatient, intensive outpatient, and partial hospitalization programs.
And what, if any, other specialized skills and trainings you may have?
Primarily just the added medical review officer, I think, to the addiction medicine board certification.
And do you have any experience treating patients with addiction?
Yes, I do.
Do you have any experience treating pregnant women with addictions?
Yes, I do.
One second. Do you have any experience in dealing with and or diagnosing substance use disorders?
Yes, I do.
And what would some of those be?
The substances? Is that the question?
Yes.
Oh.
methamphetamine, cocaine, opioids, alcohol use, cannabinoids, pretty much any substance of abuse, hallucinogens, inhalants.
And what is substance use disorder?
Well, a substance use disorder is a diagnosis that's related to a chronic illness that we call a substance use disorder based off of the substance, the primary substance. And it involves biological, psychological aspects that are typically defined by somebody continuing to do things despite negative consequences.
And have you ever testified before as an expert, as a medical review officer and a addiction specialist?
Yes, I have.
No further questions at this time, no. Okay. I would ask that he be tendered as an expert in, as a medical review officer, as well as a addiction medicine specialist.
The state's not so much concerned with his qualifications, but with the relevance.
What are you wanting him to opine for this jury?
I want him to opine for this.
Go ahead and ask.
Oh, okay. Dr. Morio, in your experience, is pregnancy a automatic stoppage to substance use?
No.
Why not?
Well, because even though it is definitely a well-studied external motivator, in other words, if somebody is in the process of using substances and finds that they're pregnant, it is something that is associated with a higher likelihood of having motivation to stop using. But by itself, it's not something that's a guaranteed that somebody would stop using any substances.
And what is addiction medicine trying to understand?
Well, addiction medicine really deals with judgment. It deals with physiologic changes that drive somebody to have impulsivity, to have the kind of behaviors that can be harmful to them. And despite those things, there's changes in the brain that cause them to continue the behaviors that hurt them. So a lot of it has to do with judgment, and a lot of it has to do with how substances interface.
Can self-reporting in clinical settings, what is your opinion about self-reporting in clinical settings?
Well, it definitely is very valuable. That's what we base all of our screens with. People self-report. It has some limited value in that we are relying that the individual is being forthcoming. And that can be difficult in addiction because addiction also, or even without addiction, actually just with what we would consider substance use. That means no addiction, no dependence, just they happen to use a substance. But in the setting of screenings and things like that, there's a lot of stigma, unfortunately, that's attached to any substance use. And so sometimes people, they have reasons to fear being forthcoming with certain things that have to do with substances.
If you know, can you please explain what is an opioid epidemic?
Well, the opioid epidemic is currently something that we've experienced since around 1999. Currently, we're in our fourth wave of the opioid epidemic, and everyone's probably seen in the news drugs like fentanyl or heroin. These are class of chemicals that typically we use for pain. And the first wave of that really happened somewhere around 1999. And it was around prescription drugs that doctors would prescribe, and sometimes people could get dependent on them. Now, dependency is not the same thing as addiction. It can even just be dependence. It can be around pain. However, it does leave people where if they stop using it, they experience what we call withdrawal. And withdrawal can be a pretty severe neurologic type of reaction to not having the substance, access to the substance, which then, when we clamp down on that and reduce that from the standpoint of the system, it created the second wave. And the second wave was around heroin, where people found that they could no longer access prescription drugs, and so they went to use heroin, which was cheaper and more accessible. The third wave came somewhere around 2012, 2013, which had to do with fentanyl. And that was the beginning of what we see now, where you didn't even have to be addicted. You could just actually come into contact with a very potent opioid, a synthetic opioid like fentanyl, not from a prescription, but something that was either adulterated, added to something that you thought was something else, or the very thing in question being the fentanyl. And that went on for some time, and now we're in our fourth wave. And the fourth wave involves fentanyl plus psychostimulants. And psychostimulants, that class, involves primarily methamphetamine and cocaine. And those are the kind of the second highest amount of prevalence that we see next to fentanyl in cases that involve fatal overdoses.
What scheduled drug is fentanyl?
It's a Schedule 2.
What about cocaine?
It's a Schedule 2.
What about marijuana?
It's federally still scheduled right now. This thing is a Schedule 1.
What about Adderall?
Adderall is a Schedule 2. That's a psychostimulant.
And if Adderall is a psychostimulant, does that mean it will fall within the fourth wave?
It is. It's an amphetamine.
And are counterfeit or fake Adderall pills contributing to the opioid crisis?
So that's the big thing that's happening now, and this is why the DEA has put out warnings about this. It's not that people are consciously seeking out, usually when they pass away, necessarily the combination of fentanyl with a psychostimulant. It's that oftentimes they think they're taking one thing, but it's adulterated. That means it's been added or spiked, if you will, to something else. And that can actually happen in both directions. It can happen to people that press pills and make Adderall, they'll add fentanyl, and it can also happen in the other direction.
And when clinicians assess risk, do they look at isolated events or overall behavioral patterns?
Well, an isolated event rarely leads to any sort of a diagnosis, right? So we're always collecting information. Some of the information comes from the patient. Some of it comes from corroborating avenues from other people or other things that are observed that contribute to the diagnosis. So generally it's an overall kind of a compilation of processes that we look at, not just one thing.
And have you had the opportunity to review medical records in this case?
Yes.
Have you ever seen, do you know of a pregnant woman who normally would smoke marijuana?
Yes, that happens.
And are they always forthcoming about their use?
No. I mean, in pregnancy in particular, again, there's significant stigma, significant fear of consequences, child protective services, being judged. These things that are unfortunate that shouldn't exist, but they do exist, and I think they're even more marked in that group of people that have any sort of substance use. It doesn't even have to be cannabis. It can be any sort of substance.
And in your expert opinion, who would be amongst the most stigmatized class of people when it comes to drug use?
I believe it would be the actively pregnant woman.
Would it be judges?
I'm sorry?
Wouldn't be judges?
No, I think that there are states that still, and we've had this historically, that want to put women in jail for substance use. So rather than looking at it as a medical condition, they look to remedy that by illegal action to put people away. So I think that's pretty severe. We don't do that. We don't do that to any man that I know of in the same way. And so I think that they're particularly stigmatized because there's an element of another being, the element of a child. So the concept of, well, you're hurting the child, therefore you have a separate action against you. And that's where that comes from. And I think there's also social pressures. It's a critical, delicate time as well.
And could that stigma and social pressures lead to a pregnant person concealing their substance use?
Sure, it can.
Backtracking a little bit, what about mushrooms or psilocybin? What scheduled drug is that?
So psilocybin, or what's sometimes called magic mushrooms, is a Schedule 1. It's in a category we call hallucinogen, that people take it and then they can have psychedelic type of reactions to it.
Mario, I want to give you a hypothetical. If there's a pregnant young lady and she notifies her friend that she's pregnant, and that friend says, "Oh, you've been drinking," is that an example of stigmatizing a person?
Well, it can be that anytime somebody that is pregnant shares any information about any substance use, that this is why doctors get trained to have more of a poker face about it, that our concern is how do we evaluate what you need rather than judge what you did.
And in your expert opinion and in treatment, have you ever heard of someone being able to smoke mushrooms?
So in my practice, I have not heard of anybody doing that. After almost 20 years now of doing this, I think everything that could be smoked has probably been smoked by somebody at some point. However, in the case of psilocybin, combusting it or burning it actually would deactivate the active ingredient, so you wouldn't get what you wanted from it, and then you would also be inhaling a bunch of fungal spores into your lungs. So there's lots of reasons why it's something that people don't really do, even though certainly you can try it.
And lastly, if you could just talk a little bit about how substance use impacts, if at all, the prefrontal cortex of a person.
Sure, that's really at the hallmark of all addiction. It's one of the most difficult parts to sometimes understand. People that have substance use disorders need help, and this is the reason we look at it as a disease, is because the parts of the brain that get affected, we know. We actually have studied it. We know the parts. And maybe the most frustrating part for a lot of people is how is it that somebody that maybe in other dimensions of their life function well, how is it that they can have this other component that is not functioning well? And the part of the brain that is involved in this is right in front of your forehead, right behind your forehead. It's called the prefrontal cortex, and that's the part that controls judgment. It controls what we call executive function. It's the part that keeps you safe, that helps you make decisions. And unfortunately, certain substances impact the part of the brain that controls a neurotransmitter called dopamine. So there's really two players in the play. The dopamine pathways, which we also call the reward pathway. When you do something that is good for persistence, it obviously doesn't exist for drugs to exist. They're there because of their survival things. So increases in dopamine decrease the function of the prefrontal cortex, which is why in substance use disorders there can be lapses in judgment.
And in your expert opinion, if a person is pregnant, but they're engaging in, let's say, facilitating drugs, what would you opine about that person's judgment?
Well, that would definitely fall under what we consider to be part of the clinical impression. So the clinical impression, without going into a diagnosis, because you really need to do a physical exam and do a comprehensive exam to come to a diagnosis. But risk-taking is part of the hallmark of addictive disorders. So engaging with a drug dealer in any fashion certainly would fall under that, whether you're an intermediary, whether you're buying yourself, whether even just associating. I think that would be one of the signs of many that we do include in our evaluation of what a substance use disorder might be.
And again, it's not uncommon for in your experience, in your expert opinion, for a pregnant person to hide any type of substance use from their friends and family.
It's not uncommon for all people with addictive disorders, but I think even more so potentially with somebody with a pregnancy that's going on at the same time. There's a bit more to lose, I suppose, that is part of the thought process.
And along with drug or facilitating drugs, being around drugs, would a person's proclivity to engage in promiscuity be something that you would consider about the judgment? Could you assess that at all?
Well, it's something that can be, just as a general, it doesn't necessarily have to do with substances, but it certainly is any high-risk behavior where you can link, where there's typically the prefrontal cortex puts the brake on and it stops it. That would be something that could be in consideration.
Your Honor, at this time, I would like to tender Dr. Mario as an expert, as a medical review officer, and an addiction medicine specialist.
Any questions from the state?
Yes, Your Honor. Well, Doctor, would I understand by that by analogy, a pregnant woman should never work as a bartender? Was there been around?
I don't understand the
substance
question.
That they shouldn't be ingesting?
Well, so for somebody with an addictive disorder that has pregnancy, yes, my recommendation to that person would be working in a bar would probably not be the best, just because of exposure.
There is absolutely no proof in any record that you've reviewed that Jade Benning was addicted to any cocaine or any other controlled substance, is there?
Not of cocaine or no addictions.
And she was a casual user of marijuana, correct?
Well, so we don't use terms like casual user, so that would have to qualify that. I mean, we have what we consider to be misuse of drugs and then use disorders. We can't really make a determination on use disorders because a full evaluation wasn't done, the labs, the examination. She did not have a use disorder that I could state as a physician because that examination was not done. But misuse of substances, there's actually a lot of information. There are chats with...
I'm not asking you about misuse disorders, I'm asking you about Jade Benning. I'm not asking about other people.
I'm not talking about other people, I'm talking about Jade Benning as well.
Okay. Well, in California, is marijuana legal in California?
It is. Well, it's decriminalized, so it's...
Decriminalized, whatever. And actually legal in a number of states, from what I understand. Okay, do you treat people with marijuana addictions?
I do.
All right, so do they come to you out of the blue, referred by law enforcement?
Law enforcement doesn't give me many referrals unless there's court ordered. However, I do get referrals, and I do have people that come in that tell me that their cannabis use has gotten past what they can handle, and they feel like their life's out of order.
Gotten out of control?
Yeah.
Absolutely no indication that happened with Jade Benning, is there?
I would consider engaging with a drug dealer unusual behavior that would be linked to, in this case, cannabis.
That's my point.
That information.
From the text messages that she was having between Danny, the dealer, she was getting for her coworkers and for herself, cartridges of cannabinoids, all sorts of different species of cannabinoids, some magic mushrooms. I'm sorry? She was brokering them. Some of it was promised to her, and but most of it was as an intermediary for coworkers. I would consider that to be unusual behavior, I think, for anybody to engage in that, because the risks are high. Not judging if it's a good thing or a bad thing, but to put yourself in a position to have to be an intermediary and then potentially be at risk for the consequences when you give somebody else a substance that somebody else brokered for them.
From the records you reviewed, we're talking about Adderall. There was no Adderall or any derivative of that found in Ms. Benning's system, was there?
No.
And remember, you and I talked, and we have a time or two, at least for the sake of low, that you would agree, would you not, doctor, that she died from acute cocaine toxicity by oral ingestion, correct?
Well, I'm not here to actually, my scope is not to testify on cause of death. So I would leave that to the toxicologist and Dr. Larkin.
Well, did you not tell me that you would agree with that finding?
Objection, Your Honor. The witness has already stated his scope.
Right. And that, how many people have you ever treated at your clinic or for being addicted to orally ingesting cocaine?
That's exceedingly rare. I mean, I know that people use it in their gums. They've had it in their mouth, but there's definitely not been a lot. That's not actually, in general, that's not a common way. Yeah. So.
Because they die.
No, that's not why. It's because it actually takes longer to get the effect, number one. Number two is because it actually deactivates a lot of it, so you don't, it's hard to get the same effect that you could get if you snorted it, you smoked it, or you injected it. That's the reason why, and it's quite a hierarchy that can be applied to most things actually. If the particular substance isn't particularly absorbed well with how you take it, that's not how it's used.
There is absolutely no indication, doctor, is there from a medical record that Jade Benning consumed any drug or alcohol after she found out she was pregnant, is there?
Correct, not medical records, no.
And so, nothing that you have testified about is based on any personal interaction with Jade Benning, correct?
That's correct.
Either during her lifetime or from obviously the review of the records. There is just nothing there.
Yeah, I have not personally evaluated Miss Benning.
And the phases of heroin has nothing to do with this, does it?
No. Are you referring to the different?
Your epidemics.
Yeah, well, they're not mine. They actually are of ours. But I mean, the heroin was just one stage of that, and so that was just one to kind of explain why there are different stages of that exist. That the most recent one is fentanyl and psychostimulants.
But I mean, your testimony about the phases. What was before heroin?
Before heroin was prescription drugs.
Okay, before prescription drugs.
Well, that's the first one. Prescription drugs. Then there was heroin. Then there's fentanyl, and then there's fentanyl with psychostimulants. That's the four. And we're likely to enter a fifth one now with xylazine, which are like anesthetics that are being adulterated into the supply of fentanyl.
And back in the 70s, there were other substances.
Back in the 70s, a whole other time of what was available, so I'm not really speaking to that.
That's all.
Okay. Thank you.
Thank you.
Step down, step back up. Oh, you got more questions?
Dr. Mario, can you explain what coca-ethylene is?
Coca-ethylene is a byproduct.
Your Honor, I object. Wasn't covered on direct or cross-examination.
Okay.
I really read the jury out.
Treatment specialist, addiction medicine.
Yes, Your Honor, and cocaine and alcohol was just referenced.
Is that what you plan on getting into with Dr. Larkin if she testifies? We've already heard testimony about it, right?
Yes, Your Honor, but however, what was just solicited from Dr. Mario was about a person working at a bar, and was there ever any evidence of any uses of cocaine with Mrs. Benning?
Is he aware of any usage of cocaine?
Are you aware on whether or not the substance cocaethylene was found in this Jade Benning system?
Well, my understanding is that there's one of the lab reports that did show that there was cocaethylene. It sounds like there's probably contested. It's maybe for the.
And what is cocaethylene a byproduct of?
Well, so when you consume alcohol in the setting of cocaine, you produce a compound called cocaethylene. It creates a high toxic environment, so your heart will work harder. All the things that normally cocaine will cause, it can make it worse. And it's one of the known problems, right, with combining those.
And can alcohol be an addiction? Can it be abused?
Yes.
Can it be misused?
It can.
And can you be a casual cocaine user?
You can. You can be a casual cocaine user, somebody that uses not with great frequency. It's possible. It's possible with alcohol as well.
So you can be a casual cocaine user, but not a casual marijuana user?
I don't think I said you can't be a casual marijuana user. That you can't be a casual? No, I don't think I would have said that. I mean, if I did, I misspoke. But you absolutely can't. You can be a casual.
You wouldn't use the word casual.
Yeah, I wouldn't use casual because in the context of what you were talking about, it was.
He's asking you can be a casual cocaine user.
So you can be. So if the definition of that is that somebody uses infrequently, if that's what your definition is, when we discussed the issue of the marijuana, I thought you were talking about something more like diagnostic. I just wouldn't use those words for something diagnostic. But they both can be used with low frequencies, for sure.
Not the cocaethylene, you said someone told you about that?
No, I've seen it in the reports from one of the labs, but again, I'm not here to testify in my scope about that. I think you have a toxicologist and you're going to have Dr. Larkin on that.
Did you prepare a report about all of this?
I did not. I don't have a report.
That's all right.
Anything else? Oh, okay, you stepped up.
All right, the state attorney for.
Yes, Your Honor. Yes, Your Honor, the state will renew its objection to this doctor testifying under Rule 702. There's been nothing that he has testified about, in fact, knowledge of this incident, no knowledge of Ms. Benning, other than she was not addicted. All this testimony would have to come under Rule 702, that it is would substantially assist the trier of fact, the jury. And the Merriam-Webster dictionary synonym is important or essential. So this testimony is not anywhere close to being essential. It's irrelevant. It is designed to, if anything, just attempt to paint Ms. Benning as someone she was not. I would ask the court to exclude this testimony in its entirety.
Sure.
Your Honor, it is not only important, but it's a vital and critical issue that the state has put before this jury through multiple witnesses, which is the fact that Ms. Benning would not engage in any type of drug use or behavior because she was pregnant. And so it is very...
They didn't say that. They said there's not even proof that she did.
And, Your Honor, we believe the contrary. We intend to get into that.
But this gentleman doesn't know that.
Yes, he does, Your Honor. He has reviewed text messages that suggest she was offered drugs while she was in fact pregnant.
We haven't gotten to the text messages, but if those come in, then they come in. He doesn't have to interpret them.
No, but certainly they are evidence of the lifestyle that Ms. Benning was engaged in. The state certainly has taken the position that it is a barrier to her being involved in anything illicit because she was in fact pregnant. And so the defense has a right to put on evidence before this jury that simply being pregnant is not a reasonable statement of sobriety in and of itself.
I asked the state that 2 hours ago, and they agreed with me.
But Your Honor, they can take that position because they have rested. They've already paraded a bunch of witnesses before this jury who have said otherwise.
So you think you need this person to tell the jury that women that are pregnant can still use drugs?
And that they are stigmatized, and that may be a reason that they would not disclose to family members and loved ones.
Okay. Thank you. All right. As it turns out, the coca-ethylene that was brought on redirect and then recross, as the own witness said, he's not here to interpret what that, he knows what it is, but he's not here to say one way or the other about what that means for Ms. Benning. The other proffer involving pregnancy, not being an automatic stop to using drugs, pregnant women can still use drugs, the testimony about fentanyl overdose or epidemics, I don't know if that word was used, the detective's already been asked about and testified. There's no proof, and this witness has said he doesn't assess Ms. Benning as being an addictive disorder person, patient, if she were one of his patients. So under, I mean, he's a fine gentleman, useful in his field, I'm sure, but 702 requires the court to assure that there is some issue that the jury wouldn't know about and that his testimony would substantially assist the trier of fact in some issue to be determined. And the court just doesn't find that. So no need for Dr. San Bartolome. Is what?
I would like to say for the record, offer proof that.
We've already had the offer.
There was one other thing that I would like to add, and that is the state has put an issue that since Ms. Benning has become pregnant, she is now leading this clean life. Ms. Benning is.
Like I said to your co-counsel, they're putting on proof that there's no proof she did use.
However, Your Honor, she is heavily involved with the sale of drugs.
Right.
That is dangerous behavior in and of itself.
Okay.
The jury needs to be educated in regards to.
And what proof is there that she was involved in dangerous drugs on the day or in and around the day she died?
Because on that very day, she reached out to her drug dealer. The very day she passed
Any
away.
proof that she met with him?
We don't know.
Okay. Well, your Dr. Larkin says on the day of her death, text messages indicate that Jade met with her drug dealer. You just said that inaccurate.
Well, I think an inference can be made that she did.
You just said she didn't.
You asked me, is there any proof that she did?
It's what we deal with is proof.
Well, we have to be able to put on a defensive theory. So all I
Sure,
have to say.
I haven't figured out relevancy-wise what it is, but that's where I'm trying to get to.
What's relevant is.
But I've already ruled on Dr. San Bartolome.
If I could just say, what's relevant is the doctor stated about the most stigmatized person when it comes to drugs is the pregnant woman. Which means that she will do whatever she can to hide her interaction, use, dealing with drugs, such that her family
Just
will not
present
know.
proof, if you have it, that she was using drugs. That's all you have to do.
There's no proof Mr. Taylor did this either, but there is an inference being made. In that same instance, we would like to make the inference in regard to Ms. Benning.
Okay, and I ruled, like you've asked me to do. Now, what did the state determine about Bumble?
Your Honor, do not believe that this is active use for Bumble. I do not think it should be admitted. I would like to have a jury out on it.
Okay,
She
where
was-
is Mr. Kevin?
I,
Bring him in, we'll hear what he says this means. And is the state opposed to the other text messages?
I am opposed.
Some of them have already been mentioned and introduced, and talked about.
I am opposed to the one on 1/20/23.
1/21/23 dealing with what? They've got them categorized as discussion with Blaise.
I'm sorry, it's like it's under the drugs category.
Okay. Which, is there a page? I got 5, a 6, and a 7.
4.
4. That's the metadata with the message. You're talking about, could I get an 8 of top shelf?
Correct.
What is your objection?
My objection is she's not ordering this for herself. It's in January and it's not relevant. We've already had testimony related to the same thing.
Correct, but they can put on other proof. What's your other objection?
On page 5, that is a received message, not a sent message.
I don't know what Mr. Edmonds gonna say. So it's received, but it's still drug related, right?
Correct.
Okay. Anything else?
Yes, on 6, it's from 11/5/22 and it's received. The state submits it's not relevant.
Okay. What else?
Also number 7, it's received, it's from January 18th of 2023.
Okay. Anything else?
On page 8, the reference to Adderall, I feel like we have already been through. This is not Adderall that Ms. Benning was requesting for herself. It was from a friend that was out.
Right, we just confirms that, right?
I'm sorry?
This just confirms that. That
Yes.
it's for someone else.
No. Right, this is like someone else is asking for it, not Ms. Benning.
Anything else? Anything else?
Number 8, I feel like actually clears up the
That's the
Mario
one you
situation.
just asked about.
I'm sorry?
That's the one you just mentioned.
I'm sorry, that was number 9, was the one that kind of clears up the Mario situation because she wasn't ordering it herself. On number 10, there's no date on this. Also, it just seems cumulative. So there's no date for the message sent. There is a date. They just cut it off. And the thread, they included 235 messages, which doesn't seem useful, but it doesn't tell you what date this message was sent.
Okay. We'll see what they have to say in their prompt. Anything else?
Number 11, like everything, he's printing stuff without the usernames in it. This message would have a username, but it's clearly someone else asking for narcotics. It just seems like it's Mario, and that would be important to the other text.
Anything else?
12, I don't have an objection. Pages 13 through 15, no objection. Communication with Blaise Taylor, no objection. Plans with Blaise Taylor, again, I don't have a specific objection. I just have no idea why we would submit a message without the person the message is sent to. And then the Bumble, I have a giant problem with.
Okay, we'll hear about that.
And the Jerry and Porter messages, the state's objection is that these are not relevant to any issue before the court.
According to the defense theory, it shows you talking with another guy, texting another guy.
These are texts from December.
Right.
The first page is from December, so she's not even speaking
Taylor then.
All right, if you'll step up, Mr. Devlin, raise your right hand as you sworn.
You swear to tell the truth, so help you God.
I do, Your Honor.
All right, if you will, in your proper, clear up whether your person here, witness, knows anything about page 23 and what that means, 22 and 23.
Mr. Devlin, could you please state and spell your name for the record?
Sure. My name is Eric, E-R-I-C. Last name is Devlin, D-E-V-L-I-N.
And Mr. Devlin, how are you employed, sir?
I'm currently the managing director of the Lone Star Forensic Group, a digital forensics company based in Houston, Texas.
And could you give the court your credentials in regards to the digital forensics?
I have an undergraduate degree in history, political science, and film out of Southern Methodist University. I have a law degree out of South Texas College of Law. After graduating from South Texas College of Law, I took the bar exam, passed the bar exam, became a prosecutor at the Harris County District Attorney's Office, which is Houston's DA's office. I was a prosecutor there. I tried everything from traffic tickets to death penalty cases, but spent most of my time as the chief of the cybercrime, human trafficking, and child exploitation divisions. After I left the DA's office, I opened a forensic company, and I've received thousands of hours of forensic training. I have certifications through a variety of platforms. I have examined thousands of cell phones. I have testified in state court, federal court. I've testified in, so far, I've testified in Ohio, Texas, Florida, South Carolina, and Indiana.
And have you had any specialized training in regards to cell phones particularly?
Yes, I have specialized training from Celebrite. I have specialized training from magnet forensics. I have specialized training in generic phone forensics. I also have advanced smartphone training.
Have you had any occasion to publish any publications and/or articles?
Yes.
Have you been certified as an expert in forensics, digital forensics, prior to today?
Yes.
And will you be opining and/or getting information today from the cell phone and dump and/or forensic download of Ms. Jade Benning's phone?
Yes, ma'am.
At this time, I will tender Mr. Devlin as a forensic expert with the cell phone of Ms.
Tell us what page 23 means.
It starts on page 22, but page 23 specifically is the activation of the application for Bumble, which is a social contact application. This indicates when you go from the springboard, which is the basic function of the screen, opening that particular application.
And does this, or do the notations that we find on page 23 actually state that Ms. Benning opened that application and interacted with it?
I can't say Ms. Benning did. I can say that this phone opened.
Thank you. And did they do so on each and every occasion? Did this phone, every notation that we see here, did it in fact interact with the Bumble application?
Each one of these is an interaction with the Bumble application.
And is not simply just a notification?
No.
Interacting how?
Either opening it, closing it, switching it, adding in, making contact with the actual application.
Can you tell me that Ms. Benning was communicating with, accessing information about other men?
No, sir.
Can you tell us what is the purpose of the Bumble application? What is its purpose? What is involved?
The Bumble application describes itself as a social contact application. So while many people use it for the purpose of dating or hookups or other interaction, other people use it as a contact social media application that time.
What can you tell us she was doing?
I can't. Just that the application was being interacted with. and the application was installed previous, so.
Can you give us, I'm sorry, can you give us a date that this application was installed on Ms. Benning's home?
There, I show an application, an installation of the application on 2/17/23, and I see another installation on 2/22/2023.
All right, any other questions? Do you have?
I do. Mr. Devlin, did you pull out the information where Ms. Benning registered with Bumble August 6th of 2022?
I didn't see that part, so.
Okay, so you were searching specifically for user activity on Bumble, and you didn't just put Bumble in as a search term in the Axiom software.
When I was, sorry.
Did you not do that?
I did enter Bumble as a search term, that's correct.
Okay, but you missed where she got a text message from Bumble with her registration code on August 6th of 2022 at 12/17/27.
Your Honor, if I could just note, that might have been during the date-limited portion of our search.
No, you wanted to go back to January 2022.
I don't think we were allowed to go back on those issues. We were limited to certain issues that we could search.
Well, you're wanting this witness to testify about her accessing Bumble, so they're asking their questions. Go ahead.
And so if this same database that you have here on page 23, if there's activity on here after Jade Benning's death and after the phone is in police custody, do you think you might change your opinion as to whether or not this is user activity or if it's just updates within the Bumble app?
The Bumble app can have updates, absolutely, as a part of it, depending upon if the phone is powered on and connected to the networks. I did see actually registration codes. I did see other messages that were what we call system-generated messages, but I didn't see any messages at all on here with her communicating with anybody on the Bumble app. So
No messages with Ms. Benning communicating with anyone on the Bumble app.
not that was recovered, no ma'am.
So it's possible that she could have even gone in to look at one of her girlfriend's profiles just to give her some feedback as a nice friend.
Some people do that, yes ma'am.
And Your Honor, I would think that that is a point for cross-examination.
Do you have any other questions?
You speaking to me? Are you speaking to me or this?
To you.
Yes, I do.
Did you find entries like this after the date of death?
I haven't noticed it, Your Honor, so I didn't look for that particular, so.
You didn't look after 3/6?
No ma'am, no sir.
Okay.
When you looked at the Bumble application, did you pay close attention to whether or not the application itself was interacted with as opposed to just a notification?
These logs here are not notification logs. These are actual interactions with the application.
And when you say interactions, what do you mean?
That means the application was opened, the application was interacted with. I don't know what they did with it. I don't know if they searched for somebody. I don't know if they communicated with somebody, but there was an interaction with the application. That's as far as I can see on here.
So then it is a possibility that if she interacted with this Bumble, it could be that she was looking at dating men.
It's possible.
So in the same manner that she could have been trying to message a friend or a girlfriend to check on her, she also could have been messaging a man to try to date.
Could be, yes ma'am.
Again, Your Honor, based on
Do you have
this.
any other questions?
No, I do not at this time.
Does the state have any other questions?
Not related to the Bumble app.
Okay, all right, thank you, sir. You can wait right back.
Thank you, Your Honor.
pages, Ms. Collins, 22 and 23 prove that Ms. Benning was dating other men.
I think it infers that she was dating other men. There are other messages that we also believe that she was dating other men in connection with that. And so,
What are you speaking of?
I'm speaking of in December, when she was in fact pregnant and living a clean life, she sent naked photographs to 3 different men. These
That's
things
not in what you said.
It's not, because I did not want to put that type of information in here, but it is important.
So you're not planning on asking about that?
I do plan on asking about that. That's why I'm bringing it to the court's attention now, because the state
So
has.
what other text are you wanting to introduce to this jury?
Outside of this, I want those text messages.
Where are they?
In December. I did not want to print out those types of photographs.
You're wanting the jury to see them, right?
No, I do not. I would just like for them to hear about them. That's why I never printed them. I was not going to print those text messages. Neither did I want to make them a part of the record, but I do want to talk about it. It is only fair that Mr. Taylor, who has been painted as someone who doesn't care, dating other women while he's with Miss Benning, that he is not afforded the opportunity to show.
Trash her.
No, they're trashing him, if that's the case.
So you want to trash her?
No, I want the jury to have all the facts, Your Honor. That is all.
That would be great if in fact it's proven.
Well, I can tell you those 3 messages are proven in December.
Has the state seen those?
No, Your Honor, the state has not seen them.
I thought you downloaded her phone.
I haven't looked at every single thing on her phone, and particularly whether or not she's dating men in December when they're broken up, the state's position isn't irrelevant.
That's the first time in 7 days I've heard that. So back to the pages 22 and 23. What does that show me under 401?
What it shows is that Bumble is known to be a dating application. It is not known to be a place where you go and look, say hello to a friend.
He said it was.
He said it was one of the things you can do.
Well, then don't say it wasn't, because your witness just said it was.
He said that in response to the state's question if it was a possibility. He said yes.
He says that happens.
It's a possibility. But that is not the primary purpose of Bumble. That might be the primary purpose of Instagram, TikTok, Facebook, but it is not the primary purpose of Bumble.
Would you acknowledge, I doubt you would, but I just ask it, that if you want to inquire with your witness, Mr. Devlin, about the application, Bumble application being installed on 2/17 and 2/23, that the state can also ask him if he looked at August of 2022 when it was installed?
Yes.
And your position is what?
If the state can talk about August of 22,
Just ask what they asked when the witness was in here.
we were confined, Your Honor, to a search period to.
So is it fair to the jury to know that she also installed it on another occasion?
I don't have a problem with that.
Okay, that's what I asked. Okay, the other issues that the state had, you can cross-examine, find out dates, find out whether it's received. I mean, if it's received, some of these, quote, drug, quote, involvements, it's received, so. It's like dating men. What does that have to do with 225? Florida condo, just like these others. But that's one of their many theories. So remove page 23 from your PowerPoint and or exhibit. I'll let you ask your witness about these other texts and slides that you wanted to introduce. Is he the next witness?
He is, Your Honor.
Do y'all need a break?
But he needs to get on the plane, so I can wait if you don't mind, so that he can make his flight. I will wait for my break.
Okay. All right, let Mr. Devlin step back in and bring the jury down.
Judge, are you keeping out all three of the Bumble references?
I don't need you're talking about the one sheet that says Bumble?
Well, yeah, I don't know why I'd bring it up if you're keeping the other pages
Well,
out.
22
and 23 are the Bumble pages.
22 just confirms that, according to him, she installed it. So you can pull out 21 and 23 and ask him about 22.
Okay, so 20, because I have a presentation on my, so 22 can stay in, 23 comes out.
And 20. 21, 23 come out.
I don't have an objection to 21 if 22 is staying in. I was trying to clarify that before.
But 21 is just some creep. It just doesn't matter. You can ask him about 22 and what that means. All right.
The defense calls Eric
Okay, we're not in here yet.
Oh.
My digital expert is here, Your Honor. I'm assuming he could be present for this.
Okay.
To be clear, what page are we taking out?
Do you have Mr. Grant?
Yes, I have it. Page 23, I was doing
Defense calls Eric Benning.
You swear the testimony about to give to the truth, so help you God.
I do.
Could you please state and spell your name for the record, please?
Sure. My name is Eric, E-R-I-C. Last name is Devlin, D-E-V-L-I-N.
And Mr. Devlin, how are you employed?
At the present time, I'm the managing director of the Lone Star Forensic Group. We're a digital forensics company based out of Houston, Texas.
And where did you get your education, sir?
My undergraduate degree is from Southern Methodist University. My law degree is actually out of South Texas College of Law based in Houston.
And did you take the bar?
I did. And
Did you pass the bar?
I did pass the bar.
And after you passed the bar, can you tell the jury how you were employed?
I was employed at the Harris County District Attorney's Office, so that is the prosecution office for the city of Houston. I was there, I prosecuted everything from traffic tickets up to death penalty cases, but I spent most of my time as the chief of the cybercrime, child exploitation, and the human trafficking sections.
Have you had any specified training as it relates to digital forensics?
Yes, while I was a prosecutor, I actually began taking forensic courses to be a better prosecutor, present those cases in court better. While I was taking those classes, I actually realized I liked that better than the practice of law. So when I left the district attorney's office, I opened a forensic company, and I've continued taking forensic classes in a variety of courses, both cell phones, computers, as well as cell location analysis, as well as surveillance systems and other recording systems.
And have you had any specified training specifically to digital forensics?
Yes, I have received thousands of hours of specialized training, everything from Celebrite, Magnet Axiom, as well as a variety of other forensic courses specifically. I've also received advanced training in smartphone examinations.
And have you been published, or have you published articles in regards to digital forensics?
Yes, I have published articles related to digital forensics, cybercrime investigation, and child exploitation.
And have you had the occasion to testify before in digital forensics?
Yes, I frequently testify in Houston, where I'm based out of, but I've also testified in Florida, South Carolina, Ohio, and I think I'm missing a couple, so.
And have you had the occasion to testify on both sides, for the prosecution and the defense?
I more frequently testify for the state side than for the defense, but I do testify for both, so.
Thank you. At this time, I will tender Mr. Devlin as an expert in digital forensics.
Any questions from the state?
And I would offer Mr. Devlin's CV as an expert.
Okay, get that to AG1. All right. All right, again, ladies and gentlemen of the jury, Mr. Devlin will be allowed to testify in his field of digital forensics. You can place such weight as you choose to upon his testimony. All right.
Mr. Devlin, have you had the opportunity to review the digital download of Jade Benning's phone?
Yes.
And in doing so, have we asked you to locate specific text messages, not all of them, but just a representative of some text messages?
Yes.
Specifically, I'd like to draw you to page 3.
Yes, ma'am.
Did you find any text messages within Ms. Benning's phone that dealt with drugs?
Yes, I examined an Apple iPhone 13. I was asked to examine and review the forensic extraction that was done by law enforcement. I did find a variety of messages related to drugs and other narcotics activity.
And can we start on page 4, if you will, and explain to us what is that we see there?
This is actually a Snapchat message. So this message was between Danny, the Snapchat ID, Danny Wallace Jr. and a Jade Benning. This activity occurred on 1/20/2023, approximately 6:53:47 p.m. This was in Central Standard Time, so that sometimes changes based on the phone. This was a message that the user account Jade Benning posted to the Danny Wallace Jr., specifically stating, hey, could I get an 1/8 of top shelf and 1 Sativa or hybrid cart?
Do you happen to know what a sativa and hybrid cart is?
I am familiar with it. I am familiar that they are narcotics. I am not familiar with exactly what kind of narcotics they are.
Okay, well, draw your attention to page 5.
Yes, ma'am.
What date is that, sir?
This was 2/3/2023, approximately 9:57:21 p.m.
And is this message from or to Jade Benning?
This is a message from Jade Benning.
And could you read the message for us, please?
It says apple fritter with the emoji of a fire sign, $25 eighth, $50 quarter, $100 half, $150 zip.
Thank you. And on to page 6, please. Is this message to or from Ms. Benning?
This is a message that was posted inside the Telegram chat room, so it's not one sent by Ms. Benning, but it was received on this device.
What is
a Telegram chat room?
Telegram is a social media site, communication site. It's created by an individual out of Russia. It is advertised itself as to be super encrypted. It is not a good place. So,
And was this application downloaded on Ms. Benning's phone?
yes, ma'am.
Can I draw your attention to page 7? Is this message to or from Ms. Benning?
This is a message posted in that gas station chat room on the Telegram application.
What is a gas station chat room?
On Telegram, you can create all kinds of chat rooms and invite whoever you want to be a part of it. That's one that occurs, and actually narcotics activity frequently occurs this way. It allows them to advertise sales or purchases or deliveries of different types of substances. And it's, again, believed to be encrypted and heavily anonymous. So,
And could you read for us the message that's on this particular date?
it says pressure plus with the emoji for carts with a fire, $30 a pop, price cut on 2+.
Could I draw your attention to page 8?
Yes, ma'am.
Could you explain to the jury what this represents, what page 8 represents?
This is an actual iOS text message, so this is a communication between this particular device and another individual. That individual they're communicating with is phone number 501-451-0608.
And could you read for us the text message?
The text message start at 11/22/2022, 10:40:13 a.m. Do of your coworkers get Adderall? The reply, Lauren has some. Message again, ooh, what MG? The reply was 15. Message to this particular device, ooh, ask her, can I buy some? And then the next was a follow-up. This is still a message to this particular device. And what color are they? And the reply from this device was orange.
And to the left there, who do you see is the sender of this text message?
The sender of this message is this number is listed in the contacts as belonging to, and I'm going to kill the name, Nijaha, Nijaiha.
Nigeria?
Yes, ma'am.
And what is the date of that text message, sir?
11/22/2022.
Can I draw your attention to page 9?
Yes, ma'am.
And could you read for the jury what page 9 represents with the date as well as the context?
This is an iOS text message, and this is between the Jade Benning account and a Mario Gutierrez account. On this message, it occurs on 2/18/2023, 9/33/02. The message was from the Jade Benning account saying he's about to bring your weed. There's a reply from the Mario Gutierrez account, says I fell asleep, and I don't know if I'm allowed to curse in this courtroom or not. So.
That's okay, thank you. Could you please turn your attention to page 10?
Yes, ma'am.
And could you represent to the jury what page 10 represents?
Page 10 is a iOS communication between the contact Danny, in parentheses weed, and this particular device. On this one, the message is, I have mushrooms right now. LOL, my coworker's wanting some.
And on what date is this text message?
I appear to have cut the date off on that text message. I can't tell you.
Okay, thank you. Would it be between the dates that you have listed there where it says first message, last message?
Yes, ma'am.
Thank you. And those dates would be between April 6th of 22 and 2/25 of 23?
Yes, ma'am.
Could you now go to page 11?
Yes, ma'am.
And what does page 11 represent?
These are text messages, specifically occurring on 2/25/2023, 9:10:46 a.m.
And what does the message say?
The message says, yo, can you holler at Danny? Your boy needs a half, please and thanks.
Now, I don't see who this message was sent to. Do you have that information, Mr. Devlin?
I do not have that information.
And what date is on this text?
This text here is 2/25/2023 at 9:10:46 a.m.
On page 12, can you tell us what page 12 represents?
Page 12 is a text message between Jade Benning and the contact Danny Weed. And it occurs on 2/25/2023, beginning at 3:39:21 p.m.
And what does it say?
Specifically, it says, hey, my coworker wants to get a half from you. The account Danny Weed replies, bet I gotcha when I get back. The account for Jade Benning replies, sweet.
Now, did you ever find through your research whether or not page 11 was a message from Mario Gutierrez?
I gotta be honest, I don't remember, so.
Thank you. I want to draw your attention to page 13.
Yes, ma'am.
Now, before we move on, were those all of the text message that involved drugs in between, with Jade's phone from January of 22 through February of 23?
No, ma'am, they were a sampling.
Let's now go to page 13. What section would this subject matter address?
I was asked to look for conversations about Blaise Taylor.
I want to draw your attention to page 14.
Yes, ma'am.
Please read for the jury the text message.
This is an iOS text message starting 12/31/2022 at 2:55:57 p.m. from the account 501-541-0608. Send a message saying, I'm interested. Followed up with another message of, did you text or are you just going to wait? The account belonging to this particular device replied, he called me back. And then a second reply of, I told him that I would call him when I get off. The account ending in 0608 replied, oh, I don't know, I didn't know you answered. And with a second reply of, how was his tone?
Do you know who this number 501-541-0608 belongs to?
I believe that's the same name that you gave me earlier that I butchered, so.
Nigel.
Yes, ma'am.
I want to draw your attention to page 15. And what is the text message thread, please?
On this one, it's a continuation from the previous page. It's the account belonging to this particular device replies, he sounded the same as always, but I could tell he had something he needed to talk about, of course. The account ending in 0608 replied, why am I anxious like I'm talking to him? This device's account replies, LMAO, because I've been waiting for this. The account with 0608 replied with, get off work already, LOL. The account for this device replied, right, I keep looking at my watch. And then the final message on there is a reply from the 0608 account, keep me updated.
I now want to draw your attention to the next section. Could you tell us the subject matter of this next section?
On the next one, there's communications with Blaise Taylor.
And can I draw your attention to page 17?
Yes.
Can you please read that text thread for us?
Yes. In fact, I'm sorry, these are smaller, so I may read it from the larger screen. This particular account, the local user account, initiated a message saying, thank you for coming to help/see the new place. I'm glad we got to talk about all that we did. It gave me a better understanding on some things I didn't have before. Hope you feel a little better as well, babes, with an emoji. The reply was from the phone number ending in 5738. Thanks and no problem. Just wanted to keep communicating and stay on the same page. The second reply of loved, thank you for coming to help and see the new place. This account replied, 100% agree with you. Another reply, 100% also turns me on when we have our talks. The account ending in 5738 replied, laughed at 100%, also turns me on when we have our talks. With another reply of why, LOL. Then another message of, I feel like most of the time it's really me telling you stuff you probably don't want to hear.
Now, in regards to this text message, is this Jade Benning's phone in the blue?
It is.
Can we now move to page 18?
This is a continuation of that text thread, the account ending in 5738. I feel like most of the time it really me telling you stuff you probably don't want to hear. The next message was from the Jade Benning account, not necessarily. You're just keeping it real at the end of the day, and that's all I ask of you. And because to see you serious, for one, LOL, and us being able to calmly communicate about the situations we have in front of us just lights me up. The account ending in 5738 replies, LOL, okay. Well, I said I'll always be up front and answer any questions you have. This account here for this device replied, heard you. And this device, this account, the one ending in 5738, was under the contact name of Blaise.
Thank you. Let's now move to page 19, and what subject matter is this section?
This specifically is related to messages regarding plans with Blaise Taylor.
And can I get you to turn to page 20?
Yes, ma'am.
And could you read for us the text message here?
This message was on 2/25/2023 at 12:03:10 p.m. The message was sent saying, okay, LOL, I'm going to plan to do a little at-home paint with Blaise tonight.
And what date is that text message?
2/25/2023.
Can we now move to the next section?
Yes, ma'am.
And what section is this?
The label on it is Bumble.
Can you please identify page 22 and explain to the jury exactly what this is?
This specifically is a set of logs related to the installation of the Bumble application.
What is the Bumble application?
Bumble is an application that's on both iOS and Android devices. It's described as a social contact application.
And what day do you see that this particular phone installed the Bumble application?
There is an install of 2/17/2023 and another installation date of 2/22/2023.
And can I draw your attention to page 24?
Yes, ma'am.
And what is the nature of this section?
I was asked to find some communications related to Jarius Porter.
And can you read for us on page 25?
Yes, ma'am. On page 25, the communications start 12/17/2022, 9/17:30 p.m. It's a message from this particular device to the porterjarius@gmail.com. You've been getting it the last few. The porterjarius@gmail.com replies, yep, I'm on my way back to the shape I was before. I started dating a world-class chef. The message, this particular device replied, LMAO, I heard that. And then a second reply of, that's good though.
Okay. And can you move now to page 26?
Yes, ma'am. And these are, there's a lot of messages in between, but it was designed to give basically an idea of the length of the conversations. So these messages occur on 1/24/2023 at 1:12:02 p.m. This message from porterjarius@gmail.com. That's good. I'm glad you have to.
Let me,
And you want to switch to
yes, please.
switch to
I'm sorry, do I continue?
Yes.
Oh, sorry. The message was porterjarius@gmail.com, 1/24/2023, 1:12:02 p.m. Message says, that's good. I'm glad you have to. I'm just honestly sad, but I know I want to be forever, and God make no mistakes. Glad you're feeling better. This particular account on this device replied, yeah, I know it hurts to know, but you can talk to me about your feelings if you want to express anything. I want you to take care of yourself better and not let yourself go down the path of just turning to drinking and smoking more to heal. The Porter Jarius account replied, of course, Saudi, and LOL, don't forget, working out too. It's some good going on too, but you're right, I've been planning on slowing down. This device's account replied, I know you're working out too, LOL, but still, don't be doing that extra stuff.
And the next text message that we have.
This was a message, actually, and I'm sorry I printed out in black and white, but this was a message from this particular device, specifically saying, Blaise told me last night he signed up for monthly subscriptions of diapers from this company, Kudos, LOL.
And what's the date, I'm sorry, on this text message?
1/10/2023, and I can't read the time, so. No, I just need to move it over.
7:42?
Yes, 7:42:10 p.m.
And can we get you to read this text message?
Yes, this was a text message from the account 1-501-231-5975, asking the question of this device, does Blaise rub your belly, LOL? This particular device replied, sometimes.
And do we know who the number 501-231-5975 is?
I don't think I do offhand, so.
There were other messages, oh, I'm sorry. What is the date? I apologize. On that text message, if you remember before I pulled it up.
I do not remember before you
Let me
pulled
grab
it up.
it.
Those messages were 1/25/2023, began at 9:30:11 p.m., ended at 9:30:35 p.m.
Mr. Devlin, in your search within Ms. Benning's phone, did you happen to run across a text message between?
Objection, Your Honor.
Okay, let the lawyers.
Aye, aye, aye. Oh, we throwing hot dogs. Hey, he got a plane to catch. We ain't got time for all of this objections and all this extra stuff. They didn't already told you that he has a plane to catch. And we ain't got no money to be paying nobody else no more extra money. Wow, I mean, I would say this much, guys. So far, Blaise, your defense is a total disaster. It has been a disaster in every which way. And I am just trying to figure out, like, man, did y'all not game plan this? Did they not think about this? Did they not talk about this? Like, I don't know. This just seemed like a total disaster to me. To me. Now, it may be great for other people, but yeah, this is a mess.
Regarding her posting about her baby, do you remember seeing any of those text messages?
I vaguely recall that, but I couldn't give any details on it. I've seen a lot of messages, so.
Okay. And you don't remember if Ms. Jackson, Najee Jackson, asked Ms. Benning when she was going to post about her baby?
I remember that specific message of when are you going to post?
When Ms. Benning responded, do you remember it having anything to do with Blaise Taylor?
I don't recall the response, so.
Thank you. I'm has the witness.
Questions from the state?
Thank you, Your Honor. Mr. Devlin, you have gone through and testified about some random text messages. Would you agree?
Yes, ma'am.
Okay. And so when you said that you went through Ms. Benning's phone, did you actually take the text message that you have in your page 4 of your report? And did you actually look at the other messages surrounding it to see what context it was given? Which, Your Honor, I'm going to ask what he's doing right now with that tablet.
He's scrolling through his.
Are you looking at the report?
Yes, ma'am.
Okay.
I'm trying to see what was on page 4,
Yes,
so.
no, I'm happy to. I just didn't know if you were looking at the extraction.
Oh, no. Did I see the messages, the context of the messages? I did not.
Okay, so you didn't look at the messages that actually preceded Jade's message to Danny, where one of her friends said, "We please top shelf an 8," and Jade responds, "Okay, I'll let you know when he's gonna come."
I'm sorry, yes, I did see all of that. That's absolutely correct.
Okay, so this message that Jade sent, like, could I get an 8? She wasn't referring to herself because she was getting it for one of her friends.
My reading of it was that she was getting it for somebody else.
Okay. And then same thing with page 5. There are other messages that reference apple fritter. And Jade was seeing if anyone wanted this because she regularly would get different weed from Danny Weed for people that she worked with.
I mean, that particular set of messages was a frequent post within that Telegram group, so.
Okay. And going to your page 8.
Yes, ma'am.
Okay. And so your page 8, that is not Miss Benning, that is one of her friends asking for Adderall, correct?
Correct.
And did you actually read through that message thread with Miss Benning and her friend had a valid prescription for Adderall? Did you notice that?
I remember the discussion of that, yes.
Were you familiar with the Adderall shortage that the pharmacies were having during this time frame of November 2022?
I'm not familiar with that, so.
Okay, so if pharmacies were out of Adderall during that time, which actually, if you read through the text between Ms. Jackson and Ms. Benning, they actually talk about the fact that Walgreens can't get it and everybody is out of their Adderall prescription from their doctor.
Okay.
Okay. And then, so this one, I would like for you to look at page 9, skip page 10 entirely, and look at page 11 and 12.
Yes, ma'am.
Okay. Did you connect page 9, 11, and 12 in any way?
Did I connect them? I don't guess I understand your question, so.
Okay, well, page 9 is actually the last message in a sequence of messages, but you put it first. And then when you go to page 11, you left the other person off of this thread. which it's readily available in the extraction, but you left off Mario Gutierrez as the person asking Jade, can you holler at Danny, your boy needs a half?
I do recall that, yes, ma'am.
Okay, so that's Mario Gutierrez, but you left his name off of this.
When I pulled it, I don't think it was included in there, but that's correct. I believe it was Mario Gutierrez.
Okay, and then page 12 follows where Ms. Benning asks Danny very specifically, and this is on February 25th, my coworker wants to get half. And Danny responds, bet I got you when I get back.
Yes, ma'am.
Which, and I apologize, page 9 doesn't actually relate other than it's from that Mario thread. The time that Mario gets anything is on February 18th, but your report listed 2 dates. It listed the 25th, which kind of inferred that the messages you included in 11 and 12 were on the 25th. But no one meets Danny on the 25th. You would agree with me about that, wouldn't you?
I have no idea if anybody met Danny on the 25th, so.
Because there's absolutely nothing in Ms. Benning's phone that indicates that happened. It's the opposite. Danny said, I'm not here, I'll hit you when I get back.
I do recall that further messages where he said, I'll hit you when I get back.
Okay, and on page 13, this section is labeled a conversation about Blaise Taylor. And that conversation, that's not the only one, correct?
There's quite a few messages about Blaise Taylor.
Okay, and this is from December 31st of 2022. And then again, the next section that you have that begins on page 16, that is not the only communication that they have, correct?
No, they had quite a few communications.
Okay. And then we get to page 19, which is plans with Blaise Taylor. And again, on page 20, for some reason, even though it's in the extraction, you left off the person Ms. Benning was speaking with. And this is from the date of 2/25/23 at 12:03. She messages her best friend, Nigella Jackson, to tell her that she's gonna plan to do a little paint with Blaise tonight. So you didn't put in the thread that they were talking about where to get the paint and maybe Dollar Tree would have it? Do you think that may be connected to why she stopped at Walmart?
I remember all those communications. I know that there were some, even some pictures. I believe there was a picture of the crib as a part of it. And there was talk about what they were going to paint. So, I mean, there's a couple of those messages. Yes, ma'am.
Okay. And then on page 22, you have this Bumble information, which you have an install date. But you didn't include the message that showed that Ms. Benning registered for Bumble in August of 2022.
This was, when I ran this particular search term, this is what came up. But we talked about those messages before. I did see a message back in August of 22 that showed a previous registration for Bumble.
And did you notice that the app was only in focus for 119 seconds?
Not very long.
It was very quick, wasn't it?
Yes, ma'am.
And you don't have any user data to show what was happening when she accessed that app.
Correct.
And so, like, if I thought that Kendall had a Bumble profile and I just wanted to go click on it to look at it, to kind of give her some feedback as a girlfriend, it could have just been that.
Absolutely.
And then you included some random messages with Mr. Jerry Porter. Did you notice that they were very close friends?
They appeared to communicate quite a bit, so during that period.
As very close friends.
I don't know enough about them. I just know I was asked to pull these messages. So.
Okay. And then the last messages that you apologize for being in black and white, so they don't have a page number. Do you know what I'm referring to?
I do know the message you're referring to. So.
Okay. So this is January 25th of 2023, and it's just a message from Jade's mother asking her, does Blaise rub your belly? And Jade responds, sometimes.
Right.
Did you keep reading the messages on where her and her mom actually messaged back and forth and draft a message from Jade to send to Blaise to tell her how much she wanted him to go to her OB appointment where she was gonna find out the gender of their baby?
I recall something along those lines, yes, ma'am. So,
Okay, and you recall the messages where Blaise Taylor did not go to that appointment, correct?
I'm unaware if Mr. Taylor went to that appointment or not, so.
You didn't look at those messages where
I've-
he didn't show up?
I read through them. As to whether or not he did or didn't, I don't recall that, so.
Well, do you recall that he never went to a single OB appointment with Jade Benning?
Objection, speculation, this witness doesn't know that.
Okay, you can ask whether he reviewed any text about that, but
Did you review any text messages where every time she had an appointment and asked him about it, he didn't go?
Objection, counsel is testifying. And
do you recall any text messages about appointments?
No, Your
pregnancy
Honor.
appointments?
No, Your Honor.
recall.
And the last message where Ms. Benning tells her mother that Blaise told her the night before that he signed up for a monthly subscription for diapers from this company. Did you find any other mention that proved that Mr. Taylor actually signed up for a diaper subscription?
No, I did not.
Thank you.
Any other questions?
Mr. Devlin, you were just asked the nature of the relationship between Jarius Porter and Miss Benning, weren't you?
Correct.
Were you aware that Jarius
Objection,
Porter,
Your Honor, can we approach?
well, she opened the door when she asked the question.
I don't know what you're wanting to ask, but you can approach the bench.
One nation that
Any other questions?
were you aware, you stated on cross-examination that Ms. Benning actually downloaded Bumble first in August?
I found a registration message. It may have happened, Bumble may have been downloaded before that, but that would have been at least the earliest time that I know of.
Were you aware, or did you find out through looking through the phone that Blaise and Ms. Benning met on Hinge in the same month of August 22?
I did not see that, so.
In regards to Mario Gutierrez, did you notice through the phone that Mario Gutierrez is the significant other of Lauren Weber?
Yes, ma'am.
And Mario Gutierrez on the 25th is the same one asking Jade to get her narcotics.
Yes, ma'am.
And that's Lauren Weber, the person who went inside of her home when was told not to, the crime scene. That is her.
Okay, see, there's disputes about all, so don't throw that up like it's true. So what is your question?
Your did. In regards, she said she went inside of Miss Benning's
Right,
home.
we've heard that, but there's nothing about police, we've heard all that today, the jury's heard it, so what is your question that this gentleman would have a foundation about?
Did you have an opportunity to look through the text messages between Jade Benning and Jarius Porter?
Yes.
Did you find that they were a little bit more than just friends?
Having read through the messages, I don't know if they were just friends or if they were what they call friend with benefits. I don't know.
In regards to the appointment of I think it was a February 2nd appointment for Miss Benning to go to the doctor to find out the sex of the baby. Did you see any text messages well, let me first ask you this. Did you learn through the text messages that Mr. Taylor worked for the Tennessee Titans?
I don't recall seeing that, so.
Did you see through the text messages that on that very same day, he had to work or had an assignment at work with the Tennessee Titans?
If I did, I don't remember that, so.
In regards to the Bumble application, and I think that the question that was asked of you on cross-examination was that it could be an app where someone will go and say hello to a girlfriend. Is that what was stated?
I mean, I thought the question that was asked of me was, is it possible that somebody logged in to see if their girlfriend's profile was on there? I thought that was what was asked.
What is the primary purpose of the app Bumble?
They call it a social contact website, but for the most part, it is a hookup or dating application.
And this is the very app that Jade Benning registered for in August and then downloaded again, and I think you said February.
Correct.
Thank you, I pass.
Any other questions?
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
Sorry, let the lawyer step up. Please don't. Said about not discussing the case, forming any opinion about it, looking things up, watching anything on the media, ignore all of that. And tomorrow, be back in the morning, 8:45, 8:50, we'll get you up here and resume the trial. Thank you very much. You can step down. Mentioned that the bench conference about having a jury out hearing the state back to this document. Well, let me ask this. Is Dr. Larkin out there?
Your Honor, please use the lady I've been holding.
Okay. All right, we'll take 10 minutes and then we'll hear briefly from her.
Causing a 2-minute recess.
Your Honor, can I get 10 minutes to go use the restroom? So we about to do some more stuff outside of the jury. Oh my goodness, what a mess of a case today. Like, complete mess. We don't have any TiVo time. We right up in there. But boy, oh boy, oh boy. So they about to have a doctor come. Yep, the doctor's about to come in and say some stuff, I guess, on behalf of the defense now. Who knew? Who knew? Who knew? Who knew? Oh, well.
Sun comes up and somebody's already there, posting memes and opinions nobody asked to share. The trial's on the screen, but that's not why we stay. We're solving all the world's problems in the chat all day. Somebody's making hot dogs, somebody's cracking claws, somebody's citing statutes they learned from watching laws. The witness takes the stand, but we're off somewhere else, discussing snacks, bad tattoos, and making fools of ourselves. Hot dogs and white claws every hour of the day. The trial's just background noise while the chat drifts away. One eye on the testimony, one eye on the fun. Started watching for the case, but stayed for everyone. Hot dogs and white claws, that's the family we chose. Showing up with bad advice and inside jokes nobody knows. The lawyer keep on talking, but that's not why we're here. We're gathering around the internet with friends we've grown to cheer. Judge says overruled, somebody posts a gift. 20 people miss the ruling while they're shooting all the shit. The evidence is serious, the vibes are mostly not. Half the room is paying attention, half forgot the plot. Morning crew and night crew, somehow all the same. Different clocks and time zones, everybody knows your name. The stream could end tomorrow and we'd probably still hang out, arguing over nonsense till the lights all flickered out. Hot dogs and white claws every hour of the day. The trial's just background noise while the chat drifts away. One eye on the testimony, one eye on the fun. Started watching for the case, but stayed for everyone. The verdict comes and goes, another case rolls by, another 100 conversations underneath the sky. Hot dogs and white claws and friends we never saw, somehow built a little hometown through a screen and a law.
Go to jail, go to jail. Go to jail, go to jail. Go to jail, go to jail.
Ay, go to jail, go to jail, go to jail, go to jail. Don't collect that 200s, take your ass straight to jail. Gavel hit, case closed, now the truth and set sail. Take it to trial in the building, baby, straight to jail. Pulled up in court, yeah, the facts on deck. No filter, no fluff, we just call what's next. If the lies don't match and the stories derail, pack it on up, baby, straight to jail. Judge on the bench, whole chat going wild. Sweet Pete on the mic like, hold up, that's foul. You be the judge, but the evidence loud. When the verdict come back, we don't do no soft crowd. Go to jail, go to jail, go to jail. Don't collect the 200s, take your ass straight to jail. No pass, go, no spin, no magical fairy tale. Take it to trial, said what? Take your ass straight to jail.
All right, is there anything from the state's perspective, objection-wise, discovery-wise, about Dr. Lindsay? That's the...
We have absolutely no idea what Dr. Lindsay intends to say because we have some handwritten notes that says red top tube and some hard things.
She's being called for what purpose, Ms. Holland?
She is a toxicologist who sent over a summary as requested to the state regarding what her subject matter would be. She is going to testify to the levels of concentration of cocaine, cocaine, and fentanyl in the samples of blood and urine of Jade.
She's going to be able to testify to an amount of cocaine that was taken?
She's going to be able to opine on the amounts that are listed on the toxicology reports and the litigation papers.
Okay, in terms of whether that they are numbers that you actually rely on?
Correct.
Okay. So she's gonna be opining about what you asked Dr. to the 500,000, 98,000, those kind of numbers.
No, I didn't.
No, I'm not talking about you, I'm talking about the state.
Judge, I'm sorry, I have the same standing objection that she shouldn't be talking about any work order that is not entered into evidence.
We don't
Okay,
plan to.
That's fine, I don't think they're doing that. So, and then on Dr. Larkin, you now have this document, right?
Yes, so.
I'm asking the state.
Yes, sir. The report that we got today?
Right.
Yes.
So, is it the state's opinion that I can exclude Dr. Larkin from testifying because you just today got this document?
Yes, Your Honor.
Based on what?
On the prior motions that we filed last year, we have had, zero notice. She's typed a report, she's trying to opine as to the cause of death, and we have had no notice. Reciprocal discovery as well,
Well, that's
Your
what-
Honor was specific with them that if an expert was going to have a report, it had to be provided to the state pre-trial.
Okay.
That is not a report. I did not get it until today. The court asked us to
Okay.
reach out to
Where
our
is Dr.
experts.
Larkin?
She's right here.
Let her step up.
Stand right here, raise your right hand.
Raise your right hand.
I swear.
Do you need to do something?
So you change out batteries?
Okay, go ahead. We waited on everybody else. Did you generate this two-page document?
Yes, sir.
When?
This weekend, I guess.
And you gave it to who?
I was asked this morning to send
Gave
my
it to who?
notes.
Did you give it to anybody this weekend?
No, I did not.
Why did you compile this two-page document?
That is the way that I approach when I'm going to do something like this. In my
Why
mind, I
wait
need
till
to.
the last minute?
Yes, sir.
Why is that?
Because I'm going through what I put together over time, and when it gets closer to me going to testify, I want to make sure that I clearly and concisely put my points. I was an engineer before I was a doctor, and
Okay,
that's
so
why I approach
when
it.
did you send this to anybody?
This morning I was asked for notes, and so those are the notes that I have. So I sent those when I was at the airport this morning, about 10:30 maybe, and I sent that to Letitia and her team.
Okay. Any questions from the state?
Dr. Larkin, how long have you been working on this?
That was just very quickly putting that together.
No, she didn't ask that. You're talking about it, the case?
Right, how long have, you said that you just at the end put your analysis together that you've been working on. How long have you been working on your analysis?
I think I got asked to, I think when originally they were in Nashville a few months ago, I was told about the case, and then more recently, I've done work on reviewing all the records, and that's probably within the past month or two. I don't know for sure, but more recent. It hasn't been years or anything.
Okay, so maximum 2 months, maybe a month, you've been reviewing records related to this case?
Approximately. I don't know exactly when I started. I'd have to look at when I started getting some information, but
Do you have documentation about that with you?
I don't have it on me. I could find that out, but it's been several months. I would say on the outside, if you want a number, maybe, several months, something like that.
Well, you said 1 to 2, and now you're up to several. Which one is it?
Yeah, I'm gonna object to this line of
Okay.
questioning. This.
Is there something in your phone or something you have today that you could tell us? Look up and tell us.
I can tell you.
Okay, yes.
We reached out to her prior to the last trial. She was not officially retained at
That
that
was
time.
in January.
Yes, it was.
Okay.
However, she did not start actually digging into the trial until probably maybe 2 to 3 months ago, before she got everything that she needed.
Okay, what other questions do you have?
Did you take notes along the way?
No, I don't, I guess I put the notes into there. I don't have any other notes that I've taken, if that's what you're asking.
So no other notes, and you put that together this morning?
She said this weekend, last weekend.
Yes.
Last weekend, but you didn't send it to anyone?
I did not until today.
Were you instructed to not type up a
No,
report?
I object. I object to that line of questioning because what I tell my expert is confidential from Mr. Taylor and his constitutional rights. She
Do you
doesn't.
have any other questions other than that?
Not at this time, Your Honor.
All right, thank you.
Thank you, sir.
Okay, here's what Rule 16, the Rules of Discovery under the Tennessee Rules of Criminal Procedure say, dealing with information subject to disclosure by defendants. Inspect and copy or photograph books, papers, documents, photographs, tangible objects, or copies or portions of these, if within the defendant's possession tends to introduce them. That's part A of that B1A. In terms of our discussion about what a report is, that's under B where it says reports of examinations and tests. And the pertinent parts say that the defense has to disclose upon the defense asks for discovery, then the defendant has to comply with reciprocal discovery, which the rule says inspect, copy, or photograph any results or reports of physical or mental examinations. That's what all the appellate cases mainly deal with, is insanity, mental health examinations, and of scientific tests or experiments made in connection with a particular case or copies thereof, if the item is within the defendant's possession, custody, or control, or the defendant intends to call as a witness at the trial the person who prepared the report. So, does this document deal with scientific tests or experiments?
Judge, she's giving her opinion based on the review of the tests.
Right. But did she do any scientific tests or experiments?
Well, I don't know, not that I'm aware of, but she refers to laboratory testing confirmed.
Okay. But then on the second issue, if it should have been disclosed, it didn't exist till this weekend, which this is, what is this, Tuesday? So the state could have gotten it 48 hours earlier. So we get to the bottom line of, if there's a failure to comply with the request, the court may order that the party to permit the discovery inspection that's already untimely for that, grant a continuance, prohibit the party from introducing the undisclosed evidence, or enter such other order that deems just under the circumstance. So, if, I haven't finished yet. If there is, I'm not sure there's a violation of Rule 16, but if there's a 48-hour violation, what is the state seeking the court to do?
Judge, we're asking that it be excluded just as we did in our pretrial motions.
Okay, but even fall under Rule 16.
It's your decision.
Did you carry her?
How do I turn over something that I don't know exists? There's an email at 10:53. So it's not a report. She has done no scientific testing. She has done nothing of the sort. She made notes for herself to prepare to testify. The court tells us, reach out to our people, find out if they have notes. Today is Monday. I'm in the middle of trial, questioning witnesses, trying to get all the experts together to give the court what it asked for. That's difficult to do when I'm direct examining and putting on my case in chief. So at the break.
48 hours if she did it on Saturday, which I don't, she wouldn't ask specifically. Go ahead.
And so we're complying with what the court asked. She didn't call us and tell us that's what she was doing. And as I've stated, it's not even a scientific test. It's nothing that she conducted any type of test on her own. We don't intend to introduce it into evidence. So I don't understand what it is that we've done wrong.
Okay, anything further?
Judge, I have a secondary objection,
Okay.
depending on if you are going to allow it.
All right.
The state has a couple of other issues with this report that is notes or report, whatever it is. Her report relies on information that is inaccurate and it's not in evidence. And it's specific to that urine test that Ms. Hollins keeps attempting to ask all these witnesses about that is not in evidence. And the state is, again, asking that she not be allowed to testify to any of the lab reports that are not in evidence, but she based her opinion on a lab result that is incorrect. She also is opining as to the cause of death, and the state's position is that she's not qualified to do that.
Said she's an ER doctor. Where are you referencing a specific date about a urine screen?
So on her handwritten notes,
Oh, I don't have,
Oh,
who are
I'm
you
sorry.
referencing?
So
Dr. Lindsay?
Dr. Lindsay references that drug sample, and then Dr. Larkin, I believe, also references the urine sample. Right, it's on the bottom of page 2.
Fentanyl was detected in a urine specimen that was collected before fentanyl was administered in the emergency department. Is that what you referenced?
Yes. And then it says, therefore, the fentanyl identified in the specimen could not have originated from the hospital treatment, and instead it indicates fentanyl exposure before her arrival at the hospital. And then she goes on in the third page, in the second paragraph, to talk about the opioid epidemic that has spread.
Yeah, I mean, I'm not gonna let her testify about that. What about is that next to last and last sentence on page 2 accurate, Mrs. Hollins?
I believe that that is a question for the trier of fact. We were given discovery in this case, and when we were getting discovery in this case, up until 10 days ago, the date on those lab reports were 2/25/23. 10 days before trial, they
Didn't
changed
this-
the date, and now we're precluded from being able to utilize that date.
Well,
So we believe that's an issue for
the
the
other
trial of
screen
fact.
wasn't tested, right?
All of them were tested, all of them.
Which one? I thought Dr. Rucoleri said no one that's been here tested them.
No one what?
No one has testified to the test result.
The work order 090 that went to some other lab hasn't been testified about.
Yes, it has been.
From who?
Kotulski, I believe it was. Dr. Kotulski.
We're referring to NMS work order 230788883. That is the one that this report is referencing, had a 2/25/2259 date. That is inaccurate. We did not correct it 10 days ago. We sent information to the defense months ago about the error on this date. We had the report corrected only in the event that it was somehow admitted during the trial, so we would not be sending
Didn't Ms.
inaccurate
Smith,
information.
from your deposition you introduced, say there was no fentanyl administered?
Correct, as well as.
I'm asking Ms. Holland.
Exactly. So what that means is when their urine test was tested.
What
when
urine
it-
test?
The urine test that was tested before she was administered in
By
the
who?
blood test. In the blood test.
Tested by who?
Tested by NMS.
No, NMS did not
No,
test that.
They didn't.
It was CFSRE.
So that's where this
Since when,
courtroom's full of
Since when does a
confusion.
prosecutor call a lab and be able to change a medical record and we have to adhere to it?
No, I'm just asking you, is there proof
No, there's
that
no
you're
proof.
asking your expert to testify about?
Yes, for the last 3
Bring
years.
back in Dr. Larkin. We'll figure what work order she's given his opinion about. What General Norman is the work order that no one's been here lab-wise to testify about?
NMS 23078.
230.
78883.
You're gonna be able to testify without anything in front of you?
No, and no.
So my question is anything in this document, 3-page document, that has anything to do with work order 2307883?
I don't know, I think Dr. Yancey's in the back,
Who?
You're looking at the document that I submitted, not Dr. Larkin.
Why are you standing up?
Because.
Just have a seat.
Okay, I think, so.
Just have a seat.
I don't have any
You
reference
see
to any
those
work
last
orders
two
in there.
sentences in your report?
report though, right? Yes, I see that.
Where'd you get that information from?
From the toxicology records that I looked at.
From who? What lab?
I would have to look, I can't remember. These are just notes that I have.
How are you gonna testify? What are you gonna use to find that out?
We will put those up when
We
put
will.
up the notes. I can ask to have that
She's
put up.
talking about me.
What? So you have no clue where you got that information?
I got them from I have all the toxicology reports and I have summaries. I would have to look exactly where it came from.
Okay.
If this were a report, it would actually have reference to that.
Okay, well, tell me where that information came from.
I would have to have the reports
Do
to
that.
pull it up.
Where is it? Is it the same report you asked about earlier or this
Well, I
one?
can share this with you. What I plan to testify or have her testify about is I'm alleviating your issue.
You're not asking her about those last two
I'm not.
steps? Oh, you said earlier you were.
No, I didn't.
Yes, sir.
Then why'd you put this in this document?
As she stated,
Those are just-
I'm not asking you.
Those are just notes for me to
So
look
you
at.
didn't rely on
I've
this-
never ever
You didn't
actually
rely
produced
on this
something like
last
this.
paragraph for any of your opinion.
Not for what I'm going to be testifying to. No, those are just some of my thoughts I put
Okay,
down.
why don't we do this?
If
You
I had-
ask her what you want her to testify about.
I'm going to tell you, she's not prepared right now to testify for that because I don't have my things together yet. She's going
What do
to
you
testify.
need to have together?
I'm going to tell you what the two reports that she's going to testify to.
Okay, give us those.
I don't have any problem with this, sir. 231, 26889 is one of them. And then 231, 29285.
Remember, that's the first blood and the comforter.
Okay. You got issues with that?
I do not have issues with that. I do have issues with this witness whose non-report that I consider to be a report relies upon false information. And
I don't know. Let me try to find out again. Your opinion that says the history, witness observations, clinical presentation, toxicology findings, and objective medical evidence support the conclusion that Jade's collapse is more consistent with respiratory arrest resulting from combined cocaine use and pre-hospital fentanyl exposure than with a primary sole cocaine-induced cardiac event. Is that your bottom line?
Yes, sir.
Where do you get the information that there was pre-hospital fentanyl exposure?
Clinically, I can tell you in my 30 years of experience in treating patients with different types of overdoses, we have a clinical picture, we have the 911 call, we have the other witnesses that have spoken, we have the EMS.
You're talking about the sleepy, awake, talking, doesn't feel right, that kind of
Yes,
stuff.
and then, and the two reports that we'll be talking about on the comforter.
So
unfortunately, it wasn't tested for and everything.
What wasn't tested?
She's not privy to it because I haven't had the opportunity to meet with her, which I had planned to do tonight.
What
The
wasn't
state-
tested for?
Not everything about fentanyl was not necessarily tested for, and
On what?
in the urine that's no longer done at 225.
But that's what I'm asking. You said you included your toxicology findings in making that opinion.
Your Honor, what is unfair is she's telling you that those are notes. Those are not her lasting opinions. That is not a report. So you're trying to commit her to something that she never intended to be that. So that's unfair to ask her for that. She has stated as a medical professional doctor.
Why
Those are
did you
her
include that paragraph?
notes. Those are her notes.
Those are just some of my thoughts. It doesn't mean they were
So
what
this
I'm.
paragraph on the bottom of page 2 means nothing to your opinion.
I'd have to look at it again. I just made some notes and I probably put, I mean, that's not the basis of my opinion, but again, they're just notes. They're nothing official. There's no report. I don't write a report that looks like that. I just was asked to give some notes, and there were some things I just put together this weekend. And
So you don't know, Ms. Hollins, that you plan on asking her about any pre-hospital fentanyl use?
Yes, I do, because it was in the vomit. Their own witness testified that the vomit was the fentanyl was in the
From the
vomit.
lower level and all that.
It's hard, it's really hard. But what I'm saying is that the fentanyl was found in the vomit. That was testimony that came from that.
But you don't plan on asking this witness anything about that other work order?
No, I don't.
Okay. Any other questions?
Yes, Your Honor. The state, number one, that was not Dr. Mithen's testimony. Dr. Mithen was very specific.
Okay, do you have questions of this witness?
Yes, this witness's notes include a reference to the EMS guy said he thought it was an allergic reaction. We do not have those facts in this case.
Where are you referencing?
That is the last sentence in the first paragraph. Our EMS witnesses said the exact opposite.
Well, here's what I can't do. And again, if she testifies tomorrow in front of a jury on inaccurate information, then again, you have the Perry Mason moment and say, everything you've said, if it's based on the inaccuracy, would be inaccurate. But she may not be asked that, so I don't know. So we'll have to wait and see what she's asked. Go from there. Anything else?
Your Honor, may I ask that Dr. Carney be able to watch her testimony if she testifies tomorrow remotely so that she doesn't have to be down here because she's been here all
Oh, I
after.
get that, but it's important if she's willing to do that. We try like we did the direct link. I don't know what happened there.
I think you said you resolved it, right?
Sir, you will have latency like she did today. It all depends on their bandwidth.
Just get with that gentleman and provide that link to Dr. Carney. Is she gonna be out of town or something?
I don't know, just know that
She's
she has a
welcome to
job
be
to do
here.
because she does autopsies.
Well, she's employed by Davidson County. If you think she needs to be here, then have her here. All right, thank you.
Thank you.
All right, we'll be then in recess until 9 a.m.
Talk about everybody was kung fu fighting. I'm telling you, that's all I can think of when I go in this courtroom every day. Everybody is fighting. Like we are fighting. If nothing else, we fighting, baby. Yeah, I think he let him go home, and I'm telling you, you talk about everybody was kung fu fighting. All they do is fight. Oh my goodness. They still haven't sent me a thing saying that my internet is back together, but you know, whatever. I mean, this is like terrible. But you know, the funny thing is that like I was trying to tell y'all earlier, is that when you go to one stream to another stream to a different chat, like what we may think over here, like in regards to there's no reasonable doubt and they guilty, you go in somebody else's chat and it is so much reasonable doubt. And they actually picking out different things that are reasonable. I'm not sure if the jury's gonna look at it that way, but yeah, it just shows you how different people think about certain stuff. But today was just like a total disaster. I don't think any of the witnesses that the defense called were really for them. You know, I don't think any of them did him any favors at all. Gosh, I wonder what he is thinking about in regards to his last meal, his last things that he's eating. I want to know any of those things in regards to that portion of it. Like, I want to know what he's thinking, what he's, you know, is he staying up all night, hanging out? Like, what is he doing? Is he going and sowing his royal oats at this point in time, considering that he may go to jail for the rest of his life and he's not going to be able to have no kids? Says the man who didn't want no kids is now, do he want kids now? Like, what are you thinking, Blaise? I really, really, really want to know. You know, it's a little different when people are out on bail versus to our people that are in jail when we go to trial, even though the jury may not know. But like, he's out on bail. So what are you doing, Blaise, Blazer, blah? What are you doing? I really want to know. Like, I want to ask, like Josie, you know, Josie Dickerman, because remember, she was out on bail until they found her guilty. And I like want to ask her, like, Josie, like, what was your last meal? What were you thinking? Like, I want to know, did you party all night? What was going on? He gonna try to have a baby this week, Lon? Yeah, like I want him, I need him to be out there shooting some girl club up and making him a baby, proving to the world that yes, I did want babies. Oh gosh. I know. Your sweet pea can definitely be super duper terrible. But yeah, I'm like wondering, like today wasn't nothing but, I don't know what testimony we got, because between the people having to talk with the judge before testimony actually start, I don't know what testimony we got in today, but whatever. So we'll be back up here in court tomorrow for our day 7. Let me see if anybody is out here and talking about this. I don't know if Leslie was going in the courtroom today or not. Let me see if she has I'm not sure. It doesn't look like she has a live scheduled or anything. Like, oh yeah, she does. She has one scheduled for 5:15. So if you guys want to go over and watch, I'm not sure if she's going to be in a courtroom or not. I don't know if she was in a courtroom or not today. So that is something. You know, you always have your crime club, right? your crime club for things. Let's see what else we got in here.
My channel. Welcome back to Real Talk Bougie. I have a quick
what is
update for you
that?
guys. So
I have
those
no
of
clue
you
what that
who
is.
have been following the RICO case,
I don't know what that is. Okay. I got things talking in the background. Yeah, well, no, I want to actually do it for real this time. I know if my internet wasn't giving me so many problems, I don't want to stream it. I don't want to try doing anything else, but I do know that I do need to do the hearing for, I would like to look at the hearing for Alex Murdaugh. I did see that they did do a court date for him. So hopefully at some point in time, we'll be able to get in. Hopefully my internet will be better tomorrow. I have no clue what that's about, but we shall see. So I can cam up. Like, I can't even be on camera. I'm too scared to be on camera because I think that it pulls too much internet or hearing. Yeah, so I see Film dropped a link for Crime Club. So if you guys want to go over to Crime Club, definitely go over there. Remember, it's just like Fight Club. I want to thank you all for hanging in here with me with our Monday morning blues with streaming. We would struggle streaming. It seems like they were struggling up there in the court in regards to what was going on. There was a lot of struggling going on. I definitely appreciate you guys for hanging in here. Shout out to the mods. Shout out to the chat. Shout out to everybody that gifted memberships. Any of that stuff that happened, I truly, truly, truly appreciate it. And yeah, guys, I will see you tomorrow morning. I am going to go ahead and put our outro song on, and I'll probably go over to Leslie's to kind of see what I don't know if she was in the courtroom, and I guess I want to find out that and kind of go from there. All right, guys.
When Sweet Pea taps in, you know the courtroom lights go bright. Trials running long, but the family's here every night. Mars on patrol, chatter showing out. This little YouTube corner's what community's about. Therapist you know, steady holding down the floor. Behind the scenes magician, keeping peace like never before. A banner king, a rule keeper too. Every channel dreams of a mind like you. Jason walks in and the ladies lose control. Down to earth king with the warmest soul. Film freaks, kindness, man, it's always on display. Fair and sweet and cheering folks along the way. And Marilia from SA keeps the laughter rolling free. Joking, shining, keeping spirits where they need to be. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This Courtroom crew is everything we admire. Yeah, no matter what the case so far, we'll forever take it to trial. Take it to trial. Pretty brown girl, she'll tell you what's true. Sharp as a gavel, funniest in the room. Dr. Rachel pops in while she's busy running lines. Speaks her mind every time, cuts through like a knife. And Paula brings the energy, jokes flying fast. Helping Sweet Pea backstage, making every stream last. And Zach's trolling, causing chaos just for fun. The resident cheater, but we love him, everyone. Here comes Maddie, handsome, quick with the line. A comedy sniper with the perfect timing. And Lynn with the updates, always loyal, always tuned. If true crime news drops, he brings it to the room. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This Courtroom crew is everything we admire. Yeah, no matter what the case so far, we'll forever take it to trial. Take it to trial. Shamrock keeps us trending, replay queen. Holding down the algorithm like a machine. Estes razor sharp, loyal through and through. And yeah, she adores Jason, nothing new. Drunky the bear with the white cloth way, managing volume. courtroom fog, and Brooklyn in the house, always bringing that spark. Lighting up the chat like a shout in the dark. Barker loves her grand, speaks truth when it's time. Micrograms with metaphors, straight up sublime. Barbara, biggest supporter, heart kind and vast. Looking for missing kids, hope to truly last. Only fan from Singapore, flag name but sweet. Still shows up with love every time he takes a seat. And even the part-timers keep this place alive. Curvy Hill, Irish Amy, Capri Law, Hellcat, our tribe. Hearts wide open, stories shared, holding space because we care. From every corner of the world we climb to spend these nights together, one trial at a time. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. Mods and chatters, yeah, this love is something rare. A courtroom crew with hearts beyond compare. No matter what the case or file, we're forever taken to trial. To Sweet Pea and the mods in the chat we adore. This isn't just a channel, it's a family. And we couldn't ask for more.
All right, crew. See you in AM.